will it involve DCP?
As the DC
Don't send yourself. Don't send other people for that. It's pharmacy stuff.
Rod will be back.
Yeah, Rod will be back. If you could introduce your staff today, who oversee the regulation of cannabis in the state in particular, that would be great. And we'll look forward to hearing your testimony.
Well, and thank you for the kind words. And, I've really enjoyed working with this committee. It's and appreciate how much time and thought you put into understanding the work we do at Consumer Protection and what we're trying to do for consumers. So thank you for having me once again to offer testimony here to testify specifically in support of HB 6697. This was drafted by DCP, and it really makes mostly clarifying and some technical changes to RERACA, the cannabis bill passed a couple of years ago. It also addresses a few new issues such as high THC products that are derived from hemp. With me here are Julianne Avalone, our legal director, and Rod Marriott, our drug control director, probably also not strangers. They're very talented members of our team. You should have my written testimony, which kind of goes through some of the more specific changes in the bill. So I'm happy to kind of summarize some of that or answer any questions.
Thank you. Why don't you touch on what's in your bill, but we have some questions on maybe some of the other bills that are before the committee as well.
So it does a number of things. I think the more substantive thing is one, it adds dispensary facilities and producers into the lottery process that exists for all the other cannabis license types. Those are the legacy medical business categories. So they would now be rolled into that. It creates cannabis specific testing laboratories. We just found that would be an easier way to regulate that piece of the program. It clarifies some of the advertising regulations. So there's a lot of businesses that are adjacent to the cannabis market, such as law firms, accounting firms, others that support the industry. So it would allow them to do advertising of their services, eliminates the background check for caregivers. And then, as mentioned before, creates a definition for high THC products that are derived from hemp. Those are probably the more substantive changes that are proposed.
And that last one you mentioned, the high THC products with respect to hemp, that I know that's been something that's been in the news lately. The AG's done some enforcement actions. My understanding is that language really dovetails with the enforcement that we're doing on the AG side and really is designed to really put a bar in the Connecticut marketplace for these products that are coming in, or give enforcement tools to DCP to prevent the influx of these unregulated products that come into the state that really are an effort to run around our regulatory scheme.
Right. So it's, tricky because hemp is legal, and you could even though hemp itself has low THC, if you abstract the THC from it and then infuse it into another product, you can end up maybe with higher amounts of THC than people may have initially thought would be derived from hemp. And so we wanted to put some guardrails, recommend language that would put some guardrails around that.
Thank you. There's a number of other proposals that we have before us today. I wonder if you or Robert, Julie could talk about the labeling of products in Connecticut, because we've had the committee is struggling sort of on both ends of this, right? We've got dispensaries who are saying, look, in order for us to be able to compete with Massachusetts and other states, consumers have to be able to come in and ask for a product they know. There are trade names. There are sort of in the community, these products are known by certain names. And the dispensaries, at least from we've heard from, seem to think they can't use those trade names on the product labeling. On the other end of the spectrum, we've always have concerns, bipartisan concerns, about making sure that there's proper warning labels, proper notifications to people, understanding what it is they're buying, how they're buying it, safe, how to safely ingest it, that sort of thing. Can you talk about the existing scheme and what it does and doesn't allow?
Yeah, so there's a couple of things. One is the brand names. And in the medical program, we did have very strict rules regarding naming, and it didn't allow for the more recreational names that were maybe seen in other places. We have moved away from that standard for the adult use market. So we are getting a lot more variety in brand names that are coming in. And in large part, we are approving those. We're really only focusing on ones that would be suggestive of a product for people under 21. But the more common names that don't fall into that are allowed and are being approved. So those those names will be seen on the shelves. If not yet, then I would expect soon.
So there's really no need for this committee to change the existing regulatory scheme in your view with respect to the brand naming. As you said, you guys are already directed by statute and then with the following regs to prevent any naming that appeals to children or is otherwise inappropriate according to what we laid out in the statutes. But dispensaries can go to you and say, hey, here's a brand name that's already in use in the marketplace. It doesn't tick off any of those concerns. Will you approve it? And they can get that approval.
Yes.
Okay.
So that's, yeah, that's now allowed. So a broader spectrum of brand naming is allowed in the adult use market. And then with regard to packaging, really the stricter requirements are particularly around the edibles. And, we were also trying to strike a balance. So we have, obviously companies do want to be able to market and make their products really attractive and maybe fun or exciting for people. But at the same end, we are hearing, and I'm sure all of you are as well, about kids who inadvertently get into these because they see a really sugary looking food and it's in a fun, colorful wrapper that looks very similar to, the fruit gummies or whatever else they normally eat or cookies. And so we do have pretty strict rules around the edibles. You can still put your company logo on it, but we want those to be black and white. We want it to be abundantly clear that this is a THC product. Also for adults, we don't want somebody to not notice, inadvertently take it and have a lot more than they anticipated. We did look throughout the country. New Jersey, for example, has similar rules around. So what we are allowing are up to 3 colors in others products outside the edible range. So we looked around the country sort of see what others are doing. Some are certainly more lax than ours, but we don't think we're way out of line, and we do think this was the responsible balance.
And when we did this last year, I know one of the things we were concerned about, and I believe this is the case, but please confirm, you can't go and buy a whole candy bar and ingest the whole candy bar of cannabis. You can't buy a jar of gummies and pour out 15 gummies and just take them all at once. There's an individual packaging requirement per serving in Connecticut.
Well, so there's limits on serving size. So sometimes it could be a larger product, but it has to clearly delineate what the serving size is within that. So it may be
You have to break it off.
But it's something candy bar.
Right.
Your gum is the actual
Yeah, right.
candy bar.
So on the candy bar, just clarify, go ahead. And
Yeah,
there's a mic over
there's
there, see if you want to.
a max per total. So it can't be the largest ever, but it can be a candy bar, for example, that's more than 1 serving size, but it has to, one, it's going to be wrapped in a way where it's not like abundantly clear this is a THC product, and the serving size will be delineated within that. But I'll let Rod speak a bit more on to the nuance of that.
Thank you. And thank you for the opportunity to be here today. Yeah, so the idea is that if there was a jar that said had 10 gummies, the max would be 10 milligrams per gummy, the total of 100 milligrams per container. So the cap is on the amount per container and the amount per serving.
Per serving
And per container.
All right. So if we wanted to expand that regulation, say for a candy bar, we want it to be more difficult to break it apart, or you have to be able to break it apart into a particular serving, somehow
So they
divided.
do
up
have
like
to have
that.
demarcation
Yeah.
right? So they're clearly demarcated and there's stamps on them. So it would, if you want to take like a Hershey bar, for instance, that Hershey bar has all those different, rectangles inside of it. There can be no more than 100 milligrams total in the total kind of connected package. And then each serving size is clearly demarcated.
That whole packet, that's our limit per bar, if
Yes.
you will, and it's that 100 milligrams, that's what we set in statute. Okay, all right. And then I've got you, if you could talk about, or Commissioner, but I think this is right up your alley, Rod, the issue of the vaping. We've gone back and forth on limits with respect to the vape cartridges. And I think it's worth the committee hearing about the issues with respect to putting a limit on those vape cartridges because of the additives. And this goes back to some health issues that occurred nationally.
Yeah, happy to add to that conversation. So the vape cartridges, the concern is that the vape cartridges generally come in standard sizes. And as we start to kind of put too many restrictions on those. We push people to kind of the illicit market, or encourage our manufacturers to put additives into the product. And some of those additives are harder for us to track, and can kind of play a role in some of that lung issue that we were hearing about a few years ago with illicit cannabis and that EVALI kind of crisis. So the idea is the cleaner the product is in the vape, the better it is for the people that are using it. And so less is more in those.
The health issue nationally was actually that people were going to the hospital, not because of over ingesting cannabis, but because the additives that were put into the vapes were actually damaging people's lungs.
Correct. They weren't able to clear the product from the lung.
And my understanding that is that the regulators across the country are all sort of banding together to try to come up with a common approach to the vaping issue. And at least one initial step that I think New Jersey took, which we might consider here, is more aggressive labeling on the vapes.
Yeah, those are some of the things that other folks have been doing. You know, we are fortunate to be able to meet with our other kind of sister agencies or other regulators in other states and kind of put our heads together there. And we do get to speak with some other public health people that have been looking at this for a very long time as well, and kind of taking a cue from the tobacco stuff that has been going on for a long time, and taking best practices from that.
All right, sorry, just so those were just some threshold questions I had. Dave?
Thank you, Mr. Chairman. Good morning, Commissioner. It's been a pleasure to work with you over these past few years. Good luck in your future endeavors. I thought the cap on edibles per serving was 5 milligrams, not 10 milligrams. Is it 5 or 10?
It's
It
fine.
is 5.
It's
I
5.
was using it.
But
as
so
an
that
example.
bar could still be 100 is what you're saying, or is it 50? I don't,
100, yeah.
so it's
It's
100. So
100.
it could actually be bigger than
It could
the
be 20
servings. It could be
servings.
more servings than 10. It could be 20.
Yeah, it was an example for the math purpose
Okay.
that I was giving.
And if you could say that the edible serving, whatever, the gummy, because we learned this one committee meeting ago or something, you know, I think it's 5 milligrams individually wrapped, one gummy, right? Because we were concerned about some of the Massachusetts rules where, you know, a portion was an ear and another portion was the other ear, and it didn't make any sense, but Connecticut seemed to maybe have worked that out, and it's a single serving. Why can't the vape be the same thing? I would fundamentally disagree with the assertion that it's the additives in the vape that are sending the kids to the hospital when they're all, you know, having a massive response to the high levels of THC. I mean, if we could do it for a gummy wrapped, why can't we do it for a vape cartridge?
So I think there's another rate limiter in the vape products in that how much can actually be inhaled per kind of puff, if you will. And that does provide some control. There's not necessarily a control mechanism on how many puffs you take sequentially that I'm aware of. But
Wouldn't it help that the vape cartridge itself only had a total of the same amount as a individual edible? Wouldn't that make it inherently safer and portionable, I guess is the word?
so, you know, I think, so you're saying like a 5 milligram vape cartridge?
They know the quantity of the THC in that vape cartridge, yes, just like they would in a gummy, just like they would in an edible. It's the state says that the edible is individually wrapped at 5 milligrams. Why can't we say that one vape cartridge is 5 milligrams and the consumer of it could take 1 puff, 2 puffs, 10 puffs, but he would max out at the 5 instead of some of these concentrates that we're finding are in the 90 percentile and causing what we believe is causing a lot of problems. I'm not, it's not your fault. I understand that I sound like it's your fault, but I understand it's not your fault. But it is, what's that? Well, we are the regulators. I mean, we're the state, we're duly elected. You're the Department of Consumer Protection. I didn't know if there was some function of how these things are made that we just can't stop at 5.
Council, I know you've looked into this. I had
Hi.
the same question, Dave, and the answer I got is really, it's
Okay, listen, that's why we're here.
Hi, it's a pleasure to be here this morning. So the thing is, to start, is that there's not the technology in these vape cartridges to be able to determine one specific dose of 5 milligrams. What's going to happen is based on your breath capacity. So that's why it's extremely difficult to do that by saying that it has to be a 5 milligram dose every time you inhale through a vape cartridge. You're basically telling all the companies that they can't make them.
I'm saying, why can't it be 5 milligrams contained in the cartridge? Just
Because
like in the gummy.
it's not financially viable for these companies, because to do that, you'd have to spend a ton of money on actually manufacturing the cartridge, and to have one single use of it is just, it's not something that's viable. And in terms of the 90% and why we actually in this case want 90%, is that those deaths from EVALI, there are about 70 of them throughout the country. The leading suspicion, I don't know if it's actually been confirmed officially, is that it's vitamin E acetate that was in those cartridges, because they were trying to make it so that it was a easier solvent to be able to inhale. There's a lot of different aspects of THC that have been coming to light, whether it's THCO, whether it's some of these THCO acetate type things, where they have toxic components. So we want to keep those out. We want to have the most pure product that we can when it comes to these vapes.
So just, I know, but I think I get where you see where he's coming from. So they can make, we could say the vapes have to be 5 milligrams. Right. And I think we'll hear from producers later today, but the producers would say, we're not going to make that. And so then you've driven people right back to the illicit marketplace where they can get an unlimited vape.
But so to be clear, the reason I ask these questions is not really the deaths that you're referring to. It's the calls to the poison control from the people that have, my concern, listen, let's be realistic. Some of the folks that maybe were against legalization, we lost that argument a little bit. Really, I'm Delta 8, Delta 9, some of this other stuff that's going on out there. So I was going to move my questioning, if you don't mind, Mr. Chairman, and with your indulgence, to like the Attorney General came out last week and at a press conference on Tuesday, strongly saying that the THC, anything over is it 0.3 or 3.3? 0.3 is illegal. I told him that some of the drug prevention people and there's some confusion out there because they think that Delta 8, Delta 9 is a workaround because of some farm bill out of Washington for hemp farmers or something like this. And he told me unequivocally, that's not true. He goes, so my question to you guys is who's responsible for regulating that market? Is it, who enforces the fact that they're not supposed to be selling this stuff? Is it the Attorney General who did an enforcement action, or is it the Department of Consumer Protection who gives these stores these licenses, to sell tobacco or a grocery permit or whatever? I would believe comes from your department, Commissioner. Am I right?
It depends on the store. We don't it just in all the areas we regulate the businesses that are licensed with us. So we don't, once it's not a regulated product, it becomes more of, the Attorney General can take action in court or law enforcement could take action, but we don't have a really good way to go after. We don't have a police force or the type of resources that would be needed to go after every single one of these stores that are selling these products. But I think, in the bill where we talk about defining high THC hemp products, it is meant to create more clarity around this, because there is some confusion as well around what products derive from hemp, what are the options to address those. One thing we are trying to do is just create a regulated market and it's still up and running, and a lot more, businesses are going to come on board, where everybody does know this product's been tested. This is packaged in a way where my kid's not going to be confused if I accidentally forget to, lock it up or leave it out. And so creating that safe marketplace is one option, but an illicit market is really outside what DCP can regulate.
Well, through you, Mr. Chairman, my question really is about Delta 8 and 9, because according to the Attorney General, that's illegal. And it's being sold in gas stations. It's been sold in vape shop. It's not the legal marketplace, which is you guys license. It's protected. You probably inspect it. So quite frankly, I don't care what they sell in a licensed marijuana dispensary. It's the local convenience store that has this wall of stuff that it's illegal. I mean, it should be illegal. Is there a way to test it? Is there a way to enforce it? I believe that the problem lies in that aspect of we'll call that market whatever you want. I'm not really talking about, I don't even think our bill is really talking about the legal sanctioned licensed dispensary. I told this story the other day, I'll tell it again. We did a survey of every convenience store, gas station in our town. We had 11, right? 8 at 11 had Delta 8, Delta 9 on the shelves. One of them was a vape shop that had the Oreos and the Cheez-Its all. Do you guys have a quick way of walking in there and testing this product to see what the THC level is, to see if it's illegal? Because the Attorney General said that this is specifically illegal.
So we don't have either the resources or a really easy testing mechanism for it. So I mean, I think the Attorney General, I don't want to speak for them. They can certainly talk about the enforcement tools they have or the enforcement tools law enforcement has. It's going, and this is true in all the areas, whether it's, people who are selling liquor without a license, doing other things. Once they're outside our legal marketplaces, they move into the enforcement is outside of DCP.
Well, I know, yeah,
Do
you
you
can,
want-
I know it's not your problem, but we do have compliance checks for alcohol and all that other stuff. The department does seem to have figured that out. I just didn't, if we're
Yeah,
gonna start doing it for other products.
And I'd love to just add to what the commissioner said, that product line that came from really the Farm Bill and the hemp stuff, it was all new, and it created a fair amount of confusion for pretty much everyone. We have been working a little bit more locally with local law enforcement on some of these issues. And when we get complaints, we do look into those and help law enforcement identify products. There's a difference between what's on the label and what's inside the product, and getting those tested is a challenge. Sometimes the state police forensics lab doesn't have the certifications to test quantitative, so they can't test how much THC is in there. And that is a struggle for law enforcement side, but we have been helping recently with law enforcement to look at these products, help them understand where these lines are, and we've seen some actions from that recently. I think up in Enfield actually, and other areas, and so we're going to continue to do that, and we were starting to work on a little bit of a toolkit for law enforcement and do some more training with them. But to do it on each store and each individual store, like how many in your town? 11?
8 out of the 11 had it on the shelf.
Yeah, and that's the ones that you were able to identify that were even selling anything. And it's a big lift for all of us from that component. And so we're trying to do it in a way that's manages our resources that we have and the local resources. But it's not an easy problem to solve.
I'm probably taking up too much.
No, I
appreciate
want
your
to,
indulgence,
we
Mr.
need to
Chair.
have this conversation.
So I had my thought and then somebody had another thought, but we actually we said a kid did a school project for college. We just asked them. They said, oh yeah, sure. It's right here. So there was no fear on their part that they were selling an illegal product. It's an illegal product. But we can't figure out. I mean, I'm thankful for the Attorney General on this one. I think his office I think this is a big problem. I think Department of Consumer Protection is going to have to, we collectively are going to have to figure out a way to address this. We do compliance checks with liquor. You guys over the years have worked this out where you go in and, you try to do an underage buy, or you try to, make sure people are carding. You do the things that are working. Well, I don't think we have this for other areas, and it's a problem.
And I do think you make a good point there. So some of the challenges with some of those other compliance checks, tobacco and others, or a lot of those have federal funds associated with them also. And so we can't commingle those funds on anything cannabis related, as far as I know, but those aren't my area of expertise, to be clear. But we are working on some of this with our law enforcement folks, and it's probably a program we're going to start to do as with our kind of cannabis licensees. And if an individual is licensed with us and has like electronic nicotine delivery system credentials, we do work with that credential kind of on an enforcement angle from the department side. But this is new. And yeah, it's a problem. We're working on it. But it is big, like you identified already.
So I mean, I guess this will be my last one because I've taken up too much time from the committee and you guys. But it begs the question, why did we regulate marijuana in the first place? The whole point was all these people went out and got licenses. So supposedly they're all doing it exactly the way they're supposed to, the way we outlined it. And yet we have allowed this entire market to flourish and really to poison our kids. If I was the one who bid on a dispensary license or and got it, I'd be so annoyed that the gas station down the street was selling an intoxicant based on a product that I'm selling legally. So it's funny because I mean, some of the marijuana folks are here today to be against some of our proposals. But if they thought about it, we're really protecting their regulated market, the one they were asking for, by trying to crack down on this unregulated market, really an illegal market. It's funny is because we keep saying the words illicit marketplace. The illicit marketplace is happening in a convenience store on your corner. I don't think there was a question there, Mr. Chairman.
But I think
apologize.
I just want to make sure I understand the conversation. Your proposed bill came from the governor's office, right? Is to make clear those limits on the high THC products, Delta 8, Delta 9, right?
Where they're derived from hemp. And I'll let, I
Yeah.
think Julianne had something
Yeah.
she wanted to add to some of this. Although I do want to just clarify one thing. We do a lot of compliance checks, you're right, in liquor, but those are typically within, again, our licensed businesses, checking are they selling to intoxicants or to underage people. It does, the challenge once we move outside our licensed businesses or where we don't have that hook, still exists, but I'll hand it over to Julianne.
Well, I'm sorry.
Clarify that it's Leslie's. No, I don't want to make sure she's either annoyed at me or something else.
I think-
Is she you?
Yes.
Because I'm getting the face
Yeah.
and I know the face.
It's probably me. Don't
Yeah.
worry.
Oh, okay, good.
To build out off of the commissioner's example to start is that
Yeah.
we do regulate liquor businesses. However, when there's an illegal, liquor shop that's operating on a corner, we do not regulate that. We do not do enforcement
I
there.
gotcha.
That then turns to police. That's why Rod gets police involved when they're going to places where they think might be selling illegal product. The bigger picture issue here is that based on the farm bill that Rod mentioned before, it created a lot of ambiguity about these derivatives that can come from hemp and what the conversion rate is between the 0.3% and by volume when you're making that candy bar. So for example, right now, if you convert 0.3% over to a Snickers bar, you have 150 milligrams of THC in there. So that is clearly above not only the per serving size limit, but also the per package limit. Now, the problem with this is that if there's a chain of custody, it comes from a state where they have hemp regulated, then that goes through the proper channels and they do the manufacturing within state law, then it can potentially be a legal product. That is something that, again, there's some lack of clarity on and not something that we think is necessarily, it's debatable whether or not it's an actionable event. So the products that are there on the shelves right now, without doing extensive investigation and without certain clarity in our law, they can market 600 milligrams of Delta 8 to children because it is not a product. Hemp is not a product that has an age
So,
restriction.
I mean, just to cut through all this, I mean, isn't what I'm hearing is so long as we're allowing these products in some form, the testing and compliance is virtually impossible given the standard, the staffing that you have, and we've got this problem. So it seems to me that the easy answer is just the only place you can buy any product with any THC in it is a regulated dispensary in Connecticut. Period, full stop.
The issue there is that.
And then,
hemp-
then it's,
sorry.
then it's an enforcement issue. That's got nothing to do with you.
Right.
Then it's the AG and police.
That's right.
And that's it. Period, full stop. Right? Then you don't have to do any testing. We've said, this is the only place you can buy it. You guys regulate those stores. Municipal police, AG's office, state police, go out to these stores and they're off the shelves. Isn't that a black and white solution?
Look at
There
that, a
may
bipartisan
be-
solution.
There may be
Yeah.
concern about essentially banning a federally legal product, but that is a different
We
issue.
legalized the federally illegal products card.
All right, anyway, Paul, you want to follow up on this? Yeah.
We are happy to work with the committee on finding.
But do I,
solutions.
at least, just for good discussion purpose, do I have that right? The issue here is you've got a product that we're struggling with the level, above a certain level illegal, below a certain level legal. And so long as there's this line, the issue becomes, how do you test it? How do you know the resources to go in and do that? And it almost becomes an impossible regulatory issue.
So I will say that the way that we structured this was to make it much easier to do enforcement. So it was to recognize that small amounts of THC may be present in these products, but also to make it so that it's not this extensive looking through records as to chain of custody, testing the product. It is if you're in possession of a product that has more than 1 milligram per serving, more than 5 milligrams per package, then that is a violation of law. So it's just really streamlines that whole enforcement
That's helpful.
aspect.
It's
Good.
helpful. The Attorney General said that every product they've come in contact is well above the legal limit, and they use packaging that's not legal either. They all have a marijuana leaf. They break every rule. I just don't know, and I'm not mad at you. I just don't know who's responsible for this. And some of us who may have wanted to delay legalization or the commercialization, let's not say legalization, commercialization, we're saying maybe we were feeling like that these should have been addressed before this marketplace was open. So that's all.
Yeah.
That's really the purpose of this whole
Yeah, I
thing,
guess.
is trying to crack down on this aspect of it.
Senator Chicarelli.
Thank you. Just a couple of questions, just clarification. It's the hemp, the legalization of the hemp that allows them to sell this in these convenience stores, correct?
Yeah.
And the problem isn't the hemp or the very small amount of THC. It's the chemicals that are getting put in these products, correct?
It's the extraction of certain cannabinoids. So it's the extraction of Delta 8, Delta 9, a variety of then products that are infused into generally edibles. But sometimes, I mean, sometimes you just see flour in the store as well that you can smoke. But typically when it comes to hemp, the hemp is so low THC that it's not a product that is typically smoked. But yes, once you distill the product, it's the intoxicating substances that we're concerned about.
And right now, a small amount of that is legal. The Delta and the different
Right.
variants of Delta.
Right now, based on, it depends on how the hemp is processed. So, and if you put it through certain processes, you can actually create by volume, very high concentration of THC. And so that is the 150 milligrams of THC in a candy bar scenario, is that as long as it's derived from hemp, that is still the conversion of dry weight to by volume. So what gets you there.
So it's fair to say that you guys think this is an issue as well, correct? Yeah. And the Attorney
consumption,
General
yes.
believes that this is an issue. And when the police try to maybe enforce if there's an incident at a school and where'd you get it, they go there. But then they're worried about any type of a backlash of taking somebody's technically legal product because there's no clear definition what is or isn't legal. Do you have language that you think we can put in something so we could start to enforce this so somebody could take action to get this off the shelves?
Yeah, I mean, we did take a pass at it with the high THC hemp language that's in the bill currently, but we're certainly, if people don't feel that goes far enough or there's more needed, happy to work with the committee on using that as a building block to what more is needed. But that is why that high THC hemp product language is in this bill.
Yeah, I think maybe we really make it clear. And then we get in the same room, maybe with the law enforcement or the Attorney General's office, and we make it clear that police can take action. And there's an easy way to do it, not a very scientific way or a way to have to measure it because maybe those tools aren't there. But I think it's something that we should do. And if we have a vehicle here and now, I think we take advantage of that so we could stop some of this stuff from happening. We hear about it happening at the schools all the time. So I'd encourage an additional conversation at some point really soon. Thank you for your time.
Is there a a different regulatory piece we can put in here, as you guys to think about answer it now, but where these products, before they go on the shelves, need to be cleared through some, I appreciate there's cost involved in what I'm saying, but need to be before, a requirement for any store in Connecticut, before you can put any product on the shelf with THC in it, you have to demonstrate to DCP that it's below a threshold. We put the actual verification mechanism on the stores that want to sell it. If you want to sell it, before you can go on the shelf, you have to get a sign off from DCP. You have to put something, give something to DCP that shows it's below the 0.3 or whatever the limit is. And you have to get a certificate that you display on those lines. And that way it's easy for law enforcement to go in and say, do you have your license from DCP to sell this? Yes or no? And if you don't, you can't sell it. It's something, some other mechanism that works within the regime we have versus the black and white bar that I was talking about.
I mean, it's certainly something we could continue talking with you about. We would have to think resource wise what that would look like, but you know, the more the bright line rule, the easier, but it there, you know, we'd have to think through the logistical challenges and the resource demands to do something.
Well, I think
that
you're hearing there's bipartisan support for getting you funding to do enforcement on your end if need be. Representative Pizzuto, I'm sorry.
Thank you, Mr. Chairman. Commissioner, it seems like we should be putting the brakes on. I can see the exposure to the state through your agency and others, the Attorney General, that we just let some product out there that some child can take 20 pieces of 5 milligrams each and OD or exceeded concentration. To the counselor's point, you're saying it depends on the volume of lungs. It's like a cigarette. You might get 50 puffs. Someone else might get 20 puffs, but the concentration is there. So shouldn't we just say, listen, we don't have this down yet. Let's stop what we're doing. Just make it illegal until we get the language that my colleague, my Representative Tigliano, the chairman, and others, other than just say, well, let it go out there and hopefully nothing happens. I mean, I know the Delta 8 and 9 are federal, but while we can, don't we have a liability, a very large liability to the public to allow these sales to go on without much more serious regulation?
I believe the products that are causing concern are outside our regulated market. But at the end of the day, allowing adult use cannabis is a broader policy decision. You know, we're the regulator, but we're the policy maker in that. But I don't think the types of products that the Attorney General or that we've been talking about are coming from our licensed retailers or dispensaries.
So I still think that we're just saying, we're turning a blind eye. I mean, we're saying it's within your purview or it's not within your purview, but yet it's still on the shelves. Shouldn't we try to stop that? Because the language takes a long time.
I think what you're hearing is we
Yeah.
get that you guys are limited. Tell us what resources we want to see some action, and tell us what resources you need. That's, you know, you've asked for 65 agents and approps. What are they all doing? You know, and if you need 50 more to do something like this, tell us that. And then we can decide whether or not we think the resources should go there or how we're going to fund it or whatever. But I don't think we want to hear there's nothing we can do about it at DCP.
And I think we hear that. I guess I want to make sure I understand. Are you proposing kind of setting up a regulatory scheme for kind of any kind of hemp basically derived product? Is that what you think is?
It's some, you know, I'm spitballing.
No, yeah,
But
fine.
so there's a range of potential options. Yeah. One is just simply a bright line. You can't sell this stuff, period, full stop, no matter what the percentage is. Now we'd have to have a legal analysis as to whether or not we could do that or not.
Sure.
But if you could do that, that's something I think we're willing to entertain, because then it's easier. Then it's just simply anything with THC in it you buy from a regulated dispensary, that's within our wheelhouse. And it's easy for law enforcement or the AG's office to go into a convenience store and say, that's illegal. It's on the shelf, legal, gone. If there's going to be, however, this demarcation of below 3%, above 3%, legal or not legal, it seems like what I'm hearing from the committee members is we need some way to police this better than what we've got. And simply saying, DCP saying it's on the AG's office and then it's on the municipal police, that doesn't work for us. So what I was suggesting was, is there some other mechanism we could come up with whereby, you know, before any, understanding your limited resources are limited, putting the onus on the retailer to say, you want to sell this product, you need a license to sell it. And then it's on you to go through the process of proving to us that it's below the 0.3 threshold. And if you do that and DCP says, here's what we'll need for you to show that, then you get a license, whatever it is. Again, I'm just spitballing this. There may be other ways to do this, but I think what we're concerned about, obviously, is if this product's going to be out there outside of the regulated marketplace, we'd like to hear from DCP your ideas on how to police it. And if that means, guys, we need $50 million and 500 agents, then tell us that.
Noted.
Will do.
Thank you, Chairman D'Agostino. I'd like to associate myself with the remarks to Commissioner Siegel. I wish you the very best in your future endeavors, and happy to say that you've done an outstanding job in the Lamont administration. And it's been a pleasure working with you and your staff. To this fine gentleman, I'm sorry your name escapes me, but you mentioned my hometown and the largest town in my district, Enfield. I don't know if it's Chief Fox that's working with you and the department, but I'd like an email at your earliest convenience, just sort of updating me as to what that interreaction is regarding the largest municipality in my district. Because I just like to know, as opposed to reading it in a newspaper somewhere or hopefully picking it up along the way. So you mentioned my town's name, and so I have to follow up with that. And this is completely, unexciting, but as part of the initial bill discussion that you raised, you talked about eliminating background checks for caretakers. And I'm just wondering what that's about, because whenever we take away something like a background check, I'm just wondering what the genesis and rationale is for that.
Okay, well, first, and thank you for the kind comments. It's been a pleasure working with you as well. So the original medical marijuana bill that was passed, over 10 years ago, it provided that if you're a patient and you need a caregiver, you could have one, but the caregiver had to pass a background check. And I think at the time there was the concern we didn't want caregivers who maybe were involved in, illegal drug distribution to now be able to buy this medical marijuana product. Now that the product's available to all adult users anyways, and I think there's been a lot more thinking on whether prior drug convictions, how much that should be limiting what you can do. It seemed like this was a time to remove that requirement. So even if you have a debilitating condition and you need somebody, you can't drive, you need somebody to be able to get your medicine for you. And even if your son maybe had a certain conviction, we don't want that to disqualify. It'll also streamline our process. It's one less thing to do, but more just as a policy, it didn't seem to be a reason not to let somebody be a caregiver anymore. Even though that was sort of there when we had much stricter rules when we were a medical only state.
I appreciate that answer, Commissioner, because it gives me some assurance that that's okay to do now. And the rationale makes complete sense, and it's a wasted use of limited resources. And I agree with the leadership of the committee. I think, the horse is out of the barn when it comes to mind altering drugs. We have strict controls on prescription medicines. We have spot checks and strict controls on alcohol, very, the 3-tier system and spot checks with people not showing IDs and being underage and all sorts of things. So this is a little bit of the Wild West, and I can't blame the marketplace for, it's like, air's going to fill a vacuum, right? And so to the extent this is sort of like hasn't been touched and it's a new thing, the marketplace is going to embrace it, but it doesn't mean that we can't run fast and catch up and to protect the public's health and safety and their expectations. And I do agree with the initial statement that in I think it was our good ranking member, Rutigliano, that some people might say, why are we now, like, perhaps they would perceive it as overregulation. But as far as the commercial viability of a lot of these things, now that we've made that societal decision, viability is important too. And a lot of big players out there with a lot of financial capital have put a lot on the line for the regulated marketplace, and to allow these sort of diversionary areas to spring up that inherently are in competition and will take away from what we've cobbled together undermines not only our confidence in the system, but also the financial viability. And so we owe it as a fiduciary to them in some respects to make sure that their investment, with the ultimate goal by the proponents, and I argued again against this bill 3 times on the floor of the Senate, but the equitable end result to a lot of the neighborhoods and areas of the state which were disproportionately impacted by the war on drugs shouldn't be lost in this as well. And so if, the corner mini mart, we'll say, I don't want to pick on any particular franchise holder, has a bunch of products, that's not going to help our ultimate societal goal in moving down this path, which I thought was wrongheaded, but here we are and we have to finish what we started. So thank you all for your hard work regarding this. I know that, we do sometimes bump heads with the federal guidelines. And I was one of the ones that actually strongly supported hemp initiatives in Connecticut because I thought it was a good crop for the waning tobacco fields up in my neck of the woods, and as opposed to just solar arrays and massive fulfillment centers. So thank you for all your hard work, and thank you, Mr. Chair.
The marathon one day will go down in history of arguing against the bill three straight times. In 3 different sessions, I think, were called back. Representative Osborne.
Thank you, Mr. Chair. I apologize if you moved on from this topic while I was out of the room, but I want to return to the question of edibles from 2 different perspectives. One is the concern about attractiveness to children. I'm assuming we don't have the ability in the state of Connecticut to have like the Joe Camel of cannabis, correct?
Right.
Okay.
We have strict, so the edibles we have very strict rules on what the packaging for that needs to look like. And there are very strict advertising rules in the state as well.
Okay, so moving on from the packaging of it to the actual product itself. I think it'll come as no surprise to anyone that food is an addictive product in and of itself. So when I think of an edible in a Hershey's bar size product, I don't care how much you delineate it. I will eat a Snickers bar with no delineation just as quickly as I will eat the little squares in multiple factors on the Hershey's bar. And I'll feel a little more guilty every square I take on the Hershey's bar, but I'm still going to eat the whole thing. That's why I don't have a lot of it sitting around the house. But I am particularly concerned about edibles that are combined with another addictive product. Regardless of whether children can get or are attracted to them by the packaging, there are adults who don't have the self-control when it comes to a bar of chocolate or some other attractive product like that. So I am concerned that I'm hearing about 100 milligrams and one whole candy bar of multiple different servings. And I can't say that I have either the intellectual or personal knowledge about how much THC is too much THC or how many milligrams it takes to produce a normal amount of high. But I'd like to hear from you. What would happen if somebody ingested the entire 100 milligram candy bar? Asking for a friend, of course.
Yeah. I would certainly not recommend somebody do that. I don't know how each reaction would be.
How small would it need to be? So if somebody ate the entire candy bar, they'd be okay.
So it's hard to say because it would, much like other substances that
How
are,
much you weigh,
it's
how
all
you
the different factors,
metabolize it.
how your individual body metabolizes it, how much you weigh, how fast you consume them, what your experience is with the chemicals inside, right? So a person that's been using cannabis for some time may not have a problem with that quantity. A person that is naive may have more of a problem. And all of this ends up being a bit of a balance, and there's no real perfect answer to all of it. But this is we did look at what other states have done and done some things that are very similar to them, understanding that there's this balance between kind of the illegal market and kind of this now legal market, which has been a point of concern today.
Well, I have to say, I'm not greatly comforted by comparing us to other states that have already legalized it, because one of the advantages of not being the first state to legalize it is that we get to learn by the mistakes of other states. And I've been to other states where cannabis has been legalized for quite some time. And I got to tell you, that's not what I want Connecticut to end up looking like. So again, I'm going to come back to the question. Is there a way to determine for the average bear what too much would be? And can we just limit it to what an overdose would be? Buy two candy bars if you really have the capacity for that.
So I think the way we've tried to kind of thread that needle is by with warning labels on the product and things like that. And I agree with you. Like, we don't necessarily want to be other states, and we attempted to do the best that we could to learn from every other state that has done this before us. But all of this is still nationally somewhat in its infancy altogether. And so we continue to learn, we continue to try to address issues that we're seeing in other states before they become issues here. And we continue to work on this program by learning from everybody else and our own experience.
So does somebody at the DCP have an ability to get me some information about, on average, what too much would be for the average person in an edible?
I will see what I can do for you
I
in
really
that.
appreciate that.
my
Thank you
pleasure.
so very much. Thank you, Mr. Chair.
Thank you. Other questions? Anybody online from the committee? What DCP's bill number is, which one is it?
6697.
6697. Jillian, before you go, just before we let you go, I want to just put a bow on the vape discussion because we got off on the Delta 8 tangent there. So to summarize, I think look, we could say vapes have to be limited to 5 milligrams per serving. We'll hear from the producers later today as to whether or not that's something that they would do in the marketplace or not. Can you talk about what happened in other states when they imposed a limit? I think they've actually gone back and reversed the limit that they put on because of the unintended consequences that they saw. Is that right?
That is correct. There are certain states that have walked it back and others that have it in terms of legislative proposals this year to make the product as pure as it can be so that you're not inhaling unknown substances. And so, yes, you also are correct that you could have per container only 5 milligrams. It would look basically like an empty container. But yes, you can.
You could do that, but the DCP's feeling, talking to the industry participants, is it's not economically viable for them to do.
Correct.
Okay, all right. Other questions? Yeah, go ahead, please. Yeah.
Thank you, Mr. Chairman. I don't think it was in the DCP bill, but it's in bill number 6699. There's a provision in here that creates an off-site event permit for retailers and hybrid retailers authorizing the sale of adult use recreational cannabis to consumers at events not to exceed 3 days and 4 events per year. Are you guys comfortable with that? I mean, are you comfortable with, it could just be the bazaars coming back. Remember, we had the issue with the bazaar last session where people are just having open hemp markets, not hemp markets, cannabis markets. Or say there's a big music festival, somebody could set up a booth that sells. I mean, isn't that a regulatory nightmare?
Well, the way that bill is written is it does limit, so the events product would only be provided by a licensed retailer or hybrid retailer to begin with. So there would be that connection between our licensees and so it would basically be offsite sales that they would be offering. So it does create some protection. So the staff then is already trained on what all the rules are, what all the laws are. They would be tied into our seed to sale system already. We would have that, again, licensing hook so that if they did act irresponsible at these events, we would have a way to take action more broadly. So it is something we're certainly happy to work with the proponents of the bill, looking at that language and making sure it's something we could operationalize.
So say for the sake of argument, it's a music festival. And because right now, I don't think you could sell cannabis where alcohol is being sold, right? Is that
right? So
you
it's
can't,
unlikely.
but if
that
it's
it
a
would be something
festival,
like
you
that.
could sell both.
Well, no, I mean, the way that the bill is currently written, it would have to be a more cannabis specific event.
Thank you, Mr. Chairman.
Yeah, and again, just so we're clear, what we're talking about is a licensed dispensary wants to set up a temporary facility at a particular event, subject to all local zoning approvals, you know, et cetera, et cetera. The town is okay with allowing that. The licensed dispensary sets up a temporary sale facility, subject to DCP oversight, et cetera, et cetera. It's not a free for all of anybody can show up and, hey, I want to sell the stuff I grew in my garden.
Yeah, as I understand the language, again, not a DCP bill, but reading the language, it would be limited to licensed retailers or hybrid retailers. So it wouldn't be just anybody doing it.
Thank you. Other questions from committee members? Okay. It's an hour, just under an hour on the nose, which is pretty good for a commission on a industry that you will be coming back for. Well, not you, Commissioner, but Rod and Julia and Lila and at all for the foreseeable future. So thank you all.
Thank you.
Is Representative Cheeseman, I think, is next. Fine, perfect. So who do we have next? Representative Mar. Ah, Representative.
Good morning, General Law Committee. I'm really happy to be here and happy to speak in support of HB 5434. Looking at some of the regulations of cannabis. And really, I guess before I even get started, I would like to say thank you. It sounds like yes, yes, yes. On so much of what you said, I'm so happy to see that there's a bipartisan effort here to look at how we can keep our community safe. Clearly, we're in the very early stages of this market, and yes, we probably did put the cart before the horse, but it is incumbent upon the state to keep our community safe. And right across the state right now, what you're looking at is people that believe that cannabis was legal or that it is legal. So now they think it is safe and effective, neither of which have been totally proven. As a trained pharmacist, I would like to tell you how many days, hours, minutes that I spent learning cannabis. Nothing. So this is, I'm really excited to see that, you know, we're going to get some good studies behind it, but we do have a ways to go. Things that we need to take very seriously right now is some of the studies that we've seen coming out, looking at road fatalities, particularly in Colorado. There was a study that showed 48 fatalities in 2020 had drivers with greater than 5 nanograms per mil of THC in their blood. The American Academy of Pediatrics says, as I think DCP probably just alluded to, just had a study that came out very timely this month, looking at the toxicity that we have found and the percentage increase in the toxicity we found in pediatrics, to where in 2021, it was over 3,000 that had toxic amounts of THC in their blood. And 22% of those kids actually ended up in the hospital, some in the ICU. So we're not talking about deaths, but obviously these are very, very sick children that we need to protect. So what are we asking for? We're asking for to repeal the restrictions that we have for police being able to pull over cars if people are suspected in smoking cannabis. we're asking that people not vape or smoke around children. We do not have a lot of studies around secondhand smoke, but anecdotally, we know that secondhand smoke is an issue. We know that THC, we know that the smell of pot lingers, and it is lingering as we sit here in this room. So looking at studies for that moving forward, I think is very important. Making sure that we have our children safety in mind if we believe that the child is going into a suspected a car in like a facility where you've got preschool pickups or school pickups. And then next, looking at the labeling on the bottle. I'm really impressed with what I read through that the DCP is recommending on the labeling. I would say yes, yes, and yes. I know that we talked about the edibles. They're not individually wrapped. They need to be. The chocolate needs to be separated. I'm okay with the amount of the 100 milligrams, 5 THC per edible in a 100 milligram, but each of those need to be individually wrapped. I don't know if you're familiar with the blister packs that medicines come in, and that is particularly to help kids from overdosing, so they don't pop out the medicines. It's really hard to pop them out. If you're opening up something and you have to individually open up each wrapper, it's going to give you a pause on whether you should be doing it. And they should be, and I think that the labeling that they have out is good, but should be enforced regularly. The other thing we need to focus on is making sure that when people get their products, they need to also, each product needs to have the risks on them. It needs to be consistent with how alcohol, cigarettes, or even medications. You shouldn't look at just alcohol and cigarettes, because there's the dose and how to use it should be on there. Side effects should be on there, as well as the warnings that you might see on alcohol and cigarettes. So I like I said, I'm really thrilled with how you're going with this committee, and really look forward to seeing what you all come up with, and happy to take any questions.
Thank you, Representative. Questions from committee members? Representative Pizzuto?
Thank you, Mr. Chairman. Welcome, Representative. When you talk about the blister packs, is it something, I know it's quite often, I'll have a hard time opening them, for children in a chocolate product? Would that be the same type of a plastic, or how would they do that? Do you have any idea how you would use a blister pack?
My guess is that you could just individually wrap each one of them and have them. And that is, I think, what you were expecting to happen. That's not what's happening. Yeah. So that each one of them is wrapped as a dosage form. And then kind of looking at the flip side, I know you're talking about vape pens, and I can see that you're not going to get a 5 milligram hit, a single 5 milligram hit on a vape, but you might be able to have maximum of 100. You could probably look at something like that with a very well labeled 1 dose equals 1 hit. I mean, it just needs to be very clearly labeled when people, we need to give consumers information. And we are a smart community. If we have information, if we're educated, then we can move forward with that knowledge. And I think if it's all well labeled, I think that.
So if someone does take more than they should, like Narcan with an opioid, would Narcan work on something like it? Wouldn't. So we
No.
don't have any. Yeah. Sorry for that.
Hey, we don't do that in this committee or here. If you sign up for testify, you'll get a chance to testify.
Right.
If you're going to do that, you're going to get out of here. All right.
Thank
That
you,
was
Mr.
your
Chairman.
question.
Yeah, no, so there is no recourse then what would they do in a hospital setting? How would you help someone that takes too much of this?
I don't know the exact treatment. I
don't?
got to be honest with you.
As a pharmacist, okay? It's
No.
good to know.
Yeah.
Thank you. Thank you, Mr. Chairman.
Other questions from committee members?
Do you have any?
No, go ahead.
Good afternoon, Representative. I just had a couple quick ones. I was hoping that you could expand a little bit on the importance or the need for warning labels, why retailers need to put warnings up or warnings on websites and what effect they might have.
Yes, so in particularly with this market, the way, at least what I've seen is how you purchase is all on websites. So your first interaction with how to get a cannabis product is on a website. So what I would like to see happen is that with each product that comes up, not for it to say, the little blip of, 1 drop equals, but maybe more of a, this is how you use it, and these are the risks on each product. Now, the websites I think do, and right now I'm speaking particularly for the retail websites. If you dig through the facts and information, there will be a blurb that consistent high use may cause psychosis, or, there's risks with pregnancy. But I would like to see that on every product.
When you said that in the bill, it says that Connecticut needs to approve products. Are you talking about individual, like things that are offered for sale? That
Yeah, thank you. I think one of the things, the cart before the horse issue is that if this were federally approved, we would have the FDA backing us up. Right now, we basically have to make our mini FDA here in Connecticut. One of the things that I was thinking of actually while sitting here, and maybe this could be an idea, is regionally we have a lot of states that are going through the same issues as we are. I'm wondering if there might be a way to regionally look at some of these approval processes, some of these testings, so that we can help defer the cost just to us. This is a huge undertaking, and maybe something that this committee didn't really think of. I mean, but what I feel like is that the tax dollars that are going to come in on this is really going to have to go to regulation, and that's really not what that's not the intent of this. And when I say this, I also don't want to see the cost going up. So right now, if you go on and you buy a product that's like $50 worth, by the time you check out, you're going to be paying about $60 worth. So we're already adding costs. What that's going to do is that's going to make it, people are going to turn away from these legal, safe products that we have, and they're going to buy them illegally. And I don't know exactly where that's going to be from. And then we really can't assure that there is a safety component around these products. So I don't want to see the taxes go up. I don't want to see high prices. I don't want to see these products be priced out of their market. That goes against the grain of what we're trying to do. So I hope that maybe we can look into something outside of the box to maybe look at this as a regional effort, because certainly the federal government is not going to take this on.
Thank you, Mr. Chairman. Thank you.
Thank you, representatives. Other questions from committee members? Anyone online? Thank you, Representative.
Thank you so much.
MJ?
I see that Representative Cheeseman is not back, so we can go next to Representative Vincent Candelora.
I think he's just submitted written testimony.
Oh,
Holly?
Holly Cheeseman.
Perfect timing.
Representative, please.
Do you want to go, or you want us to give you a break? Okay.
Let's rock and roll, people.
Good afternoon, esteemed members of the General Law Committee, Chairs D'Agostino, Ranking Member Ritigliano, and in absentia, the Chair and other Ranking Member, and other distinguished members of the committee. Well, it's very strange to be sitting in General Law on this side rather than peering out at everyone testifying. Here we are. And I will not rail against cannabis, as the good chair threatened I was going to do. I'm here to testify on HB 5434. It's a lengthy bill with many elements, some of which I know have no chance of seeing the light of day. I'm going to concentrate on two of the sections, the one that deals with labeling and the one that deals with driver's education. Having legalized this substance, we are not doing our duty as a legislature unless we inform those who are going to partake of this substance of the risks involved. Even states like California are looking at strengthening their labeling requirements and modeling their packaging labeling along what Canada prescribes. And I've included that in my testimony. You are required on all marijuana products to have a rotating health warning label. So on your Hershey bar, so 10 possible warnings on those particular products, you would choose one of the 10. It's set against a bright yellow background, a minimum of 12-point font in black. So one is led in no doubt that these are the possible risks. And they include the smoke from cannabis is harmful and contains toxic chemicals. Don't use while pregnant or breastfeeding. It was very concerning when the Colorado Department of Public Health did a random phone sample of cannabis retailers. 70% of them recommended the use of cannabis to deal with morning sickness in pregnancy. That yet this leads to preterm birth weight, impaired neurological development, and real harms to the unborn child. Don't drive or operate heavy machinery. Youth, young people and adults, adolescents and young adults are at greater risk from harm. We know if you start using this high potency cannabis before the age of 18, you have a 1 in 6 chance of becoming addicted. 1 in 6. That's almost double the adult risk. Indeed, if you use alcohol, there's a 1 in 10 risk of becoming an alcoholic. But this risk is even greater for young adults. It can take up to 4 hours for you to feel the effects after imbibing the edibles. I think this is one of the great dangers and perhaps misconceptions. When I was here before and the commissioner was talking, I've had a gummy. I don't feel anything. I'm going to have another gummy. I'm going to eat that whole bar of candy. And before you know it, you are severely impaired. New Jersey requires an additional label. That's the poison control number on all edibles. If you discover, your child or you're afraid, they require the use of the poison control number. I think that would be an excellent idea. I think there are a number of additions to labeling that we in all conscience should put on these products because they do come with danger. Again, the horse is out of the barn. Responsible use is responsible use. But for those people who may be imbibing for the first time, hey, let's try this. They should know that it doesn't come without risk. And again, the section that deals with mandatory additions to our driver's ed. Many users of cannabis, as have a Yukon study recently found, underestimate their level of impairment and believe after an hour and a half they're fit to drive. Whereas the research shows you should wait at least 4.5 hours before you can safely take the road. I believe Mothers Against Drunk Driving found 6 in 10 adults didn't think driving while high was a danger. Again, just as we have learned that you shouldn't drink and drive, we need to send the message, particularly to young people, that driving while impaired is just as dangerous, just as wrong as driving when drinking. And there are other parts of this bill. I think we need to look seriously at our packaging. Child resistant is not child proof. I know Yukon requested in excess of, $200,000 for additional poison control resources because we've seen such a huge increase across the country as this has become legalized in childhood poisonings. I think we need to look at the ability of law enforcement. California prohibits either drivers or passengers from eating or smoking cannabis in motor vehicles. Probably the wrong committee for this. I mean, we know where we are, but having done what we've done, commercializing this product, making it available to adults, what must we do? What should we do to ensure that it happens in a manner that keeps the maximum number of people safe, prohibits the most amount of harm, and makes our residents safer? And I think that's the job of this legislature. So I'm happy to take any questions. As I say, it's strange to be sitting on this side of the microphone, but I know from the previous conversations I've had with everyone on this committee how seriously you take this and how you realize part of your important responsibility is to ensure the safety and well-being of our residents.
Thank you, Representative. Good to see you. I'm sure it won't be the last time.
You can't get rid of me that easy.
Well, I think, yeah, I think you'll be
Chair
back on
D'Agostino.
the committee.
Yeah.
Representative Tigliano.
Yeah, thank you, Mr. Chairman. Good afternoon, Holly. How are you? I'll just ask you a couple of quick questions. The 200,000 UConn requested, was that for their own poison control line or was that for a study of?
No, that was for for additional resources for their poison control because they anticipated significant extra calls.
Do we have, and that's just on the UConn campus? Or
Actually, I just want to be clear. Is that
That's
is that the university? Or it's a separate arm, right? It's this poison control
the
center.
poison control, but it's run, I believe, run out of UConn. And
Okay.
they put in a request for the additional funds. And I did ask if they had the data so far, and they don't.
Okay.
In terms of additional calls, but I know if we look at what's happened elsewhere in the country, there've been, 1,000% increases in calls to poison control centers in states where it's become legal.
And I guess my last question would be that all of the labeling suggestions in this bill, are they consistent with both alcohol and what used?
I think
on
depending on
tobacco?
the state of this particular state requirements, yes. I mean, in California, they have Proposition 65, which requires if there's any risk of cancer, everything has been
Right.
labeled.
But we put health warnings on tobacco
Tobacco.
and alcohol.
Hmm.
And so this bill just says
We
some
should-
manner, we're going to rotate and use the same sort of warnings for cannabis.
Exactly.
Thank you. Thank you, Mr. Chairman.
Thank you, Representative. Representatives, questions for Representative Cheeseman?
Oh,
Representative
thank you,
Pizzuto,
Mr.
please.
Chairman.
Thank you.
Welcome Representative Cheeseman. Speaking with pulmonologists that have been in the building and so forth, they're telling me that there's a significant amount of damage as with cigarettes, but I don't seem that never seems to come up. Has you kind of looked into that as well?
I don't know if UConn has looked at that, but we actually received a report when the DCP was tasked with looking at cannabis lounges, if you were to go somewhere and imbibe. And just quote from the report, smoking and vaporizing cannabis create secondhand cannabis smoke and unhealthy indoor air quality. Although not identical, cannabis and tobacco smoke contain many of the same toxins. Cannabis pre-rolls generate 3.5 times the smoke as a Marlboro cigarette. And though vaping produces less smoke, it pollutes the air at a similar level to a cigarette. Long-term smoking of cannabis is associated with many of the poor health effects as smoking tobacco, including myocardial infarction, heart attacks, ischemic stroke, and chronic bronchitis. So if we, I think particularly if you are smoking or vaping, that's a significant health risk, and we should indicate that there is that danger. If, again, this is now a legal product, but we need to provide the consumers with the information they need to make an informed and a safe choice. And then it's up to them, as it is legal, to weigh up the risks, the same way we do with cigarettes, the same way we do with alcohol. And we have to prevent, as far as possible, people who are under 21 from using this because it brings such significant risks.
Those are comorbidities that should be listed for sure. Yeah, thank you. Thank you, Mr. Chairman.
Thank you, Representative. Other questions for Representative Cheeseman? Anybody online? Thank you, Representative.
Thank you.
We'll see you in the chamber.
Indeed.
MJ?
Thank you. Sorry, Mr. Chairman. Up next, we're going to have Ginny Ray Clay from the Social Equity Council.
Just be sure to hit the red button too. There you go. Perfect.
I'm being fancy today with my laptop. Senator Mulrooney, Representative DiAgostino, Senator Ciccarella, Representative Ritigliano, and honorable members of the General Law Committee. Thank you for the opportunity to offer testimony regarding several bills on your agenda for today's public hearing. I am Jenny Ray Clay, the Executive Director of the Social Equity Council. I am here today to testify in support of House Bill 6695, which was requested by the Social Equity Council. We greatly appreciate the committee's thoughtful consideration of this proposal. Additionally, I am here to provide testimony regarding House Bill 5432 and in opposition of House Bill 6700. House Bill 6695, an act concerning recommendations by the Social Equity Council concerning cannabis regulation. This bill would recommend 3 aspects of the responsible and equitable regulation on adult use cannabis at RERACA. First, the requested amendment clarifies the definition of control for social equity applicants and equity joint ventures. Clarifying this definition will protect social equity applicants by ensuring they are involved in the direction and management of their cannabis businesses. Second, it eliminates the need for the Social Equity Council to annually recertify the disproportionately impacted areas map. Per Public Act 21-1, the Social Equity Council must use the most recent 5-year United States Census Bureau's American Community Survey to determine which census tracts are DIAs. Census tracts are modified with every decennial census. However, boundaries generally don't change that significantly. Therefore, an annual recertification is not needed. Additionally, recertifying the map annually is proving disruptive for social equity applicants, as potential applicants could be located in the DIA 1 year, then removed in the next. And lastly, it modifies the criteria for Social Equity Council, for the criteria the Social Equity Council uses to identify DIAs by replacing unemployment rate with adjusted poverty rate metric. A disproportionately impacted area is currently defined as a census tract in the state that as determined by the Social Equity Council has a historical conviction rate for drug-related offenses greater than 1/10 and an unemployment rate greater than 10%. Unemployment rates are heavily influenced by short-term economic situations. This is especially true in 2020 because of the COVID-19 pandemic. This has resulted in outliers or towns that historically would not be considered DIAs being included. Over time, poverty is more a stable metric that is less influenced by short-term economic situations. According to the Institute for Municipal and Regional Policy at the University of Connecticut, research shows that the war on drugs is more closely correlated to historical poverty rather than the unemployment rate, which are the communities that the Social Equity Council wants to reach. Lastly, replacing the unemployment rate with a poverty rate will less likely cause significant variations from year to year in the census tracts identified. House Bill 5432, an act concerning graduated schedule of cannabis license application fees. This bill would establish a graduated schedule of license application fees that increase in proportion to the number of license applications that a person submits to participate in the adult use cannabis market. The Social Equity Council supports a more equitable lottery process, and we look forward to engaging in conversations on how best to go about doing that. House Bill 6700, an act concerning hemp licensees and adult use cannabis market. The bill would enable a licensed hemp producer to seek a cultivator or microcultivator license from the Department of Consumer Protection. And if the hemp producer receives a cultivator or microcultivator license, participate in the state's adult use cannabis market. The SEC opposes House Bill 6700 for several reasons. Currently, there are 78 hemp growers licensed by the Department of Agriculture. That number is sure to increase if hemp farmers are allowed to cultivate adult use cannabis. This could lead to oversupply issues and result in generally diminished retail prices, as has occurred in Massachusetts, making it difficult for social equity licensees to benefit from the legalized market. The proposed conversion pathway for the substantial and potentially growing number of hemp farmers will also bypass the social equity lottery, a unique opportunity for residents of DIAs. These residents are often faced with reduced financial capabilities and may have limited opportunities to own a business in this nascent industry. If many of the 78 current hemp growers take advantage of the conversion pathway, there may not be market capacity for further social equity cultivation licenses, effectively locking out DIA residents from cultivation in the future. The Social Equity Council was created to ensure the adult use cannabis industry is grown equitably and that revenues generated by this industry are returned to the communities hardest hit by the war on drugs. Allowing hemp farmers to cultivate adult use cannabis would hinder this effort and undermine the goal of addressing systematic inequities in the DIAs. Thank you for your time today, and I'm happy to answer any questions you may have.
Thank you. Questions from committee members? Representative Pizzuto.
Thank you, Mr. Chairman. Welcome, Ginny Ray. Quick question. I know that you've been instrumental in working with diversity on these people that are allowed to do this. Have you been successful in increasing diversity so far? I know you're always looking for more, but have you started with at least some minority owned?
Owners, absolutely.
Okay.
Yes, we have. I can give you, are not collecting right now racial makeup of the owners, but we are collecting folks who are living in the DIA information. That was one of the criteria for being selected as a social equity applicant, is you had to live in a disproportionately impacted area at some point in your life.
Very good. Thank you. Thank you very much.
Thank you, Representative. I thought the proposed changes to the DIA definition were really well thought out and compelling, make a very good arguments just for why you want to change the criteria and use the poverty data as well. I think that makes a lot of sense. And it's precisely because I thought that was so well thought out that I do have a concern with the other part of that proposal, which is kind of a catch-all, which I get why you included it, right? It says the council can develop other metrics to determine the relative disproportionate impact area at issue. I think I'd be more comfortable with exactly what you did with what you proposed on poverty. Like when you come up with something else, you think an additional change works for DIA, some other metrics make sense, come to the committee, let us hear it out just exactly the way you did on poverty. And I mean, I think you're going to have a lot of support for that particular change. I guess I'm just a little uncomfortable with ceding kind of a catch-all authority to Social Equity Council, at least right now, to let you come up with other metrics without and bypassing the committee process. We put in a lot of time and thought into the DIA through the whole process over years. And I think the evolution of it that you're proposing makes a lot of sense. And so I'd like to just sort of keep that process going, at least for now, just to have that. So that was my one quibble with what you proposed, but I thought the specific proposal on changing the DA with respect to poverty made a lot of sense. I know you guys, it didn't come out of the blue. You guys actually, I think, had some studies that you did.
Yes.
We via UConn behind that.
Yeah.
You actually looked at those metrics. That's exactly the kind of analysis we want Social Equity Council to do when it comes to the evolving standards of how you implement your mandate. Just my 2 cents.
Sure.
Thank you.
Yeah.
Other
Appreciate
questions
it.
from committee members? Thank you very much. Appreciate it.
Thank you very much.
MJ.
Thank you, Mr. Chairman. We have up next Ben Zacks, who is online.
Hello,
All right, we can hear you. I don't think we can see you just yet.
how about now?
Might be an issue on our end. Hang on.
That's all right. I wouldn't call mine a face for TV.
There you go. You got it.
All right. You'll
All
have
right,
me.
go ahead, Ben.
Yes, thank you very much for the time today, General Law Committee. I very much appreciate the opportunity to offer testimony regarding a number of cannabis bills. I like to think that Fine Federal is Connecticut's cannabis company right now. We are locally owned and operated, and we've put in the time, work, and effort to open 3 of the state's first hybrid dispensaries. We opened the first social equity joint venture, which is a novel concept that we thank your committee and the state legislature for introducing. We opened that in Manchester. We've also, with our social equity partners, paid our $3 million fee for a DIA cultivator license without litigation. We employ 150 people across the state, and we look and hope to expand. In the 6 weeks since adult use cannabis sales have begun in our state, it has been an operational success. Much of the fears of not in my backyard, traffic concerns, folks coming by, issues of traffic, et cetera, have not come to fruition because of the incredible work and diligence that I think us operators, as well as the Department of Consumer Protection, have put into place. And we also thank the Social Equity Council for working with us and putting our partners and us in an opportunity to have opened our location in Manchester. I'll focus on, I know there's a number of bills, but I'll focus on Bill 6697, which is we support with some changes. While that is true operationally, we are not competitive with the market to our north in Massachusetts, as well as the east to Rhode Island. Specifically in this bill, the expansion of prohibiting static billboards during daytime hours removes one of our only ways to market. We should be held to a similar standard to liquor or gaming, which do not have such difficult requirements regarding our marketing, because we are currently playing a game tied behind our back. We still have people showing up, not knowing that we've opened, even though there's been a lot of news of the law 6 weeks ago. Another element that we believe needs to be codified within this bill is that the DIA cultivators, 41 were approved, only 11 have paid their $3 million fees after attesting to pay it within 5 days or 60 days afterwards in a letter, and are not being held to that standard and are given an open invitation without the understanding of the state to know how the market is going to expand. We also believe that those licenses should be cultivator licenses with 2 equity joint ventures attached to final licenses, not dispensary licenses that you may or may not build out because you don't want to or spend the money. So we believe that you need to have a final cultivation license before you can open an equity joint venture. We also firmly believe that by delineating the difference between 20 miles of a equity joint venture of a hybrid retailer, as we are, and a Section 149 cultivator, and forcing them to be 20 miles from each other has an incredibly enormous negative impact on our social equity partners that own 65% of a cultivation license, who now can't place a location within a better retail area because they are tied to us as a retailer, which has separate ownership and separate backing. So those are around Bill 6697. Also around Bill 6670, we agree with Mrs. Clay as well. And we believe that the hemp applicants had an opportunity to apply like everyone else in the social equity applications to create a partnership, and to have the opportunity to skip the line creates an unequitable and unfair advantage when there was an open process for 2 years. Overall, we're proud of the program that we're building. We're proud of the safety around it. We are proud of the way we're working, but we believe that there are some changes that can be made and added to create a better market, to create more jobs, more tax revenue, consistent operations, and continue on the path that we're running with between the operators and the state. Thank you.
Thank you, Ben. Questions from committee members? All right, seeing none, thank you very much.
All right, thanks.
Next up, we're gonna have Sean McGill and Jacob Honing.
Okay, well, I feel like I could say quite a lot, but I'm gonna more or less try and stick to what I have written down here to start at least. So, good afternoon, everybody. I'm here today in support of Bill 6700. First, I would like to take a little time to introduce myself. My name is Sean McGill. I was born and raised in the quaint hills of northwestern Connecticut on 13 acres in Harwinton. My eye for new opportunities, passion for the cultivation of medicinal plants, and willingness to conquer the unknown led me to Northern Michigan University for the majority of my college experience, where in the spring of 2021, from the couch in my living room, I was awarded my Bachelor's of Science in Medicinal Plant Chemistry. Upon graduating, I moved back home to start our hemp farm, the CBG Gurus. On the farm, we are USDA certified organic and practice a regenerative, no-till permaculture style of agriculture. This means that we farm in alignment with nature. We focus on cultivating not only the plants, but the soil as well. We do not produce any waste and use minimal energy. We collect rainwater and produce a large amount of our inputs from local, widely available plant and animal ingredients. This has proven to increase soil health year after year while producing extremely high quality cannabis. These qualities can never be achieved in an indoor corporate cannabis setting. The only way to guarantee high quality craft type cannabis production is to partner with local farmers. Farmers who already have the infrastructure, know-how, and teams necessary to produce high quality cannabis. Partner with Connecticut hemp farmers. Connecticut cannabis needs us, and we're ready to put seeds in the ground, just like we do with our beautiful hemp type cannabis plants every year. I would love the opportunity to continue supporting the development of the cannabis space in Connecticut, but as a young entrepreneur who goes where the opportunities take him, I will do what makes the most financial sense for myself and my business. With that in mind, $1 to $3 million is an unfeasible amount of money to spend on a license to grow marijuana. In that case, I would much rather go partner with some friends in Michigan or Massachusetts, where all of their license fees are less than $50,000 and as low as $1,200. As a young farmer who has a passion for sustainability, innovation, natural farming, healthy competition, and high quality cannabis, I will continue to be a part of the movement to rebuild our soil, normalize cannabis, and create world peace. I implore you to empower us as farmers who have devoted our lives to this craft, the ability to provide the people of our state with a high quality crop grown in the right environment with loving hands that have been trained in the art of cannabis cultivation. Thanks.
Perfect timing. Questions for you, Senator? Hold your applause, please. We don't, thank you.
I definitely support world peace. I appreciate it.
Unless it's for world peace. Go ahead, Senator.
My question is, first of all, you're a great public speaker, and I appreciate your ingenuity. But I'm just curious, how do you grow things? How do you plant things without tilling the soil?
If you must know, so how we choose to do no-till is essentially instead of tilling the soil, you can till once, but we lay down lots of cardboard and wood chips to reintroduce a lot of organic material into the soil. We use a lot of cover crops to help with the weed management. There's other ways to do no-till, but the main reason why we do no-till is to increase soil health. I believe that a living soil is the healthiest soil, and basically all the bacteria and fungus that live in the soil can't live if you grind it up 2 or 3 times a year. So that's why we really just try and kind of harbor that life.
No, I appreciate that, because I saw some stuff on Instagram, those little reels that are like 2 minutes long. And there was a gentleman from Great Britain saying that the way we use the land, it depletes its ability to regenerate. Letting ground go fallow is one way to do it, or rotation. But your way seems, and with your degree, cutting edge. So I appreciate it. The $3 million also makes it a very elite club. Either you have a ton of dough, or people that have a ton of dough. And so for our young farmers or entrepreneurs, it really creates a barrier. So I'm very open to these arguments and appreciate you taking the time. Thank you very much, Mr. Chair.
Thank you. If you were allowed to convert, and this is specific to your farm, obviously, what kind of yield would you be able to produce on a yearly basis?
In an outdoor setting or a greenhouse, I guess, it really depends on the cultivation style. But just, as an example, right now our farm sits on 13 acres. Last year, we only farmed half an acre. We were able to raise 600 plants on half an acre. And, you can generally expect, with good cultivation practices, a yield of half a pound to a pound of cannabis per plant. We also do in-house extraction and manufacturing. So really everything stays on the farm. That's something we're really proud of. But yeah, a yield of half a pound to a pound per plant. And if you do get the technology to, harvest multiple crops per year by using like light deprivation greenhouses with environmental controls, then, you can get up to 4 to 5 harvests per year.
Interesting. Thank you. Other questions from committee members? Please.
Thank you, Mr. Chairman. Good afternoon, sir. I just, we ask these questions a lot. The chairman is fond of doing it, but the Social Equity Council, the one sort of convened to regulate and oversee the market, is against this bill. I didn't know how you reconciled that, or how you could work through that.
I don't want to say anything like mean. The hemp farmers have been in the cannabis space since the federal legalization of cannabis. And, I can't really speak for everybody, but I think some of us are struggling or succeeding a little bit more than others. So I think helping the Connecticut hemp farmers is a form of social equity. And it's helping a group that has very clearly been in support of cannabis legalization since day one. Whereas other parties, may just be kind of jumping at the new opportunity. We have been here cultivating cannabis and, trying to create a space where conversations like this can happen for quite a while now.
So I remember I was on the committee when I think we made hemp legal, right, Senator? We did that. It was about 10 years ago or so. And they were talking about all the things that it could be used for, and rope and paper and all this other stuff. And it was supposed to be this great thing. What do you do with your hemp product now? Do you make CBD? Do you make clothes? What is your primary?
Yeah, so we do focus on the cultivation of the flower. So we have a line of smokable products, and then we do in-house extraction using only ice and water to basically create an extract that we use to create our line of edible products. In hemp farming or cannabis farming in general, you can do something that's called like tri-cropping. So then you're farming for the flower and the fiber and the bark, which is what they use for clothes. However, unfortunately, right now on the East Coast, there's really not too much infrastructure for fiber type hemp cultivation. So it doesn't really make financial sense to grow hemp for fiber, which is grown in more of like a corn style versus we grow for the flower. So we space our plants like 6 feet apart. And like I said, I would love to use, the woody material for other, things, but at this point, it's just not really financially sound because of the infrastructure lacking.
So I'm through you, Mr. Speaker. I got a couple more. I might get all my hemp questions out with you if you don't mind, because I see there's a lot of that extract that you're talking about. Do you what do they use when they make the deltas, when they make the synthetic? Is that come from? No. I'm asking a question. This is why we ask questions, so we learn, right? Everybody, calm down. Does that come from the extracts that you make? Do they take that and then produce something else? I don't really know.
Sure. So I think it's often very, very misunderstood what Delta 8 is and where it comes from potentially a legislative and definitely from a consumer standpoint. We go out and we vend everywhere. So we talk to a lot of consumers about hemp and cannabis and everything. And a lot of people just don't understand what Delta 8 is. Essentially, Delta 8 it's a naturally existing cannabinoid that is synthetically produced in a laboratory. So what happens is generally CBD flower is what's used, and in a lab using a bunch of chemicals and equipment, they take that CBD flower, perform an extraction, you get your CBD extract, and then using more chemicals and organic chemistry, you can take CBD and turn it into Delta 8. You don't grow Delta 8.
Okay. How do they put the effects in it? How do they get the THC in it? Because if it starts with hemp, which is like minimal amount of
Chemistry.
THC, so they add this to it. So
no, chemistry. You take CBD and you add chemicals that shift the bonds, and it turns CBD into Delta 8.
Understood. Good. I appreciate that answer. That's interesting. And my last question is, because we've heard from many of the licensees that grow marijuana that they need to do it indoors because of mold and control. And they could be right, they could be wrong. I have no idea. I would like your perspective on that, but they do say there's some risk to growing outside. I don't know if that's true or not.
Well, there's risk to everything. You can contaminate your entire indoor facility if somebody improperly installs your air conditioning or something like that, And I think there have been a lot of problems with contamination of cannabis coming out of Connecticut. I think that's, recently there was a huge issue with mold and all that stuff. So really it's in agriculture, we call it integrated pest management. And pest, like mold, is a pest. It's not just bugs.
Understood.
So it's really just having a program to monitor problems like that. And even as hemp farmers, we're required to undergo, not only pre-harvest compliance testing, but also compliance testing prior to selling any product. So we have to demonstrate that our cannabis products are below, the levels that have been deemed. And I would just say that it's like a risk to growing anything, like you can grow peppers inside and they'll probably turn out a lot better, or you could grow them outside and like, is there a risk? Yes. But yeah, I also really am, we believe in the power of the sun, not only for its ability to lessen the amount of energy consumed and the amount of waste associated with indoor cannabis production, but also if you ask a lot of experienced cannabis farmers, some of them believe that, just because of the light spectrum from the sun, it really does produce the highest quality products. And yeah, like I said, farming in alignment with nature. Why produce waste when you can rebuild soil?
Oh, I appreciate that answer. And my last, your perspective being at the hemp, you would have no care or worry if this committee was to take action on Delta 8 or 9 or anything like that. It doesn't affect you one way or another. You have no interest.
Personally, I do not like Delta 8 or THCO at all. Because of the fact that the consumers don't really know what they are. I, again, when vending, like I'll always tell people, you know, if you're trying to use cannabis medicinally, maybe try some of the non-intoxicating cannabinoids like CBD or CBG, which are naturally produced by the plants. If you're trying to get high, smoke THC, Delta 9, like the natural stuff. So that's my belief. So I would not be impacted at all if y'all banned Delta 8. I'd be
I
happy
appreciate
about it.
that. I've enjoyed the conversation. I found it enlightening, and thank you, Mr. Chairman.
Other questions from committee members? Thank you, Sean. You're a good spokesman for your industry. I think I had some requests from committee members while you were speaking. We'd like to tour the farm. So you can leave your contact information with our clerk, and maybe when the weather gets good, we'd like to come out and see the operation. MJ.
Up next, we're going to have in person David Salinas.
Good afternoon, Chair, Vice Chair, and other members of the committee. I want to thank you for your time today and allowing me to speak in opposition of HB 6700, an act concerning hemp licensees and the adult use cannabis market. My name is David Salinas of Milford, Connecticut. I'm a husband and father of 3. I'm a serial entrepreneur here in the state. Started multiple companies, most famous for the District Technology and Innovation Campus in New Haven, which is home to one of the most successful co-working spaces. I invest in a lot of startups and I mentor a lot of companies here in the state. But today I stand before you as an owner, a co-owner of Let's Grow Hartford LLC, which is a minority-owned cannabis company where all of our owners are Connecticut residents. We are led by a woman of color from Hartford with a great vision of social equity. So I think it's important to note that the 149 license is only for social equity applicants, and the qualification was to make under a certain threshold of money and then come up with $3 million. So to the point of Ben Zaks and the $3 million that's been paid already by the 11 companies and the companies that will be paying in the future, they're at a distinct disadvantage now if we continue to license people in without understanding the true supply and demand issue that's currently happening. I have no problem with any of the farmers, but currently there is a good chance that we have already over licensed the state through the lottery process and the 149s. If you do the math and you reverse engineer the expected revenue that the state was anticipating, which has been quoted anywhere from $600 to $800 million in total revenue, that is then being counted for taxes, being counted for and against to create the tax base. There's a good chance we're never going to reach that number because supply is going to crash the market and you're going to see the prices drop down, as we've seen across the border in Massachusetts, where they had a price drop of from $3,600 a pound down to $1,200 a pound, which means that they're seeing less taxes. Colorado just collected $100 million in less taxes in 2022 from 2021 because they over licensed, and states that continue to over license are having this issue. So I came here today not knowing that there were 78 hemp agricultural licenses in the state of Connecticut. This is just using the basic math for the licenses, the lottery licenses, and the 149s that were granted so far and approved. We are going to put a tremendous amount of pressure on the people that have worked really hard to get these licenses, especially the social equity members that are fighting to fund these programs, that are fighting to find locations in these DIAs. And quite frankly, if you look at the DIAs, the landlords that have the properties in the DIAs are predatory. They're buying they bought properties for $50,000 3 or 4 years ago, and they're trying to sell it to social equity applicants for $3 and $4 million because they think that the cannabis world is going to be a gold rush. So I think that right now what we need to do is we need to let things settle out, let the people that paid the money and came in today figure things out, let the market settle itself down so that we can see what the health of the market is going to be. And more importantly, as a citizen of Connecticut, what the health of the tax base is going to be. And I thank you for your time today.
Thank you. Questions from committee members? Do you have a sense of what the supply? I mean, I don't have a good handle on how to even measure supply, how to even understand, like, from an aggregate level, what kind of supply is needed. And I wonder if we can extrapolate anything from other states. Obviously, we're smaller than Colorado and other places, but what kind of supply we're talking about on an aggregate basis?
So you can reverse engineer it based off of the estimates on revenue, right? So if you take let's say you take a number of 500 million, right? And the number that was used in most of the places like MJ Biz was 750 million. I recently saw 800 million, but for the sake of the conversation, say it's $500 million and we're never going to see the number 800. If it's 500 million, you divide that by a price per pound, pick a number, 1,000, 2,000, 3,000. You divide that by the amount that someone can cultivate. It's typically about 1/10 of a pound per square foot of canopy. And you look at, and you'll be able, and then about 5, say indoor, not that everybody's doing indoor, there are going to be a lot of outdoor growers, but let's just say indoor, that there's 5 turns, 5 transitions where they're able to plant and harvest 1/10 of a pound. So they're able to do about 1/2 pound per square foot of canopy. Just the 149s alone, there's 24 approved, 11 paid so far, but just say that the 11 paid can grow 15,000 square feet up to 240,000 square feet, right? So that is 125. If someone builds a 240,000 square foot facility, that's 120,000 pounds, right? So if you reverse engineer the numbers, you'll quickly see that if 2 of those happen, we're oversupplied, right? And it's 24 approved. Then you have the micro cultivators, and if the micro cultivators are able to upgrade their licenses, which by right they can over 5 years, you're going to wind up with a huge supply and demand imbalance, and that's going to crush the market. Everybody that invested today, which by the way, there's no out-of-state money coming into Connecticut. The MSOs have dried up their cash reserves for the most part. The public money and the stocks are gone, right? They're all down. So the money that people are investing in Connecticut cannabis are through Connecticut citizens. So if we crush this market, you're going to see people lose homes. You're going to see people lose their 401ks, and you're going to see a massive issue. So I can share the math with you at some point if you'd like, but I would just use any derivative of the numbers that I gave you, and you'll come up.
Your starting point in that analysis was retail sale numbers.
Yeah,
Okay.
which is half the market. So if a retail sale is, let's say, $4,000 a pound in retail, the supplier is charging half, so 2,000. So the $700 million number, $750 million number is actually $375 million at the wholesale level, and then you can reverse engineer from that on a price to the pounds.
Okay. All right, thank you. Other questions from committee members? Thank you, Deb.
Thank you.
Up next online, we have Kirsten Nauman.
Good morning.
See you, and I think I can hear you.
Can you hear me?
Yep, go ahead.
Okay, great. Thank you. Good morning. My name is Kirsten Nauman. I'm a resident of Milford. I'm on the executive committee of the Connecticut Association of Prevention Professionals, and I am co-chair of the Connecticut affiliate of Smarter Approaches Marijuana, which is known as CTSAM. I'm testifying today in support of House Bill 5434. I have submitted written testimony, so I'm just going to cover a few highlights here today. I support establishing a potency cap on each serving and requiring potency disclosure on packaging. I urge you to explicitly include all vape products containing THC, as local youth surveys across the state demonstrate that vaping is the preferred method of ingestion among youth. And based on what I heard before, I really hope that our kids' health is not put at risk because it's not financially viable for producers to make a safer and less potent product. I support further expansion of packaging requirements to be in parity with alcohol and tobacco, requiring that cannabis products be sold in child-proof, not just resistant containers, and requiring clear and explicit warning labels. I support prohibiting any gas station, convenience store, or other non-licensed cannabis retailer to sell any THC products, whether they're created from hemp or any other cannabis plants. I support provisions to keep our roads safe from THC impaired drivers, including financial support to send officers to the drug recognition expert certification training. As there's no reliable roadside test yet for THC impairment, DREs are really essential to keeping our roads safe. We only have about 50 in Connecticut so far. It's very costly and timely to send officers to do that. They typically have to be out of their own departments for about 2 weeks. Other states with commercial marijuana sales have experienced alarming increases in THC impaired driving and crashes. I support repealing restrictions on cannabis-related stops and searches of persons and motor vehicles when officers observe drivers or passengers actively using marijuana. I support specifying that imminent risk of serious harm includes a situation where a parent or guardian visibly under the influence of cannabis tries to pick up a child from a school or daycare facility. And I support requiring each minor applicant for a motor vehicle license to complete a course on the impairing effects of cannabis and its impact on the ability to operate a motor vehicle. And finally, I support requiring the DCP to review and approve each cannabis product, review cannabis tracking procedures in retail establishments and pharmacies, and to designate cannabis as a Schedule II controlled substance. Thank you for all of your efforts to keep our communities and our youth safe.
Thank you. Very efficiently done. Questions?
I was gonna have questions, but she did so great that.
You did great. You anticipated all of our questions. Thank you very much for your testimony. MJ.
Thank you, Mr. Chairman. Next up online, we have Michael Goodenough.
Hey, folks, just let me know if you can hear me.
I can and see you. Thank you. Perfect.
Excellent. Thank you very much. Yeah, my name is Michael Goodenough. I'm a hemp farmer. I'm actually a manufacturer and extraction company here in the state of Connecticut. We were one of the first manufacturing companies and extraction companies in the state. Currently, I make over 800 different products that are hemp derived in the state of Connecticut for over 40 brands. Every single one of those products has a certificate of authenticity that shows that it is below 0.3% in total THC. I came here today to testify on 6700. However, I find myself fearing that we're about to lose our entire industry. Some of the new regulations and the new laws that are being recommended to you would not only shut me down, but the 77 farmers you were speaking of out of the 280 plus that we originally had when we start this effort in 2018 and are now down to 70 plus, which only half of those have put in a harvest report. We are down and we are absolutely at a point where we cannot survive any longer. I came here to ask you to give us the ability to be a part of an industry that, for me, I've been testifying for 10 years, folks. 10 years I've been trying to educate and to provide information to and around a platform of cannabis. And in that 10 years, I've got to be honest with you, we're having the same conversations here today. No matter what law you come up with, you are not going to be able to regulate the illegal products that are coming from out of state. I am licensed by Department of Consumer Protection to make my products. I am licensed by Department of Agriculture to actually grow my hemp-based products. But right now our gas stations are flooded with products that are out of our state's ability to control because they are not regulated or in our state in their manufacturing. They are flooding the market and stealing from the legal cannabis industry and our hemp industry. This is where the laws need to change and impose infractions. If you guys make the changes of stopping all THC in any cannabis product that's derived, you will kill every single one of my brands. All 800 products would have to be completely revamped if those farmers could survive. And every one of those farmers that we just spoke of that went from the 250 plus down to 70 plus, some of those farms are gone. Remember, farms are protected resources in this country, federally protected resources. We are supposed to be a part.
I want to just interrupt you there for a second. Is that I'm trying to follow what you just said, because this is what we were struggling with earlier. You're saying there's a flood of products coming in, being sold at gas stations that obviously are not your products that we should ban, but we shouldn't ban.
Absolutely.
But we shouldn't ban I'm not following what you were just saying. I'm sorry.
Nope.
What should we
I can
ban and what
follow
shouldn't
exactly where you're coming from. Yep.
Yeah.
The products that we're seeing that are coming from out of state right now are the ones that are over 0.3% that are currently advertising
okay.
towards children. We currently can't make labels that advertise towards children. We currently follow the limitations of 0.3%, which means our products don't have the same impacts as a 500 milligram
All right.
Wonka
So
bar or
there's the
whatever
issue.
is on the shelves.
I got you. All right.
Yep.
So what if
Yep.
we said you can still make your products, but the only place you can sell them are licensed dispensaries in Connecticut?
That would change. That would change our outreach. So those small farmers who are making their products, they would have to actually have an ability to get to these larger dispensaries to be on their floor. Right now, these farmers.
Yeah, I understand what you're saying. Just the issue is we're sort of betwixt and between here, because if we continue to allow this demarcation between 0.3 and above and 0.3 and below, legal below, illegal above, all we heard this morning was it's almost impossible to police it. And we hear you saying, if you don't police it, it's cannibalizing my marketplace. But if we go the other way and say, well, then, okay, you can't sell any product containing THC anywhere but a licensed dispensary where we could police it a lot better. You're saying that cuts off your supply. You see what I'm saying? I mean, obviously the status quo isn't working, but help me with the solution here.
So in our current gas stations and stores, we have tons of products that fall into those gas stations and stores, and we're required to regulate them and to protect our consumers with those products. The products that they have sitting on their shelves right now that somehow fall into a hemp-derived product, which they're not, they are starting to poison my business and the true products we're manufacturing that don't have the same effects, right?
I don't know. I'm trying to figure out what the solution is. I understand what the problem
Well, the solution is to police those.
All right, the
solution would be police those.
Yeah, that would be great, but we don't. I guess we can talk about it, but I don't see as a practical matter how we've got. I guess I'm addressing this more to the committee. I don't see as a practical matter how we've got the resources to fan out enforcement force to go out and police every convenience store in the state of Connecticut on a continual basis as to whether or not they're selling the right products. And it's not just right. It's not for an enforcement officer. It's not just a black and white question of product or no product. It's 0.3 or not. And so they can't even figure that out without testing. So to me, I'm reflecting what we heard from DCP, which is there's a real functional issue with enforcement. So my reaction to that is just ban the product from being sold anywhere but a licensed dispensary. So you tell me how that, I mean,
you hold the distributor, right? You hold the distributor accountable. Who brought that product to the supply, to that business? Who's the distributor that is bringing that product from some other state into this state to be sold? We've always controlled the distributors. The distributors were the ones that allowed that product to come into the licensed location. So you can't hold that store owner accountable, just like you can't hold them accountable for the yellow dye number 23 or the orange red dye in the Lucky Charms that are on the bottom shelf. At the end of the day, it's the distributor who's bringing these products to them. And then you have to hold those manufacturers in state who are making illegal products absolutely liable.
Yeah,
for those of us
we get the. I think we get the problem. I get exactly. I think we get exactly what you're saying. We're struggling with the right solution.
Right. By removing THC from our products, you are asking me to strip out a component of what naturally derives in this plant and make it into a product so we can easily or we can police the process better. And that's not the answer. The answer is very simple. Products that are illegally on a shelf, we have to have them removed, just like any other industry, whether it's vape, tobacco, any of those industries. And Lord knows we've made plenty of money in this state from cannabis.
I've got another question for you.
Go ahead, sorry.
I'm not sure it's yet a question for our speaker, Mr. Chair. New to all this still, but we don't permit non-alcoholic beer to be sold in convenience stores, do we? Can we buy an O'Doul's, which has, 0.3%? It's a small amount of alcohol in non-alcoholic beer, but we still don't allow that to be sold outside of
Yeah,
grocery stores,
that's what,
correct?
it's a straight ban. In other words, you can only buy
Right.
those
So
types of
even
products
though
from a
it's
liquor
small
store.
amount, and what's the rationale for not selling non-alcoholic beer? It's super hard to police, right?
Right. Again, to me, that's an easy solution, but what I hear this gentleman saying is if we only said you can only like alcoholic, non-alcoholic beer, you can only buy it at a package store. If we said you can only buy these products from a licensed dispensary, he's saying he can't get it out there. He doesn't have the ability to. Yeah, go ahead, please. Yeah.
Thank you, Mr. Chair. So can you explain a little more about the barriers to your business if you have to sell to a licensed dispensary instead of to gas stations and that sort of thing?
Sure. It would limit our ability to reach an actual market, right? Right now, my farmers sell at their farm stands. Right now, my farmers sell at their at the farm events. Right now, my farmers are able to get into maybe 2 or 3 stores locally. The reality is that we don't have the same pockets. For us, this was Department of Agriculture's most profitable crop. So we replaced parts of our fields with this crop. In getting it to market, for us to then have to turn around and go make a relationship with a dispensary who will hopefully carry our products, which, by the way, CBD is a very small tier of sale to those dispensaries. Those dispensaries are much busier selling the THC molecule, which is the molecule they're licensed to sell. Remember, none of these other molecules out of the 140 in this plant get you high. Only one is licensed for a dispensary. What about the other 139 that are there that are very beneficial to the human body in many capacities, which I would like everyone to be aware of the research symposium that UConn is putting on this year in March 2015, where we have 7 different research studies going on with 7 different universities across the country that during the UConn symposium, they're going to be providing lots of research-based data on things you guys are talking about here today. And that's happening in the March 16th and 17th.
Just as a follow-up question, if I may, Mr. Chair, through you, sir. Is there a differentiation for you, for your business model, between products that would be vaped or smoked, vaped, I guess, versus edibles? Do you have an edible market, or is this strictly a vaping market for you?
Honest to God, vaping market almost doesn't exist because it's very impossible for us to strip the THC out of our vapes, out of our distillates and our oils to make them something consumable. Adding in a bunch of things to dilute it can end up getting people really sick. So overall, in a vape perspective, I don't have much of a vape market. Yes, I have a huge edible market because a lot of people don't want to smoke, but they still want to have the effects of what CBD does, or CBT, or CBM, or CBG, or any of the other molecules, which all have different balances of calming and soothing, et cetera.
So this is a different product than a product might contain Delta 8 or something.
You could still have Delta. So Delta 8 is always going to be found in my hemp as 1/1000th of what the total cannabinoids are in there. So 1/1000th, it's going to be there very, very, very minutely. Generally, when I put it into something as small as a gummy, you're never going to see it because it's so small in the spectrum that the standard labs don't measure down to that billionth. And so it will exist. It's very small in my hemp products. So won't THC. But again, below 0.3%, that won't have the impact that a gummy that's going to get you intensely high would.
So by way of education, and through you, Mr. Chair, by way of education, we learned from a prior speaker, I don't know if you heard his testimony or not, but his testimony was that Delta 8 is produced through a chemistry process in a lab somewhere, and it's not a naturally occurring product. Was that a little too simplistic?
It was. So it does exist to 1/1000th. What that means that I have to grow 1,000 pounds to make a tiny amount of it. It is much easier for the synthetic drug world to convert my molecule into a synthetic. And there's acetones in your hearing about all of these new molecules. They all have some chemical property into THC, Delta 9, Delta 8, Delta 7, and then even Delta 6, which is what we call Epidiolex, and that's the pharmaceutical drug, right?
Thank you very much for clarifying that. I appreciate it. And thank you, Mr. Chair.
Thank you, Representative. Other questions? All right, thank you. That was a helpful discussion. Appreciate it.
Thank you very much. So I guess I would just like to finish up. Our hemp farmers, you guys,
I think you are done. Thank you, though. We're just gonna keep things moving along. Thank you. Appreciate your time.
Thanks.
Next, also online is Caitlin Comment.
Hello, can you hear me okay?
Yes, and see you. Thank you.
Great. Hello, Senator Romney, Representative D'Agostino, and esteemed members of the General Law Committee. My name is Caitlin Kama, and I'm a program coordinator at the Hub. We are the Regional Behavioral Health Action Organization for Southwestern Connecticut, a division of RISAP, and I am here in my capacity today as a member of the Connecticut Prevention Network to support HB 5434. Cannabis is one of the most widely used substances in youth and young adults, especially those under the age of 18. In 2021, the age group most likely to use cannabis in our state were young adults 18 to 25. The use of cannabis, including vaping, can have detrimental effects on physical and emotional development, including impaired driving, worsening of serious mental health conditions and symptoms, psychosis, development of a substance use disorder, suicide attempts, and for mothers who use during pregnancy, birth defects. In our state, hospital admissions and poison control calls for cannabis intoxication has increased. This includes children consuming edibles that look like candy. I will address some parts of the bill today that can make significant impacts in lowering these potential consequences. Today's cannabis is unlike decades ago and contains higher and more addictive levels of tetrahydrocannabinol, THC, the psychoactive component of cannabis. And our current law exempts pre-filled vape cartridges from THC caps. Many of these concentrates exceed the current THC cap limit, as some have even tested to have over 90% THC. In our state, we are seeing statewide, regionally, locally, cannabis and vape use is rising. Additionally, cannabis edibles contain high THC per serving in one product, and some products can have up to 6 servings. And essentially, we need to regulate these potency caps to all THC products, including vape and edible products, and to close those THC loopholes in our current cannabis law. The perception of harm for cannabis use has decreased. This means that too many people, especially young people, believe that it is relatively or completely safe to frequently use cannabis. Enticing advertisements which promote sales of potent THC products are highly visible in many neighborhoods, including your local convenience stores or gas stations, despite this being illegal. There is low awareness and missed opportunities of education of cannabis use, and we need obvious and appropriate health warning labels. Stronger consequences for out-of-compliance cannabis retailers is needed in order for this to be effective in its purpose. We are also aware that many unlicensed stores are selling illegal, high THC products even to underage youth. These retailers should be heavily fined for such and continue to be monitored. Prevention dollars through cannabis sales tax revenue will not start for at least another year, with the potential waiting longer. Currently, local prevention councils have no allocated dollars in the near future for cannabis prevention. By passing this bill, we can position ourselves to become more proactive and will be a huge step in the right direction of prevention. So thank you. Thank you for your attention to this matter. Please refer to my written testimony for further information and data points, and I'm available for any questions. Thank you.
Thank you. Thank you for your testimony. Representative Vertigliano.
Thank you. And thank you for your testimony. Do you have any stats on the amount of available beds or how many beds are being used right now for inpatient treatment for anybody with cannabis use disorder?
We do have some statistics for DEMIS treatment admissions for the past year, 2021 and 2022. And we did see, I can't say for certain the exact number, but we are seeing that there are many individuals that are being admitted for treatment, and even many stating that cannabis is their primary substance use. I'm happy to forward those numbers to you.
I just didn't know if you had a percentage or an increase or decrease or whatever year over year.
An increase, yes, an increase in especially young adults, and I'll be happy to forward those specific numbers to
We
you.
love that information. And how about poison control? Do they keep stats on how many people have called year over year? Do you have any? I mean, I know I'm probably asking you a lot, but I thought maybe you could have them handy.
We do have the statistics, actually. I don't have them right on hand, but I will forward that with you. And we did see a significant increase. It's pretty scary numbers. What our state poison control center we're seeing in calls related to cannabis for all across the age span, but specifically for children ingesting edibles, those numbers increase, and they are seeing the highest numbers that they've seen in years.
So if somebody was to go to the emergency room, you know, because they poisoned themselves or ingested too much, would that statistic go to poison control, or would the emergency rooms have a separate sort of accounting system or statistic that they use? Do you know?
Yes, it's actually a good question because the hub, we're currently in our priority report process and we are gathering these numbers, and looking for those numbers related to cannabis has been very difficult in the past year. There's some data systems that don't even account for cannabis, so they're trying to catch up to this. So there are many different systems that report differently, and many gaps in these systems. So it's a hard question to answer, as we're even in the process of trying to answer this for ourselves. But I'm happy to consult with our stakeholders and experts who will be able to better answer that question.
Okay, thank you for your time. Thank you, Mr. Chairman.
Thank you, Representative. Thank you. Other questions from committee members? Thank you very much.
Thank you.
Up next in person, we have Emily Sabo.
Before you go out, Emily, just for the committee members, just I know we've heard some testimony today about the standards for when someone can get pulled over. That really is Judiciary Committee. So whether that happens or not, it won't be through this committee. I don't want our bills to get referred to Judiciary. All due respect to those chairs and getting bogged down there. And then Senator Kissel's got a shot at it again. And he's a crafty legislator. He boxes bills, does all this funky stuff. So while I appreciate that's part of the proposal here, it really would have to go through Judiciary. So just want everybody to be aware of that. Thank you. Thank you. Go ahead, Emily.
As the only workforce development and training curriculum specifically designed for cannabis workers of its kind, and we continue to fight to ensure that wherever cannabis is legalized, worker equity is a part of the conversation. Back in 2021, SB 1201 legalizing and regulating the adult use of recreational cannabis. This bill includes equity standards and worker protections to ensure that the jobs created in this new industry were family-sustaining jobs, and those most adversely impacted by the war on drugs have the opportunity to benefit from this industry. An integral component of ensuring social equity is worker equity, which is why the law requires each cannabis establishment licensed to enter into a labor peace agreement with a bona fide labor organization. Currently, Section 21A-421T of the General Statutes defines a bona fide labor organization as someone who, and I'll paraphrase here at the same time, represents employees in the state of Connecticut, has officers elected by secret ballot, is free from employer domination or interference, and is actively seeking to represent cannabis workers in the state. So I'm here today to present some of the concerns we have about how this part of the law enforced by the Department of Consumer Protection, and we're thankful for the opportunity to address these concerns in HB 6699. So the UFCW became aware of multiple license applicants that have signed labor peace agreements with unions that do not meet the definition of a bona fide labor organization. In at least 2 cases, applicants signed agreements with unions that do not represent workers in the state of Connecticut. The UFCW has dealt with this issue in other states and was successful in communicating the same to the regulatory bodies and resolved the issue. However, in Connecticut, on many occasions, I have personally contacted the DCP and the Social Equity Council to discuss this issue. The UFCW testified about these issues during Social Equity Council meetings. UFCW leadership sent written communication and DCP in at least January, June, September, and December of 2022 in an effort to resolve these issues prior to the rollout of adult use sales in January of this year. We booked meetings to discuss with DCP to discuss our concerns, only to hear that DCP didn't have a solution and they would get back to us when the workforce was more developed. Instead, license applicants were approved and adult use sales began.
even though these operators signed labor peace agreements with labor unions that violate the statute. So section 13 of HB 6699 attempts to provide further guidance to regulators and moves enforcement of that provision from DCP to the Department of Labor. It requires the DOL to determine if a labor union is a legitimate party to a labor peace agreement by developing a list of those actively seeking to represent cannabis workers in the state. So in my written testimony, I've included the proposed legislation for a further definition of a bona fide labor union. However, unfortunately, since adult use of recreational cannabis is not legal at the federal level, the Connecticut Department of Labor fears that providing the oversight could potentially jeopardize funding that it receives from the U.S. Department of Labor. On the other hand, the DCP has suggested that they don't have the experience with labor matters and therefore are not the appropriate agency to determine whether a union complies with the definition of a bona fide labor organization. We don't see this as a compelling reason to not enforce the statute as written, and we are left with two agencies unwilling to enforce the law. Without a regulatory body to enforce this statute, the workers are the ones caught in the middle, and the intent of the law is lost. Workers in this industry are already missing their opportunity to form a union and establish a career. We are asking that this committee provide DCP with the clarity and the funds it needs to enforce the statute and redefine a bona fide labor union. Thank you for the opportunity to testify here today, and thank you to the committee for working to address this issue. I'm happy to go into further detail regarding this, and I'm available to answer any questions you might have. Thank you.
Thank you. Questions, Senator?
Hi, Emily. Thank you for coming up today to testify before us. You may not have the answer to this question now, and so feel free to get back to us with the answer. You mentioned that your organization had assisted with writing the legislation in other states. I was just wondering if you could let us know if this definition of a bona fide labor organization has been utilized in other states.
Yeah,
and if you
absolutely.
could get back to us on that.
So we modeled the language after New Jersey's, but later on in the day, Alexander Claiborne from our international union will be testifying, and he can provide more insight about other states and those details for you.
Great.
Yeah,
Thank you very much, Emily.
thank you.
Questions from committee members? Thank you. Thank you. Appreciate it.
Our next speaker in person is going to be Christine Ritigliano.
Good afternoon, Chairman Maroney, D'Agostino, ranking members Chicarella and Ritigliano, and distinguished members of the General Law Committee. My name is Christine Ritigliano, and I am here in support of an act, the Bill 5434, an act concerning the regulation of cannabis. I would first like to say that I have never testified before and never been so compelled to testify for anything before. This bill is deeply personal to me, and I'm compelled to share my story because I feel as though it would help with making this bill become an act. My story isn't anything that I could have dreamed that would become of my family as a result of cannabis. I'm like you guys. I work, my husband works, we have 2 kids, we live in the state, we have sports, we have school, we dropped our son off at college, and I am the mom stricken by substance abuse in our family. My husband and I dropped off our handsome, intelligent, bright son at UMass in the fall of 2019. And in March of 2020, when everyone was shutting down to combat COVID-19, Michael came home from school. It was at that time that my 6-foot son, who weighed 110 pounds at the time, came home from college. He was someone that we didn't know and didn't recognize. As any parent would do, we chased everything that could be affecting Michael and Michael's body. We had no idea what was causing the problems with his stomach, why he couldn't eat, why he was unable to function. We took him to every single specialist in this state that we could. We went to every hospital. We went to the best of the best. We reached out to other cities, other states, anything that we could do to help him. After a litany of tests and unimaginable things that we had to have done in order to rule out everything else for Michael. After 13 trips to the emergency room, it was determined that Michael had something called cannabinoid hyperemesis syndrome, something none of us had ever heard of before, and something that I haven't heard addressed today when the health concerns came up. I would like to let you know a little bit about CHS and how destructive it can be, not only to the person, but to their family. Emergency rooms, gastroenterology doctors all over the state have been seeing the syndrome, and the damage that it has done. How do you get the syndrome? Well, chronic habitual cannabis use over a prolonged time. What does it look like? It is violent. It is unimaginably painful vomiting. That vomiting can only be stopped by IV sedation, hydration, or ingesting more cannabis. My son had never so much as had a stitch or a broken bone in his entire body. And at 19, he had 13 emergency room visits under his belt just due to CHS. Cannabinoid hyperemesis syndrome almost ended my son's life on multiple occasions. I cannot express the fear and the terror of watching my son turn blue after violently seizing from overdosing on cannabis and becoming unresponsive in mid-state's emergency room. If it were not for the expertise of those emergency room doctors and their staff, I would not have my son here today. He would be gone. And it would be because of cannabis. Just as proud as I was to tell people my son was headed to college on a master's track with scholarships in tow, I am equally as proud to tell you all that my son Michael today is sober. Michael will battle demons of addiction every day of his life. But had he not gone through substance abuse rehab, which continued as intensive outpatient settings, ultimately concluding with lifelong counseling, medication management. If that hadn't happened, Michael would be gone because of cannabis. Without the responsible parameters being proposed in the act before you, the risk and likelihood of other families living the nightmare that we have is great. Why would we purposely put families in harm's way? The suggestions for action in this proposal make common sense, and it is not too much to ask for. As your neighbor, a resident of our state, a parent to two beautiful children, I implore you to look at this bill as a responsibility that you all have to keep people safe. So please do the right thing and pass this legislation so that unregulated cannabis and cannabis abuse becomes something that we can manage. Our lives and the lives of our children depend on our actions to keep people safe. Thank you.
Thank you. Well done. Dave? Senator.
Thank you very much, Chairman D'Agostino. Well, Ms. Rutigliano, we have a lot of fun on this committee and sometimes take light of issues, but occasionally the heart-wrenching testimony that you just provided regarding your son brings us all down to earth. It may not affect lots of people the way it affected your son, but it affects some. And so we are dealing with a drug, albeit very common, but it's going to have a very deleterious and negative impact on some individuals. Just like, I mean, I love peanuts, right? But we have to be cautious because some people have really negative physical reactions to that. And so what we're dealing with is, and we've said it all throughout the day, is the horse is out of the barn. The reality is it's out there and it has a potential lethal impact on some people. That's why the notions of labeling, I think, are well taken. I got to be honest, I thought it might be an overreach with Poison Control Center, but it's been a while since my two little guys have grown. Now they're 27 and 19, but back when they were, 1 year old and 9 years old, if something happened accidentally because I had a candy or something that looked like a candy that was really marijuana, and they took it, I would be panicking. So it would either be 911 or what do I have to do immediately if someone's turning blue, as you had indicated, you saw your son? I'm glad he's doing better now. An addiction is something that is a day-to-day thing, and I'm sure he will be successful. I feel that. Whether all of the things in the bill that's proposed before us will get passed, I don't know. But certainly I think that there's some very reasonable, legitimate steps that we can take, seeing how this is unfolding. And I just want to thank you, whether it's on this committee, the Judiciary Committee, or any other committee I've served on, having real people bare their souls and do something that's really scary. And you said, despite the fact that you've got a wonderful brother-in-law here with Representative Retigliano, who fights the good fight day in and day out, this is your first time in this building. And as someone who's been here a long time, when I testify with my constituents, I still get nervous as well. So I know how difficult this is. And when you're bearing your soul, it's twice, 100 times more. So thank you. Your testimony makes a huge difference. And I don't really have a huge question. I just want you to know your time here and your patience, it makes a big, big difference. And it has nothing to do with who you're related to or anything like that. That probably was something that caused you to think twice, but you know, what your son and what your family has gone through, we're going to try to turn that lemon into a little bit of lemonade and learn from it. So thank you. I just wanted to say that, Mr. Chair.
Well, I'll try, but I think the point we're trying to make is Michael was under 21. He wasn't legal to consume marijuana. We don't know how he got it. I think over time, you know, it's become sort of like we're normalizing it and the kids think it's okay. So they start it and they can't handle it, or they have it in doses that are just so high that they can't really grip with it. It's just not for them. I think that's our point. There's some of us who weren't crazy about the retail market, who maybe didn't oppose decriminalizing or legalizing. Quite frankly, where some of us are more libertarian. What the hell you want to do in your own house is your business. But whether or not it should be on a street corner and a billboard, it is probably not good for the general public. And these things always seem to get younger. So the younger kids see it in the older people, and they start using it. So, you know, I could ask 100 questions. I don't know if I could make it through them all, to be honest with you. But so I'll leave it at that. The only thing maybe I don't know that you and I maybe haven't talked about is, I know he was in Massachusetts at the time, but was any of that started with the synthetic stuff? Was that part of the picture?
There were a multitude of ways that he ingested. And once it passed the point of becoming something that he could control, wherever he could get anything, he would.
Okay. All right. I'll leave it at that, Mr. Chair. Thank you so much, Chris, for coming by. So we're glad to have you here. Thank you.
Yeah, no, look, I think that exchange that you just said is probably one of the more important ones we'll have, because it's, and again, putting aside the merits of the pros and cons and the debate, that, you know, Michael was exposed to an illegal marketplace, right? And now, would he have done that? Would he have been exposed to that, whether, you know, cannabis was legal or illegal in Massachusetts? Probably so.
Right.
So then what the question then for us is, can we help with that sort of educational piece through our legal marketplace? In other words, okay, if you're going to have it be legal, you buttress that marketplace with the warning labels, the education money devoted to education. And so you flood the marketplace as much as you can with an educational component, very much as we've seen with, frankly, the turn that you've seen with the cigarette industry over the last few decades. We can accelerate that process here. So I think that exchange that you just had with your brother-in-law is really helpful for us, because it helps sort of frame the regulatory structure that we're in charge of here, and how we steer that discussion and those requirements to having a responsible adult use marketplace, but then actually try to recognize some of the, I don't want to say benefits, but we can leverage that marketplace to do more to prevent exactly the sort of thing that happened to your son. So really, we really appreciate your taking the time and sharing that story with us, because it's very helpful to really put in context and frame the things that we're going to try to do from a regulatory perspective. So thank you very much. Other questions or comments? Yes, Representative Osborne.
Thank you, Mr. Chair. And I wanted to thank you so much for your testimony today. I'm new to the legislature, but I'm not new to sitting on commissions or boards. And I've worked for a long time in child protection. I've heard a lot of testimony and dealt with a lot of people with issues of substance abuse affecting their family. And I have to tell you, that's probably the most impactful testimony I've ever heard. So I know that was so difficult, and thank you so much for illuminating that for us. And you said one word in answering Representative Tigliano's question, and that was ingest. Is this a syndrome that affects only people who ingest cannabis?
So the syndrome is any way that the THC is in their system to a level that they cannot stop.
Okay.
So it's prolonged, it's habitual, it comes with triggers, it comes with, I mean, to watch someone go through an episode is just
I can't begin to imagine.
Incredibly, it is unbelievable to see and know that you cannot stop that without going to.
But
get
somebody
help.
who only inhales cannabis could also experience the
Yes.
syndrome? Okay, thank you very
Absolutely.
much for that clarification. I really
welcome.
appreciate it. And again, thank you so much. What
Thank you.
you've said and done here has been so important for other people. And thank you for taking the time and having the courage to come and speak to us today. I'm
Thank you.
grateful. Thank you.
Thank you very much.
Thank you, Representative.
Yeah.
Representative Pizzuto.
Just a quick comment, Mr. Chairman. Thank you. Incredibly impactful testimony, and just want to say that his son has a great mom. Thank you.
Thank you.
Yeah.
And uncle.
Thank you.
The uncle's a little questionable.
Yeah, so we can attest. Thank you. Thank you very much for your testimony. Appreciate it. Thank you. Thank you, Holly. MJ.
Thank you, Mr. Chairman. Up next, we have Ashley Austin.
Hello, my name is Ashley Austin. I'm from North Stonington. I have a little farm called Austin Acres. I'm here to speak on House Bill 6700. I'm a farmer and I had high hopes for my hemp crop. As you know, it's an amazing plant. I use it myself to use CBD to treat my epilepsy. As a budding hemp farmer, I went to the state-sponsored seminars, participated in webinars, classes, and more education on the cannabis and cannabis industry that was provided by the state. I have learned a tremendous amount about this plant in the past 3 years and started honing my skills as a cultivator. Unfortunately, my farming has not been profitable enough to pay back the money I put forth towards classes, materials, manufacturing fees, not to mention the required licensing fees and plant testing fees. Then there are the taxes I pay on the CBD products that I have made that I sell. So all in all, it hasn't been overly profitable thing for me. My hope is that with the 6700 bill passing, allowing farmers like myself to convert my hemp producer license into a cannabis micro cultivator's license, would be a huge step in aiding me in advancing hemp participants to make some money in this field. We've put a lot out into it and we're looking to try to make a little bit something back. This bill does come with concerns for me. It states that you have to be licensed to hemp, to have your hemp license for 2 years consecutively since January 2021. And considering how young the hemp program is, that's difficult for a lot of people. I myself only had my hemp license from April. I started applying for it in March of 2020. But through the pandemic, it wasn't easy for people to get paperwork passed through the state or anywhere. I was currently then working inside of the hospital, which I still do. While I do feel CBD is a worthwhile crop, the profit margin is not there for small farmers like myself, and the cost of a micro cultivator's license is unattainable for me. Connecticut seems to give a lot of lip service to wanting to help their farmers and support local business, but here's a chance for you to truly do both of those things. Connecticut needs to work on keeping the emphasis on local grown products, and what better way than to allow their farmers to thrive. These gas station products are really hurting farmers like myself and creating a lot of confusion. We have great ground here in Connecticut, and we're able to produce a craft product that I think will be sought after. Please allow farmers and manufacturers who have worked in building this industry and have supported the state's initiative to have a seat at the table. Thank you.
Thank you. Questions, committee members? Good. Thank you. Appreciate your testimony.
Our next testifier is going to be Brian Murray.
Good afternoon, Chairman DeAgostino, Ranking Member Cicerella, and in absentia, Ranking Member Rutigliano, as well as Chairman Maroney, and esteemed members of the committee. Thank you for taking time to listen to and thoughtfully consider several cannabis issues today. You guys certainly got a mouthful. There's a lot of cannabis issues, so thank you for your time. My name is Brian Murray. I'm the Executive Vice President of Government Relations at Acreage Holdings. We have 2 hybrid dispensaries and a dispensary, and entered into a joint venture with Keebler Smith Bolden. I'm here to respectfully express our opposition to HB 6700, an act concerning hemp licenses and the adult use cannabis market. Under RERACA, distinct licenses are required to grow, manufacture, or sell cannabis in Connecticut's adult use market. These license types are awarded with priority to social equity applicants as part of Connecticut's effort to redress the disproportionate harm caused to communities of color by the war on drugs and criminalization of cannabis. The first adult use licenses were cultivator licenses for facilities located in disproportionately impacted areas. To award these licenses, the statute directed the Department of Consumer Protection to, and I quote, open a 3-month application period for cultivators during which a social equity applicant may apply to the DCP for a provisional cultivator license and final license for a cultivation facility located in a disproportionately impacted area without participating in the lottery or request for proposals. Hemp farmers enjoyed the same opportunity to apply for a cultivation license as everyone else. Carving out a shortcut for hemp farmers to acquire a cultivation license creates a special application class foreign to the social equity spirit of RERACA. Additionally, allowing hemp farmers to acquire micro and cultivation licenses outside the lottery negates the applications of more than 37,000 applicants across all license groups, including 42 cultivators and 8,469 cultivators. It especially devalues the 16 cultivator licenses already awarded. Providing hemp farmers a competitive advantage via a leapfrog into the market before current licenses are fully operational poses the possibility of irreparable harm. In closing, this bill offers little justification as to why this change is necessary. It communicates no deficiencies or problems with the current system that it solves. It communicates no restitution for current operators it would harm. It does not communicate what prevents hemp farmers from applying like everyone else, and establishes a dangerous precedent at the start of Connecticut's adult use program. The 5 pathways outlined by DCP for avoiding the lottery are sufficient, and we ask this committee to protect the integrity of the process and vote no on the proposed bill. I'm happy to take any questions this committee might have on this or other cannabis-related issues.
Thank you. Questions from committee members? Senator.
Thank you very much, Chairman D'Agostino. Thank you, sir, for coming and testifying and being patient with us throughout the day. So I'm not really sure the name of your enterprise sort of, is it,
Yeah,
I'm not sure what it is. So like, you have an officer's rank, and what's the background of your business?
Yeah, great. Thanks so much. So we operate as the botanist. We're currently in the medical market, and we've served the medical patients of Connecticut for several years now. So we're in Danbury, we're in Montville, and South Windsor.
Okay, so up in near my neck of the woods. My mom lives in South Windsor, so that's cool. And you heard testimony today from folks that are hemp farmers. And my concern regarding them is I do think that anybody who's involved in farming, it's a brutal business. So much is dependent on the weather and other factors, even if, I mean, there's overhead costs if you're all indoors. So it's a tough business. And I don't want them to get caught in the crossfire. I see that there's a problem with this other commodities being sold in mini marts and things like that. But I also, at the same time, very much recognize that you folks or folks that you speak of have put a lot of money on the table to play by the rules as the rules were set out. And for us to go and change the rules of the game halfway through, while perhaps being well-meaning and trying to take care of a group of individuals that may not have had the best financial luck thus far, I think would be inappropriate. That's just me. I can't speak for anybody else on the committee, but I think that once you sort of set up a construct, that you have to sort of let it play out, because people, there's bankers, there's going to be some money people way behind all of this that are going to say, well, I extended this based on XYZ, and now if everything changes, the terms of my exposure have changed dramatically as well. So you probably have a lot more expertise in this than I can even dream up. How hard is it to get financing? And you guys are in the medical side of it, but I'm guessing even there, the legalization might have an impact on what you've already been up and running. So just sort of give me a little nutshell version of what's it like out there as far as bankers and the fact that this isn't really allowed by federal law, and Connecticut may not be the first state, but it's still, my understanding is like even transactions, you can't use normal banks. Just explain that.
Yeah, thank you, first of all, for the question. There's a misnomer that cannabis is this, billion-dollar industry, and anyone that gets into it is making a whole lot of money. That couldn't be further from the truth. It's very difficult to actually make a net profit in cannabis. And when you speak of banking, for many operators, the safe banking at the federal level was going to be a lifeline. What we have seen recently are some of the largest operators have decided to leave markets. Curaleaf made an announcement. Columbia Care made an announcement. Air Wellness made an announcement. Even the company that has the largest real estate footprint in cannabis so far as leasing properties has announced several of its clients are not able to make payments. And part of that is because there's not a lot of capital in the cannabis market. Part of it is that it's federally illegal. Part of it is because it started with a lot of speculators who just kind of put a lot of money into the industry, and they're realizing that it's not what they thought it was going to be, because there isn't federal legalization, and it's going to take much longer for cannabis to get a foothold as a bona fide industry, regulated industry in the nation. So it's very difficult to get banking. It's very difficult to get insurance. It's just a hard market. And so for those, as you mentioned, who've already invested in cannabis and played by the rules as they were set up, to then have the rules completely shift under our feet creates not solid ground, but quicksand. And you're going to see just people go under. It's not viable. As somebody else testified, just the supply in the marketplace. We really do have to have an opportunity for the law as it was written to play out, and then to look at that and say, all right, well, is demand outpacing supply? Well, in that case, then yes, let's go ahead and increase supply. But I'm sorry for the state that farmers find themselves in, and it's across the nation, whether it's hemp or some other agricultural, crop. But the fact of the matter is that this bill was written a certain way. We all knew how it was written. And now to come and change it for one special population at the behest of all the other individuals who sought to participate seems unfair.
And I very much appreciate that answer because my instinct is to be very sympathetic to the hemp growers. But likewise, I'm very sympathetic to our vineyard owners here in Connecticut. And yet there was a previous proposal a couple of weeks ago, and the proposed remedy I don't agree with. And so I sort of feel for the co-chairs and ranking members on this committee, because I don't want to see us throw out the baby with the bathwater. I don't want to see the legitimate hemp growers and whoever out there to get caught in this crossfire because there's some microscopic element of THC in what they're trying to cultivate. At the same time, I am completely on board with what you're saying, is that not only have you been in this business for a long time, but there's huge amounts of financial backing and signatures and, and all of that tied into this. And we as a state have a reputation, whether it's when we do our bonds on Wall Street and what our reputation is there, and also when we set up a very complicated construct. And you started off with pointing out that the ultimate goal here is to be responsible for the equitable ends that have been designed into the system as well, right? For those particularly impacted communities by the war on drugs need to get some of this. But if the players that have invested get wiped out along the way, we're not going to see the end result as we envisioned it. And I'm not sure exactly. I mean, I live up near the Mass border. That's my district, North Central Connecticut. And I'm aware, and I don't know, I just heard it on the radio not that long ago, but there was all this hullabaloo about a dispensary opening up in this town or city of Northampton, Massachusetts, about a half hour north of where I live. Very nice college town, Smith University and the other universities nearby. But they opened with a great fanfare, and now I think they closed. And I'm just wondering, because a college kind of town, you figure that would be where it would be a good venue. And I don't know if it was financially driven or something else. And part of what we're going to see here is what we see when a brand new restaurant opens up in a town, right? There's all this initial fanfare and excitement and lines. But then, when the novelty wears off, it sort of peters out. And the ones that are really, firmly footed and financially sound will survive. But it's like anything else, what's hot today may not be so hot tomorrow. What might be cool today may not be cool tomorrow. And, even with our young people, nicely so, you see that there's less interest in like smoking cigarettes. And so something that might have been so commonplace not that long ago may go out of vogue. And, and also we're talking about, legalizing this for adults, but at the same time, we are telling our young people, stay away from drugs. You don't really need mind-altering substances. And what we saw with Ms. Ritigliano and her poor son getting addicted to marijuana, and what you see far more often with fentanyl and alcohol and tobacco for that matter, is we don't want people, especially our children, getting hooked on things that have an addictive quality, right? So essentially, we as the state of Connecticut are singing two songs. Yes, this is legal for adults, and we want to have, but we need to have warnings. And gee, kids, don't go down that path. So we're cutting out future purchasers, and I think that's the right message. So you're entering into a field that might ultimately run aground no matter what. So I just want you to, I appreciate the testimony, and it's something we really hadn't heard here today thus far, but it's a complicated business construct that we're dealing with as well.
Yeah.
So, but huge emotional issues, but there's huge complicated financial issues as well.
Yeah,
Thank you
so
very much.
If
Mr.
I
Chair.
could mention one other point to what you had mentioned, unlike other industries, the cannabis industry is subject to what's called the 280E tax at the federal level. And it's a tax only on cannabis businesses, which means that we can't deduct normal and necessary business expenses. There's more than 15 deductions we cannot take. So, to the point about viability of the industry, I think HB 6700 would make it that much more difficult because we pay about $2 billion in taxes that no one else has to pay federally each year, just because we're in cannabis. So.
Wow, thank you. I didn't realize that either. Thank you, Mr. Chair.
I think Approach actually has a bill to at least affect a state deduction for them with respect to their equipment. Representative Pizzuto?
Mr. Chairman, thank you. No, Mr. Murray, just wanted to, you touched on 280. I heard something about that in finance yesterday in testimony. And so you're right there. Thank you. Yep. Appreciate it.
Yeah, my mistake. Finance. Thank you, Representative Pizzuto, for correcting me. Other questions or comments? Thank you. Thank you very much.
Thank you very much.
MJ?
Thank you, Mr. Chairman. Up next, we have Paul Travalingo. Oh.
Close enough.
I think we're on, right? Okay. I may rely on my glasses. It's been a long day. I just want to first thank co-chairs Maroney and D'Agostino, ranking members Ciccarella and Rotiliano, and the distinguished members of the General Law Committee for the opportunity to address these raised bills. I appreciate, as a taxpayer, as a cannabis consumer, and as the founder of a provisionally licensed food and beverage manufacturer business, that the General Law Committee is fully engaged, has a fully engaged willingness to refine our state framework. I think you all acknowledge that there are tweaks that have to be made along the way. There will come a time when cannabis is federally descheduled and our nascent industry will need support. We value the ability to have input like this. Connecticut has many nicknames, but the one I like the best is the land of steady habits. I think we have a well thought out framework, not without its detractions, but to see you still at it, I very much appreciate it. I'd like to address 5434, but I'm going to do that second because it seems like an existential threat to my license. But first, I do want to talk about 6700 briefly. Brian had mentioned 280E. There's a point I want to make about 280E that you may not know about. If you're not a C corporation, then you were just a partnership or a sole proprietor. Obviously, your tax liability flows through to you personally. With 280E, there are companies, because of the lack of deductions, that can have a greater tax burden, a greater payable tax on the federal level than they have made in profit. You can be upside down. And that's, I think, the thing that lights everybody's hair on fire about 280E. The Safe Banking Act federally, which didn't pass, it didn't pass because there were other social equity provisions that needed to come to bear in that debate, and it just never got there. But the Safe Banking Act isn't just about Bank of America and Wells Fargo being able to do loans. It's about people breaking into dispensaries because they believe cash is there. And it's about the ability to be taxed like a normal business. So I just wanted to kind of mention that. The other thing I'll say about 6700, there are 16, well, there are more than that. There are about 26 DIA cultivators in the pipeline. Only 11 have paid their $3 million. I know some of the ones who have not. I appreciate the idea of bringing the hemp growers in. I would ask that you look to create some parity if you do. You have a fee structure for the DIE cultivators that's $3 million with no way to cut that in half with equity joint ventures. But there are other licenses, the converted license from the medical marijuana market, that did have the ability to cut their license in half to get EJVs. And by the way, those EJVs are really great business opportunities that, and for the most part, they're going to be retailers. I happen to think personally that the microcultivator license is really the best one. And it currently allows you to step up to be a cultivator eventually. I think a lot of people were surprised there were that many DIA cultivator licenses that were sought. And that it would be great if we had a state that had lots of microcultivators. There's probably a way to make that happen. Some of the horses have left the barn, I get that. But you have a number of individuals or companies that have gone down the DIA path. Funding for cannabis is down this year over last year by 92%. That's partially because of the financial ecosystem that we're dealing with, but it also has to do with the fact that a lot of companies are not making money in cannabis. And so I would just ask you to create some parity there. The last thing I would ask for is potentially charging DCP with the requirement to do a canopy assessment every year. At this point, you could go to all the growers that are in the pipeline and say, how many square feet do you think you're going to have? And obviously an indoor grower can do 2 tiers. Some can even do 3. I wouldn't put a person up that high personally, but it can be done. And a greenhouse grower is only going to do 1 tier. But if you do an assessment on what the canopy, the anticipated canopy, you can then at least have some data where you can step to new licenses in the future. Right now, we would be essentially flying a little bit blind. So that's all I have. And I don't know if anybody has any
You
questions.
had mentioned the microcultivators.
Yeah.
Like you, I was probably the license I was most excited about. I really sort of viewed it because we've seen the incredible growth in like the craft beer industry, and it's not a 1-for-1 analogy. I get that,
No,
but I'm curious if you have any thoughts on how to encourage more micro cultivators.
Well, I will bet you that if you went to the DIA cultivators that have not put their $3 million in and allowed them a path to become a micro, they would take it. And I'd hate to see them die on the vine. I can see how some people who paid their $3 million within the expected 5 days, which is, I think, what, I don't know if it's the statute, even said that, but, or maybe it was the regs, might not be comfortable with that because they put their $3 million up. I think if you were to reduce the fee for them, I think you could allow the DIA cultivators who paid their $3 million to have a tax credit in future years, just create parity among those licenses. And let's collectively, I will tell you that in all the meetings I've gone to with all the other licensees and even people who didn't get licenses and are still coming to these events are looking to watch out for each other. We're trying to collectively do this the right way. And I think all you have to do is ask, and you'll probably get some pretty straightforward answers about really what each company desires to do and where they think they fit here. But the micro cultivator license is great, and it allows you to have a direct relationship with the consumer.
Exactly. Yeah.
And I think, you know, if you go back, there are people here I know would go even further. They were looking for full decriminalization. Although we can't have that, meaning anybody can grow and sell. The ethos behind that sentiment is to know who your grower is. I suppose in the illicit market, you'd want to know who your seller was, right? And where that stuff was grown. And so that being said, I think having a relationship with the company for the medicine that you seek, for the plant that means so much to you is a good thing. Yeah.
That's exactly what we were thinking about in terms of, I know for some of the medical patients, particular strains that the larger producers may abandon, not produce anymore. A microcultivator could really step into that marketplace and for niche products. But
yeah, and you've created a framework that allows a grower to not exercise the other parameters of their license. Not everybody has to do product manufacturing. Not everybody has to do food and beverage. Clearly, I'm out asking growers to let me do their food and beverage for them. Why wouldn't I? But I think it's a license that allows somebody to kind of work their way into the market and test what makes sense. Somebody mentioned earlier, there were a lot of, in the early days in other states, people put a lot of money up, you know, it was gold rush, it was fever dreams. And there have been some precipitous exits in some states because of that.
Questions from committee members? Thank you. Thank you very much.
All right. Can I address 5434 briefly?
We got to keep things moving though.
All
We
right.
got your written testimony.
Okay.
Thank you.
All
Appreciate
right.
it.
Thank you.
Up next, we have Brant Smith.
Good afternoon, members of the General Law Committee. My name is Brant Smith, and I am a hemp farmer with a greenhouse operation located in Cheshire, Connecticut. I am testifying in favor of potential bill 6700. Currently, the state has 4 medical marijuana growers being the sole producers of recreational product for the marijuana market. This has caused Connecticut to have the highest marijuana prices in the country due to an extreme shortage of product. problem that will persist through 2024 unless changes are made. We hemp farmers would be a partial solution to the state's problem and would advance the rollout of the recreational marijuana program if we can convert our hemp licenses. Hemp farmers are part of the fabric of the Connecticut community and have been growing cannabis for 4 years. Not only would more product be available to the market, but that product would be a craft product of small, high-end batches produced sustainably. We use the sun in our production instead of what indoor growers do, easing the strain on our environment. As you know, the cost of energy is extremely high, and the 4 medical marijuana producers currently are the 3rd largest users of power in the state. With respect to the proposed bill, I would urge the committee to revise it in 2 notable areas: the timing of applying and receiving a license and the cost of the license itself. In respect to timing, I believe hemp farmers should be able to submit an application for a probational license on July 1st instead of October 1st. This would speed up the introduction of a craft market and help out with the current shortage. I also believe we should keep our hemp licenses until we receive a final license. It will take several months to move from a provisional licensee to the final license, and I will need to put 23 employees on unemployment if the bill stands as written in this area. Finally, I believe the price of the licenses has been set at a point where few, if any, licenses will be issued. Currently, a microgrow license costs 1,000 times the cost of the microgrow license offered in the lottery. Hemp farmers are not multi-state operators with access to the public markets, nor wealthy Russian oligarchs. I myself generated no income the last 2 years as hemp prices crashed. I suggest that hemp farmers pay the same fees as the medical marijuana growers, based on the square footage of the canopy. Since they paid $3 million to grow up to a 250,000 square foot canopy, equal to $12 a square foot, hemp farmers could have a regular license capped at 80,000 square feet for the price of $1 million. The microgrow license that is capped at 10,000 square feet would cost $120,000 at $12 per square foot. These license fees are substantially higher than the cultivation licenses found in the lottery and are on a par with the medical marijuana licenses on a square foot basis. I believe this provides parity with the existing cultivators from a fee standpoint, although hemp farmers will not be getting a 2-year first mover advantage that the current growers will likely enjoy. Thank you for your time, and I'm happy to answer any questions you might have.
Thank you. Questions for committee members? Representative Ackert.
Thank you, Mr. Chairman, and Fran, thanks for being here. I know your facility pretty well. Are there other facilities, hemp growers, that are similar to yours in the state?
I believe there is one other facility. I have been hearing testimony about how we're going to flood the market. I can almost guarantee you that there will be less than 125,000 square feet of canopy being built or grown if hemp farmers are allowed to grow. Most hemp farmers have 1,000 square feet of space, 2,000 square feet of space. It's tiny. So I'm hearing testimony to the contrary, but I don't believe that. And I believe that we have a demand supply problem now. That's the opposite of what I'm hearing from some of the testimony. Demand far exceeds supply.
Thank you. And I haven't got a chance to get to get into the public and ask about that, you know, into the individuals that
Sure.
participate. The other question, the fact that one thing, would your product, because you don't use the electrical component to the level of others, because actually in my other job, was given a set of plans and went through a facility and talked about you know, the level that they build the facility out to. and the amount of power that they use,
Right.
electricity wise. And it was interesting, the comment from the grower was, oh yeah, we grow a green product, but we're not a green company. So would your product, a hemp grower, would it be more reasonably priced to the market than others?
Well, it could be. I believe that my current grow situation with greenhouses, and I do use lights, it's the only way I can get multiple crops, but it's about 30% cheaper than indoor grows. And I believe it is the wave of the future. More and more grows will be done in greenhouses as opposed to the sterile environments of the indoor grow with the terrific costs of electricity, especially with Massachusetts. I mean, with Connecticut. I mean, Connecticut, I believe, we're certainly in the top 3. You would know better than I in terms of costs, but we're in the top 3 in the country of our electrical rates.
Number 2.
Number 2.
But
we try harder.
Yeah. Thank you for your perspective, and thank you, Mr. Chairman.
Other questions from committee members? Give me the fee structure again that you were proposing.
The fee structure I'm proposing, it looked to me, the law that you are considering was trying to equate us with the medical manufacturers and having which I believe is great, having the 2 joint ventures for social equity. That's very similar, if not identical, to the medical existing marijuanas, which makes sense because they're cannabis growers, we're cannabis growers. So I'm saying on a per square foot basis, we should pay the same. I get that. And so I am proposing on a per square foot basis. So there's $3 million for a grower, for a medical marijuana grower. They can grow up to 250, I believe, up to 250,000 square feet, which equates to $12 a square foot. So I'm saying there is no hemp farmer that is going to pay the $3 million. They can't. We just don't have the money. And we want to do a craft industry business. We don't want to do a 250,000 square foot grow. So I'm saying cap it at 80,000, $12, that's $1 million, $500,000 for JV, and do the same thing for the micro grow. Because the micro grow, I mean, you're charging $1 million for 10,000 square foot of canopy. That's economically not feasible. I mean, at $12 a square foot, it's 120,000. It's substantially more than the 1,000 that is what the lottery micro cultivator is. So we're paying our share, if not more than our fair share, which is fine because we'll do the joint ventures for 6. The joint ventures are great. I want to be part of social equity. It's fabulous. So I don't see where we're at odds with social equity, but I don't know.
All right, that's helpful. I think the fee structure isn't just to reflect the square footage, but to reflect the fact that you are being, if this were to pass, permitted to essentially jump the line. So
well, it's interesting. Can I comment on that? I don't know what queue there is. There's nobody waiting, jumping the line. There's no line there.
You heard the concerns from the social equity advocates today. I mean, they strongly disagree with that.
But we would be forming joint ventures ourselves.
I don't think it's required that you.
It's not required, but I guarantee, I shouldn't guarantee, I can't guarantee, I will do it.
Maybe that's what we have to do, is require you to do that to pay the reduced fee.
Well, I can only speak as me. Yeah, I'd be happy to do that.
Just taking a note on that. Hold on.
It's just, and can I address, because you guys know, a lot of you have been at my facility. I've heard testimony saying, why didn't we do this? Why didn't we do section 149 or whatever? My facility was already built, and it's in Cheshire, and it's not in a disproportionately impacted area. So the only way I could do that would be to pay the $3 million to the state and then move my facility at great cost to a disproportionately impacted area. Just can't do that. So,
Look, I mean, Senator Kissel,
Yeah.
Nailed it, which is we're struggling with this tension of different competing interests.
and I
here.
participated in the lottery, and I was frustrated that of the micro grow cultivator lotteries, 3 of the 4 went to out-of-state people.
And I'll ask the same question that I'll ask to you. The yield that your facility could do on a yearly basis, what would it
The
be?
yield I could do would be about 4,500.
Is it pounds? What is that? Pounds?
4,500 pounds.
Okay.
Yep.
And
that's best case.
And embedded in all of this is the requirement that in order to convert, you have to meet all the other requirements as well. You're not excused from seed to sale tracking and
Oh, no,
security
I
requirements.
understand that, and I'd be happy to.
I know you would. Of the 70, and maybe this is a
Well,
question for
when
Becky.
it says 70, there's only less than 40 that are actually growing.
And how many could actually meet the requirements of seed to sale tracking and security?
I
of the
think that's a
facility
better
and-
question
for
for our
Becky.
president,
Yeah,
Becky, who is the next.
Agree.
I don't know.
Fair enough.
But
Thank
Okay.
you. Thank you very much.
Thank you for your time. Appreciate it.
Okay, good follow. I know you probably have testimony, but you might as well just jump right into that
Will
question.
do. Good afternoon, everyone. I want to thank you for the
Introduce yourself, otherwise. Up to the committee. too.
Yeah.
Thank you.
Becky Getch, hemp farmer located in Killingworth, Connecticut. And I do want to thank you for the opportunity to be in front of you today. I provided testimony last year begging to be heard. So I appreciate the efforts over the course of the entire year that you've made to work with the hemp farmers. It's significant and we do really value this opportunity. And I hope we get it right, or at least we can make some meaningful impact with this bill, 6700. Okay, so I'm feeling a little disrupted because we're going to go off script completely.
Take your time. We'll give you the
So-
time. We'll have some questions, so we'll.
Start where I was going to start, which is we're a small hemp farm in Killingworth, Connecticut. We're before hemp, we were a garden center nursery. We still produce annuals, perennials, mulch, firewood, etc. Typical for your average family-run 3rd generation garden center. So we're in a position where we're constantly trying to bring new things in and diversify our farm offerings so that we can support the 3rd generation as well as meet our community needs. And so when the opportunity to grow hemp in 2018 presented itself, I started working actively in the industry then as an advocate for hemp. I have personal reasons why I brought CBD on as one of our crops. It helps me medicinally tremendously. And I'm also in recovery and it's been instrumental in recovery. And so from where I'm sitting today, I'm talking to you as a hemp farmer first, but I'm also carrying the responsibility of the president of the Connecticut Hemp Industry Association. And so I've struggled with what 2 hats I want to wear today and what I want to focus on the most. And after hearing today's comments before me, I think it's best to kind of speak from my heart, which is the hemp farmers are a craft industry and we are committed to the cannabis plant. We've spent 4 years fine honing our skills, building out our facilities, some more than others. And we all grow at different scales, but ultimately we're environmentalists, we're craft producers, and we have immense integrity. We believe in regulation. We would like your help with enforcing against the bad actors. We don't want synthetics. I'm also certified organic, as you heard from my friend, and we're a regenerative farm. The idea of Delta 8 getting sprayed on my hemp flowers a no-go. I don't sell it to people who are going to do that because I grew painstakingly some really good flower that's meant to be enjoyed organically, safe, and that's my message and that's my ethos. So, and I think that's spread pretty uniformly across the hemp producers that are licensed hemp producers in the state. I want you all to be aware that we're also, if we're hemp producers, licensed with DCP. I myself have a DCP license for manufacturing products, even though I don't alter my hemp. all I do is make herbal teas or sell whole flower in the form of joints. So I have a DCP license to even manipulate my flower into a consumable product. And so we are, as an industry, are very comfortable with regulation and compliance. And I think that the most important thing to talk about is perhaps like what impact we could have on the community, which is I sent out a survey to the 78 hemp farms that exist, down from well over 200 a couple years ago. When we had to convert to a USDA program, we had to renew our licenses, and now there's 78 farms that have renewed. From the email that I sent out begging for feedback from my fellow hemp farmers, 3 email addresses bounced. So I'm assuming that that means that those entities have closed doors. And I received about a 20 to 24% response rate. So those are people who are interested in converting their hemp licenses to a marijuana license. Of the people who did respond, it's very clear that there's about 3 farms that are licensed by the Department of Ag with greater than 10,000 square feet of greenhouse space. Sorry, 4, myself included. I have 10,000 square feet. Keep in mind, I just told you that I'm a diverse business. So I use 2,000 square feet to grow cannabis on my farm. And that's the average number of people who have greenhouses existing today. So were we to get our licenses in July, you have well under 130,000 square feet of existing greenhouses, none of which have the compliance in place. So we all need that window to build out. And in respect to social equity, the way you have the bill proposed is with 2 joint ventures. I suggest we can go further, and I think we should be creative. I don't think that social equity in the state of Connecticut needs to be structured in the form of marijuana licenses, okay? We can achieve social equity by bringing in training programs, mentoring programs, and maybe start thinking about how we can really have a good impact that doesn't cost $3 million. And I'll take questions.
Great, thank you. Questions? So 4 facilities basically that could conceivably convert over.
In a scale that would impact, you
Right.
know, supply.
Okay.
I myself, I have 2,000 square feet. You heard from my colleague and Chia member who plants 600 plants in 1/3 of an acre. I can't, if I plant 600 plants in my greenhouse, it's challenging to stay organic.
Right.
Without pesticides and with all natural components and IP and pest management practices. So I like to plant about 300 plants. But for me, I could incorporate light deprivation or enhanced light. So I could do 3 to 4 crops a year.
Do you know how many hemp farmers in Connecticut are greenhouse versus on a farm?
I believe that there's only, I don't know anybody who's exclusively in the greenhouse other than Grant, who you just heard from. But speak up if you are. Everybody else is some sort of outdoor grow primarily or a hybrid.
That's helpful.
And if they have greenhouse space, it's typically to initiate the growing process, to be able to start your clones early and be able to be ready to plant outside in the growing season, late May, June timeframe. But I think there's plenty of enthusiasm to convert the licenses, so it should be open to the existing licensed people. And also I heard something this morning that of concerns that it would cause more people to go out and get a hemp license. That's not what we're asking for. We're not asking for people to go get a new hemp license and be able to use that as a fast track. We're asking for the people who have invested their family farms into the cannabis industry with, I hate to say it, but a lot of expectation to be able to convert to marijuana licenses. And not that I don't want to take anything away from the way it was rolled out. What I'm just saying is a lot of people have really invested a lot of money into this industry and should be able to try to recoup some of those costs with a viable distribution outlet, which is another reason CBD products have to be able to be sold in dispensaries, because we have integrity. We want our licensed products to be available to the consumer.
We do, that is part, just so we're clear, that is
That's-
part of the committee bill allows your
Yes,
products to be
Section
sold in
7, yeah.
dispensaries.
Yeah.
Questions from any members? Thank you, thank you.
Up next online, we have John Kennelly.
Stay online. Can you hear us?
I can hear you.
Great. We can hear and see you. Terrific. Go ahead.
Good afternoon. I want to thank the many members of the General Law Committee and staff for taking these last 3.5+ hours to listen to the many stakeholders in the cannabis industry here in Connecticut, and to also from the many members of the public who have interest in these topics. To begin, I want to testify in support of creating a moratorium of 3 years for the issuance of any new cannabis licensing here in the state of Connecticut. I joined with many other individuals who've testified, warning of the inherent and unavoidable risks to this industry from an unlimited supply of permits being issued. If you look around the United States, anywhere from California to Michigan to Massachusetts, our neighbor, you have seen what unlimited permitting has done to the industry. It has resulted in the failure of many corporations, everywhere from growers to producers to retail. When you have a situation where you have unlimited permitting going on, you create an unstable and unsustainable marketplace that will inevitably result in saturation. What happens after that? A previous witness testified that, you're going to see a lot of Connecticut people lose their homes, lose their 401ks, and that would be the first step of the macroeconomic trend of oversaturation of a marketplace. What happens next is even more disturbing, because when you have all the people who in Connecticut who tried to get involved in this industry, people and most of the social equity applicants who have been approved by the Social Equity Council, after they're wiped out by this oversaturation, which again, we've seen throughout the nation by unchecked permitting, you have inevitably the only people who can move into the space after the market is cratered are multi-state operators. It is only the big companies that can then afford to come up to the wasteland that becomes the cannabis industry and become the only producers. Therefore, in about a 7 to 10 year cycle, you go from what your legislation aimed to do, which is to create wealth in places adversely impacted by the war on drugs and give opportunities to entrepreneurs throughout the state of Connecticut. You actually create the opposite. You create the runway for the macroeconomic situation of there being no Connecticut-based operators in the industry here in our state. Additionally, I would ask, the other thing I'm here to testify in favor of is extending the pay date of provisional licenses for cannabis applicants. Presently, one of the biggest hurdles to people who have been approved by the Social Equity Council for social equity applicant permits of all types is the rather significant fee structure, both provisional and the final fees. I would advocate that the provisional fees would only be due and payable 12 months after the provisional fees have, or the provisional permit has been issued by the DCP, which of course happens after the SEC's approval. This could be securitized through a promissory note by the applicant, and additionally making approval of a final permit conditional on paying that fee before the final permit could be issued. Finally, in the legislation, there is a timeline between the issuance of the provisional permit and the final permit of 14 months. Now, I will tell you, at least for the cultivators and for many other elements of this industry, up and down the food chain, 14 months is just literally not enough time to go from construction documents or even schematics to construction documents to permitting to actual construction. 14 months, I've built things on behalf of clients, everything from billboards to restaurants, And I can tell you that 14 months is not a realistic timeframe to create the food-worthy production lines that we're talking about and that will be required by the DCP. I would humbly ask that this committee think about an amendment which would extend that timeline to 24 months. I think the most important thing, and I think the theme you keep hearing here, is that in an economic sense, we cannot allow an unregulated market. Now, some people have a real problem with regulating markets, and that markets should just find their own level. And I understand that perspective, but it is unfortunately a short-sighted perspective. There must be, the state must move as a partner in creating a sustainable and healthy market for the long-term success of this industry. By allowing a completely unfettered permitting process for year after year will unfortunately, inevitably result in this market cratering. Thank you very much for your time again, members of the committee. Again, my name is John Kennelly from the Hartford Cannabis Company. I don't know if I mentioned that at the start of my testimony, but I welcome any questions.
Thank you, Attorney Kennelly. Any questions from committee members? Representative Brown, nothing? Thank you very much, Attorney.
Thank you very much.
Our next testifier is in person, Kebra Smith Bolden.
Good afternoon. I would like to thank the co-chair, D'Agostino, my state rep, and General Law Committee members for allowing me to provide testimony in opposition to HB 6700, an act concerning hemp licenses in the adult use cannabis market. My name is Kebra Smith Bolden. I am a registered nurse, mother, and serial entrepreneur in healthcare and cannabis. This one is a little hard for me because as a cannabis advocate, I advocated alongside my friends in the hemp industry for the legalization of cannabis for adult use. One of my fellow advocates, which he said it was okay for me to talk about him, Louis Vega, went through the process to build a thriving hemp company, Wepa Farms. I built a nationally recognized business, Canna Health, medical cannabis centers responsible for certifying thousands of medical cannabis patients in Connecticut, and the first legal cannabis business owned by a Black woman, well, a Black person in the state. But as the opportunity became available due to the passage of RERACA, Louis, despite his established status as a hemp business owner, decided to sell his hemp company to further his passion for farming and plant science in the adult use market. I too wanted to get a license to cultivate, knowing the jobs I could create and the greater good I could do in my community as a cultivator. I sold Canna Health and began the application process because it would have been a conflict for me to have both businesses. Now I was knowledgeable regarding the legislation, having sat on the governor's social equity working group and was a part of building this legislation. So I knew that you had to qualify as a social equity applicant in order to apply for this one-time only limited application window to become a DIA, disproportionately impacted area cultivator. I knew you couldn't make more than $236,000 a year, but needed $3 million to apply. So despite that financial obstacle, amongst others, to become cultivators, we sought out partners, took on huge debt, and applied for our cultivators' licenses and started securing properties. Having done all of that, Louis and I were far from grandfathered in because of our previous and notable work in advocacy in this industry. Like every other social equity applicant, we had to go through the application process, were subsequently denied. We both had to retain appellate lawyers and essentially sue for our right to have this license. Because of this denial, I lost property. We were in contract to purchase, and once we filed and won our appeal, I was back to square one. Myself and 8 others were approved in November of 2023, and since then have been working tirelessly to find properties and work with our financial partners to become operational within 14 months of receiving our provisional licenses. However, many things that we could have never predicted happened, like 41 people applying for this. No one knew that was going to happen. And now with 24 approved. In a state where around 3.5 million people, having 24 large-scale cultivations signals oversaturation in the near future if all of these businesses become operational. Then to grandfather in nearly 78 of my friends, I love y'all, but hemp growers in an environment where there are already a large number of cultivators, many of whom have yet to be able to become operational, is a mistake. Further, to allow non-social equity qualifying individuals to partake in a social equity only license type and to allow these conversions to operate outside of disproportionately impacted areas, which the point was to create jobs and opportunities in those areas, undermines the entire spirit of this legislation. I believe it is incumbent upon the state to first support and ensure the stability of social equity approved DIA cultivators before anyone else is able to enter the already fully loaded playing field. And I do believe hemp is necessary. I know there are great things that can be done with hemp, and I feel the state should support the hemp growers in their farms and help them be sustainable.
Thank you. Like we've heard from Lewis before, actually. It's interesting. We didn't know that he sold the farm. So
He
it's,
did.
thank you for that update.
Mhm.
Questions from community members? Thank you very much.
Thank you.
Next up, we're gonna have Jacob Honig.
Hello, thank you, Mr. Chairman and members of the committee. My name is Jacob Honig. I'm from Harwinton and I co-own and operate the CBG Gurus with Mr. McGill. I'm here to testify in support of proposed Bill 6700 and to highlight the provisions in Section 5 and 7 to allow hemp products to be sold in dispensaries. I want to emphasize this is currently prohibited by DCP policy, and we need legislation to codify our right to sell hemp to dispensaries. As a CT medical marijuana patient, I know firsthand there is zero access to non-intoxicating, non-THC based cannabis products in dispensaries. This is a disservice to medical patients and consumers who desire to work and live productive lives while managing severe pain, anxiety, and other debilitating medical conditions. Hemp products can provide relief without the intoxicating effects of THC cannabis. Hemp products undergo a full panel of laboratory safety tests to strict USDA standards, ensuring the safety and efficacy for patients and consumers. Therefore, it makes sense to give patients and consumers the opportunity to choose hemp in our dispensaries. However, this legislation requires 3 changes to ensure it will benefit Connecticut's medical patients and hemp industry. We need to add a provision to guarantee all hemp and hemp products sold in Connecticut dispensaries are grown in Connecticut and manufactured by a Connecticut licensed hemp manufacturer. This will ensure Connecticut has oversight over hemp products sold in dispensaries. If this is not added, cheap hemp products from out of state corporate plantations could flood our dispensaries and further diminish the Connecticut hemp farmers' access to the market. We should delete section number 7, clause 2, requiring hemp products to be sold in a separate area from marijuana in dispensaries. Patients deserve to be informed of their options for cannabis medicine, and hemp products are an important tool in their tool belt. Hemp products can be clearly identified with proper signage and therefore responsibly sold alongside marijuana. Finally, section 5, clause 2, the long timeline for dispensaries to sell hemp products is unreasonable. We shouldn't prevent patients from accessing medicinal, non-intoxicating hemp products in dispensaries until 2024 or beyond. With these provisions in place, we can get hemp products in dispensaries this year. These provisions will enhance the safety and well-being of consumers and patients in Connecticut, encourage use of medicinal, non-intoxicating cannabis products, and support Connecticut farmers and small businesses. Thank you, and I'm happy to answer any questions.
Thank you very much for your testimony. Are there any questions from committee members?
If I may, Mr. Chair.
Okay, Representative Osborne.
Jacob, I just want to say you're full of surprises and please say hi to your mom and dad.
Sure. All right, thank you. Oh, unless you have any more questions.
Are there any other questions? Hearing none. Thank you very much for your testimony.
Appreciate it.
He doesn't mean karaoke too, just so y'all know.
All right, Mr. Clerk, I believe the next is remote. Is it Jeff Wenzel? We'll wait while you admit him. Mr. Wenzel, can you hear us?
He's joining, Mr. Chair.
Okay, thank you.
I'm here. Can you hear me?
Yes, we can hear you. Please proceed.
Yeah, thank you, Mr. Chairman, and thanks to the committee for doing this. My name is Jeff Wenzel. I live in East Lyme, and I'll submit written testimony today, which provides deeper analysis of some of these bills and some suggestions to promote product safety and some lessons learned from other states. But in the 3 minutes I have today, I'm speaking on behalf of CHIA, the Connecticut Hemp Industry Association, in support of 6700. We are a nonprofit representing Connecticut hemp producers, manufacturers. We're a diverse group who started out with a love of the plant. We've matured in the legal hemp space as hemp producers licensed by the Connecticut Department of Ag, and as hemp producers licensed by the Connecticut DCP. In a time where the adult use markets seem overrepresented by large multi-state operators, we are your local craft industry, similar to microbrews who can create an alternative to all the cannabis Budweisers coming to our state. We've seen our products help improve people's quality of life, where pharmaceutical drugs have sometimes failed, and we want to continue to help people. We've been growing hemp cannabis using regenerative practices, and our use of sunlight and greenhouses compared to purely indoor cannabis growing makes us a smart, sustainable alternative as electricity costs continue to rise and we put increased pressure on our energy grid. We were happy to see our hemp producers included with an adult use licensing path this year, and happy to see the social equity components, which we strongly support. I understand the current licensees don't want competition, but the concerns we're hearing from current licensees about skipping the line or an unfair advantage are respectfully misguided. As Becky mentioned, all the hemp farmers together wouldn't equal the canopy of one single current cultivator license. We're not partnering with big MSOs. We are your local family farms. Your fears of hundreds of hemp farmers creating an oversupply are just not reality. The current proposed regulations have already prohibited outdoor growing and would only allow the few with existing greenhouses to participate. We look forward to partnering with social equity applicants who prefer experienced local farmers over large out-of-state corporations. The untruths being told by some of the current licensees turned gatekeepers sounds like hyperbolic fear-mongering. While we're asking for the crumbs left on the table, you prefer to wipe them all away out of unfounded fear. You sound like a Walmart complaining about competition from local mom and pop businesses, which you think threaten your bottom line. By excluding hemp farmers, the few we have left, the adult use program would suffer. You'd not only be excluding some of our state's cannabis pioneers and greatest talents, you'd be harming local businesses who spent years preparing. You'd be harming our social equity partners. You'd be harming the employees who count on us, and you'd be harming the consumers who deserve better. We hope to start a discussion to alleviate any valid concerns and to come up with fair, common sense solutions. And the claim that some rules should be changed, but others can't be, is just self-serving hypocrisy and antithetical to the iterative process of improving our laws. Thank you.
Thank you for your testimony. Are there any questions from the committee? And Mr. Wenzel, I apologize. I wasn't here when Brant Smith testified, so he may have already answered this question. But can you just let us know how many hemp farmers are there who do have greenhouses or growing indoors, or could be able to grow indoors?
You know, most hemp farmers have really small greenhouses that they use for propagation and grow outside. So you know, probably a dozen tops, but most of them are, a few thousand square feet, not big grow operations. These are, like I said, crumbs on the table.
Great. Thank you very much for your testimony.
Thank you. Appreciate it.
Okay, Mr. Clerk, I believe next, Christina Capitan. Did I pronounce that correctly?
Yes, you did.
Okay, great.
Good afternoon, respected members of the General Law Committee. I appreciate you hearing my testimony today. I would like to speak on several of the bills that are being heard in this committee today, just briefly. So first and foremost, I would like to speak on HB 5434. I'm strongly in opposition of this bill. I think it was not well thought enough. And I believe that many of the claims that are being made within that bill don't have substantial evidence to support those claims, i.e. Imminent risk of injury to a minor should you pick up your child and be perceived to be under the influence of cannabis. That's a very broad thing to say, and I think it puts a lot of families at risk, as well as the potential for birth defects to be had if you use cannabis during pregnancy. I don't think that's a proven statement. I also wanted to comment on HB 6699. And while I'm generally supportive of most of the language in this bill, and I applaud you all for taking the time to recognize the industry that's existed for generations prior to legalization, the craft industry, and looking to establish a task force to study what would happen if you allow those craft producers to get their product out into the community. I think that looking at just the negative impact that could have is a disservice. There's also many potential benefits to that, including allowing others to share their experience and their knowledge with people in the community, including those who have been licensed to cultivate cannabis in Connecticut. I hope that we can continue to explore that and go a little bit deeper. But one of the main things that I'm here to talk about is HB 6799. As someone who has acted as a caregiver in the state of Connecticut and other states illegally for a long time, I have to say that, while we talk about allowing people who have been convicted of drug charges or manufacture or sale of cannabis to serve as caregivers in the medical field for patients, I don't think that expounds enough upon what caregivers really should be able to do in this instance. There have been many parents and people who are at the end of their life who need care, and parents of children who are very sick or dying, reaching out to me excessively since the inception of the legal recreational sale of cannabis. And what I keep hearing is that the products that they need are not available. When I see a menu at a medical dispensary that does not include many CBD products, that's a red flag for me. These things are either not available currently, they're in very short supply, or they are just financially unattainable to these families. And I think we could do a lot better to expound upon the definition of caregiver if we're going to look at that at all, and allow for those individuals, like they do in other states, to grow plants for these patients to meet their specific needs, manufacture products for them, and not just family members, but also people who would trust these caregivers as a close friend or family member to provide those services and needs to be met. Thank you very much. I believe that I did submit my testimony, but it came through blank, so I will resubmit that for you today. And if you have any questions or anything, I'm here. Thank you.
Okay. Thank you. Are there any questions? Okay, hearing none. Thank you. Okay. Next, I believe is online, Ray Pantalino.
Good afternoon, Chairman, committee members. Thank you for your time today. My name is Ray Pantalina. I'm a Connecticut registered pharmacist and managing partner of Affinity Health and Wellness, a licensed hybrid dispensary. RERACA, the Responsible and Equitable Regulation of Adult Use Cannabis Bill, provided for the creation of equity joint ventures, or EJVs. The original bill did not limit the number of EJVs that a hybrid dispensary could create. Affinity Health and Wellness, a Connecticut-owned and operated hybrid dispensary and its social equity applicants created partnerships and formed EJV businesses for 6 EJV licenses. Applications were filed under the old law, and the $500,000 application fee was paid in February of 2021. The law in effect at the time, Connecticut General Statute 21A 420U, effective July 1st, 2021 to May 23rd, 2022, required a minimum number of 1 equity joint venture, but otherwise did not limit the number of EJVs that an existing hybrid dispensary facility could create or participate in. Relying upon the effective date of RERACA, the applicant submitted EJV applications, while the prior version of Connecticut General Statutes 21A 420U was in effect, which did not cap the number of EJVs a hybrid dispensary could create. In this instance, based on and in reliance of existing law, the applicant sought to create 6 EJVs. The relevant law changed on May 24th of 2022. Connecticut Public Act 22103 was enacted. It was effective from passage and subsequently rewrote 21A 420U by adding subsection H, which capped the number of EJVs at 2. By its plain language, pursuant to Connecticut General Statute 55-3, the May 24th legislation operates only prospectively to furnish a rule for future cases only, referencing Little versus Ives, 158 Connecticut, 452, 457. As such, the new version of the statute did not apply to the applicant's pending applications. Moreover, the applicant was entitled to rely upon the former version of the statute. Affinity Health and Wellness and its social equity partners, the applicants, are not limited to 2 equity joint ventures. The applicant's EJV rights are controlled by the version of 21A 420U that was in effect at the time the applicants submitted their applications, which was prior to May 23rd, 2022, when there was no limit or cap or the number of EJVs a dispensary could file. At minimum, we are asking for supportive legislation that would allow any hybrid dispensary who paid their fee prior to the passage of HB 5329 to be allowed to move forward with their equity joint ventures and help these social equity partners realize their dreams and these great opportunities. That's my testimony. I'd be more than happy to answer any questions.
Thank you very much. I did not see your written testimony online. Are you going to be submitting written testimony?
I will submit I apologize. That's my error. I will make sure it gets there promptly right after this testimony.
Okay, great. Thank you very much. Are there any questions? Okay, hearing none. Thank you very much for your testimony.
Thank you, Chairman.
Next online is Nicole Hampton.
Hello, can you hear me?
Yes.
We can hear you. Your video's sideways, but that's okay.
Yeah.
Oh yeah, I don't know why. Sorry about that. Good afternoon, General Law Committee. My name is Nicole Hampton. I am a woman in recovery from mental health and addiction, a mother of a teenage daughter. I've been working in the recovery field for the past 7 years. I'm a part of my local prevention council, and I'm a strong advocate for protecting our children. I come before you today in support of HB 5434, and I'm so grateful that Connecticut placed some caps on cannabis products. We currently have a 30% THC cap on plant products and 60% on concentrates. We should definitely have caps on the THC of pre-filled vape cartridges that our youth are attracted to. The cannabis today is not Woodstock THC level, and we are finding 70, 80, 90% THC levels in the pre-filled cartridges. Studies show that any THC level over 10% puts someone into psychosis. Our current caps aren't based on science, they're based on harm reduction. Maybe Connecticut should prohibit edible cannabis sales. Edibles are not individually wrapped in Connecticut, and we actually have a yoga studio in Westport that sells edibles that are 3 times the serving size. Not to mention it takes 2 to 4 hours to kick in, and I'm sure those first-time users will be over consuming. If we have labels on cigarettes, then we should have labels on cannabis products. The secondhand smoke of both are harmful. The CDC actually published a study that cannabis can cause low birth weights and neurological deficits. We put the cart before the horse, and educating our youth through programs such as Courage to Speak is pertinent. And we also need funding for prevention before year 3, as the current law reads. Gas stations should not be selling THC products, especially the ones marketed to kids that look like knockoff Skittles, Sour Patch Kids, or Oreos. Cannabis sales should be halted until our police departments are properly trained. I think it's ludicrous that our police cannot pull someone over for smoking a joint right next to them, but they can if they're drinking a beer. Also, the same regulations and consequences for alcohol should apply to cannabis when it comes to public consumption as well as underage use. If someone can't pick up their child drunk from daycare, then they shouldn't be able to pick them up high. We absolutely need child-proof containers with the poisonings and deaths from child consumption of cannabis edibles in Connecticut. Cannabis is addictive and can be a gateway drug or the drug that kills someone. It should absolutely be a Schedule II controlled substance. I ask all lawmakers today to please read through the written testimony submitted. Of course, the cannabis industry showed up to testify today, but a lot of folks in the prevention field weren't allowed to testify due to a prohibition on lobbying, since they receive a tiny bit of money through the LPC grant. Thank you for your time today. I will make sure I submit my testimony, and I'm happy to take any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, and then we have none online. So thank you again for your testimony.
Thank you.
Okay, next is in person, Duncan Markovich.
Good afternoon, General Law Committee, representatives, Chair D'Agostino, fellow cannabis advocates. My name is Duncan Markovich, founder and owner of Better Ways, a cannabis therapeutic store in Branford, open since 2019. I am here to testify not in support of Bill 5434 and in favor of Bill 6700. I have a background in biomedical engineering, political science, and an MBA in sustainability. I use cannabis products every day for pain management and neuropathy issues. I too have experienced cannabis hyperemesis syndrome many times. It is as painful and violent as shared earlier by Ms. Ritigliano and impacts lives deeply. My and my mother's hearts go out to her and her own son's experience and wish him steadfast courage and discipline with his journey in addiction. In my personal experiences with CHS over the last year and a half, I find that quality control and lack of dosage education are big culprits in this problem. From what I was told recently with my newest experience was that the input actually came from one of our very own Connecticut dispensaries in the form of an edible. Ultimately, the patient pays the cost. Cannabis is an amazing and powerful plant-based medicine that has great ability to balance our endocannabinoid system and support homeostasis in the human body. Just like with anything, all things in balance, and cannabis holds cautionary tales as well. Cannabis is also an individualized experience in both medical and recreational applications. That is why correct dosage is a dynamic conversation. I am steadfast in equal agreement with all here that accurate education, quality products, accurate transparency and testing standards, dosage directions, and up-to-date information is available for industry members, the public at large, and especially for the safety of our youth that equally benefit from cannabis products under the correct supervision and protocols. These have been the foundational tenets since my business's inception and have proven to be extremely successful thus far. Representative Osborne echoed great wisdom in suggesting we look towards other states' triumphs and and follies. Maine is a fantastic example, and I recommend you all research its benefits. THC potency caps do not work and ultimately limit patient options in their palliative care, as well as correlation to higher THC dosages and budgetary restrictions. Basically, the higher the THC, the more expensive it's going to be. A graduated potency step-up scale is necessary, as this plant is able to touch upon serious health obstacles such as cancer and anxiety. I've seen this phenomenon firsthand in my store many times. As always, correct education is our best tool to tackle this. The suspension of sales immediately impacts medical and now recreational patients, and will only continue to plunge our jeopardized program further into chaos and place patients at risk. I have a recent audio testimonial here with me today of an active medical patient of how the current medical program is failing them for your review. There's suspension of anything, it should be the unsafe levels of mold and bacteria in the medical program that were recently voted last year to 10 to the 5th CFUs. I can't rationalize voting to increase anything that would jeopardize the health of the plant or its end user. The other concerning measures the current operating model is the use of remediation tactics, such as soaking unsafe cannabis in ozone or irradiating it in order to pass state compliancy tests. The irradiation tactic is directly linked to the now
I believe you're,
recently uncovered Russian-owned and controlled Curaleaf.
You could just
can
summarize.
can you please summarize?
Here in
Yeah,
Connecticut.
your 3 minutes.
Yes,
All right, thank you.
I asked our governor Tuesday morning in Branford, and I ask you all now, what is your committee's commitment to the Connecticut cannabis community and our country at large? Initially with safety standards, quality, education, and the removal of this Russian-controlled company out of our state's borders.
I do have a question for you on the medical side. I know you're very active with it. The Curaleaf is owned by a Russian.
Originally Connecticut brand bought and has now been proven to be the Russian-owned and controlled. There are now multiple state audits in where that money went, including here in Connecticut.
On the medical side, we don't have the we deliberately kept higher limits for the medical. I don't think we've really heard much, frankly, in the last few months. A lot of focus, understandably so, on the recreational market. On the impact of the recreational market sales on the medical marketplace at all. Are medical patients still able to, putting aside the issues that I know have been raised with respect to mold and things like that, but in terms of availability, in particular with respect to strains?
And that's the audio testimonial I have from an active medical marijuana.
Can you just summarize, are people not seeing?
Availability scarce. The quality of products that the medical patients rely upon is no longer available. Strains, strain dependent, I believe it was for her Parkinson's was her condition. The producer no longer grows that cultivator, let alone produces she can't smoke.
Yeah,
she needs edibles.
So this was a concern that we heard beforehand, and it's interesting that it's coming a bit to fruition. It may, understandably so, the larger recreational marketplace, the larger producers are going to focus on the recreational products, and we were concerned about. Again, we've all been educated from the medical community over the last, what's it now, 12 years since medicals, that when it comes to treating certain ailments, patients are particularly devoted is probably not even the right word, reliant upon particular medicines and strains that treat their particular ailments.
Yes.
I guess we were hoping that, and maybe this will happen, this is still a young marketplace, that in particular, the micro cultivator community would develop to fill that gap.
Absolutely.
Is
If
that
more micro cultivator and micro dispensary licenses were awarded? There is no Venn diagram. The gap is present. I hear this daily. Blue Point, or whatever it turned into, Resonate or Rhythm or whatever. Rise is a mile and a half away from my storefront on Main Street in Branford. Daily, I get customers coming in. Do you have weed? They don't have what I have. The lines are long. I'm not getting hurt anymore.
Do you
These are
think?
people paying the state
Yeah.
for a medical program under the guise that they're getting the products. they
We,
need.
this committee is very sensitive to the medical program. I think we'd like to hear more on this as
Yes.
well. And you're the only ones really testifying on it today. I wonder if there's a solution we can come up with vis-a-vis a dedicated medical micro
called a
cultivator
caregiver
license.
And I strongly urge you to look toward Maine.
What did Maine do?
Their caregiver platform, allowing, such as myself, I don't have a license. I have a storefront. I have a brick and mortar location where people can get their medicine. I'm limited.
To what you can
with
dispense.
what I'm legally allowed to offer these people. And I'm on the CBD and hemp side. I have been for 3 years. I'm extremely frustrated that the 80-year-old who pays $500 in the program, who goes to the appointments, who thinks they're being heard, they get to a dispensary and it's like, you need 35% THC. I don't care how high you're going to get. That's medical.
Mhm.
That's not how this plant operates. Entourage effect, terpenes, cannabinoids. There is a significant lack of education in how this plant works and how it's being educated to the community, let alone the people who are community facing.
I think we did include some caregiver language in our bill. We'll take another look at it. Too. And we got rid of the fees, but he's talking about really the availability issue is one that I think we need to be sensitive to in terms of.
Chair D'Agostino, we talked about this last session on the lawn. If I grow a bunch of tomatoes that I would love for you and your family to have, and I know organic soil, the best heirloom genetics, great growing season outside, by the way, where plants should be grown. Massachusetts gets homegrown outside. Why do we have to grow indoors, especially when electric rates are doubling?
So, fair points. No, thank you. It's very helpful to hear, especially that perspective. No, you can't sell cannabis, but you sell CBD and
Federal
right
and Connecticut state compliant up to 0.3%.
0.3.
And you can check with DCP because they came to my store and said I couldn't sell Oregon.
But his, he's not a convenient. His stuff has to be top notch because his patrons are people who know what the hell they're buying. Obviously.
Does the caregiver program in Maine allow somebody with your type of retail operation to sell THC stuff?
All of it. This is a comprehensive plant-based material that covers a litany of health concerns.
The medical patients, certified medical patients who could come to a particular.
I have a personal kind of issue with the whole medical recreational delineation. Even if someone is recreating to get high or use hemp or use CBD and not have a psychoactive experience, you're getting all the medicinal benefits from the plant, whether you know it or not. That's a medicinal application constantly. It just needs to be good quality product medicine, which we have a lack of.
Thank you. It's very helpful. If you wouldn't mind also just if there's a way to sort of marshal some information from the medical community, we'd be interested in knowing, I think, again, more on that unavailability of certain strains, certain products that actually are key to the medical community that have either become extinct or
shouldn't sort of be designed, physical, mental, everything in between. This helps with these ailments. These strains cover these 6 things.
I think we're open to that, but we've heard this
and the strain names and the actual genetic
and the strain names.
That's how people identify. I know that strain holds this terpene profile, these cannabinoid levels. That's great for the pain management and
That's what I'm talking
my
about.
leg.
Yes, thank
you. That will be exceedingly beneficial to our community.
Thank you. Thank you for
you.
the testimony. Appreciate it. Go ahead, MJ.
Okay.
I'm sorry.
Yeah.
And Marie is up next online.
Okay. Hi, Ms. Rosado, please proceed with your testimony.
Good morning or good afternoon. Good afternoon, distinguished members of the General Law Committee. My testimony is in regards to HB 6997. This is the most concerning, this has the most concerning medical marijuana patient issues. However, I do ask that you take into consideration some of the other issues that I'll touch upon, as our medical marijuana program does need some attention. For those of you who know me or have heard my testimonies, you will hear me once again say that the patients are getting lost in the shuffle. At the highest point, we had 53,000 medical marijuana patients. As of this morning, the data showed that we have 48,560 patients. We're losing those patients due to the fact that, just as Duncan stated, we have a shortage of medication, a shortage of strains, shortage of quality of supply, and the prices of the product are rising. This is a hardship for a lot of patients. They're paying cash, they're paying a fee, and they're also paying for the doctor to write the recommendation. In 2012, we adopted a medical marijuana program. Clinics like mine were the only way for patients to enter the dispensary and to purchase cannabis. Now we're being told that we cannot advertise. We were the ones providing, and we were the ones who brought cannabis to Connecticut. Again, we are the safest avenue. I keep an office to assist an aging clientele. I help them, and yet I also give them an entire course on safety. Whether they have children in the home, they shouldn't be driving and consuming, whether they have to get drug tested at work. Not every clinic is going to do that. And whether you walk into a dispensary recreationally, you're not going to get that safety. That's also going to snowball into driving and safety. This shows me that if we're not able to advertise and let people know that we're here, that safety is going to diminish. I started this as an advocate because I believe in the program and I think it's essential. So I'm not taking a paycheck for this, especially for the sake that our program is diminishing. It's dying. It's a hardship for people to pay these fees. And also now that they're not being able to obtain the medication that they're used to, it's difficult. To talk about removing edibles from the program or removing edibles in general, that is a very unfair, not compassionate statement. When you say removing edibles, patients need edibles. The first thing a patient will say to me, or a potential patient, I don't want to smoke. When you say edibles, don't forget that that could be a pill, that could be a tincture, or even if it is a gummy, for an elderly patient, they may need to consume in that form. When it comes to child safety, which I know that that's where this is going, 100% I agree on child-proof packaging. As you know, most things that come from the dispensary are already child-proof. So again, child-proof packaging, 100%. And also, yes, if it says Skittles or things like that, get rid of it. It shouldn't happen. When we say no gas station sales, that should go for convenience stores. It should go for bodegas. It should go for anything across that board. The only ones who should be selling CBD are dispensaries and CBD stores, quality CBD stores. CBD, let's talk about that. That's an essential part of the medical program. The selection on the menus at dispensaries is quite appalling. More appalling is the fact that our CT hemp farmers are being left out of dispensaries. CT imposed regulations are being broken by out-of-state hemp being used in our grow facilities. I saw it myself in a tour of a Connecticut facility, one of our 4 growers. And that's just wrong. Anybody who knows this.
If you could summarize for us, we'd appreciate it. Thank you.
Summarize in which form? What would you like to hear?
Oh, just we try to keep everybody at like around 3 minutes. So you're
oh, okay. I thought you wanted to know where I saw it. But okay. So what I'm basically saying is that our Connecticut hemp farmers, they do need some help. The entourage effect of CBD and THC it's a wonderful marriage. It needs to be addressed. Help our hemp farmers. The statement, them skipping the line, that I feel is just a knife in the heart. They really have struggled just as me, as a small female business owner that didn't qualify to be equitable, I am a victim of the opioid crisis. I am a gun violence victim. I wasn't willing to play the lottery with my future anymore. I've been playing the lottery with this program. So,
Thank you.
I also, can I just state one more?
We do have to, just let me open it up see if anybody's got any questions. Questions from committee members? Okay. Thank you very much. We appreciate you.
Okay, I hope you read my testimony. Thank you guys. Great day.
MJ?
Our next speaker is going to be Ivelisse.
You're finally up. Come on. We've seen all that energy in the back, so.
How's my hair look?
You're great.
Yeah, 20.
All right, before I begin, I did have a question. I wasn't able to find, are there any women of color on this committee, or I'm not represented in that aspect?
Say that again, I'm sorry?
Are there any women of color on this committee, or am I not represented in that aspect? I just wanted to make sure before my testimony.
Don't believe we have any on the committee members.
Oh, that's too bad. Okay, then. So nice to know I'm not represented. I'm sorry about that. All right. So my name is Ivelisse Correa. I'm with Good Trouble Advocates and Black Lives Matter 860. I'd like to thank the committee for allowing me to speak. So today I'll be speaking in favor of Bill 6699. They say if we don't learn from our history, we're doomed to repeat it. We're currently wasting tax dollars on prohibition era policies to enforce protection on a primarily gentrified cannabis market. The poor former director of DCP, Jerry Farrell, and the husband of the mayor of Stamford, who stole social equity licenses from the truly disenfranchised, are the people we're protecting. I love how there's calls on restrictions from owners to allow training. There's a historical context that comes to mind with white owners and Black workers, but I just can't put my finger on it. Every Black and brown social equity licensee and joint applicant has come out in support of the Black market and all raised concerns, the majority of them, about criminalizing their loved ones and neighbors, and say there's room for both. So who's complaining? Is it DCP, the white owners? Why do they hold licenses while Black people are still sitting in jail for a joint? As you discuss price protection and equity with white men whose families romanticize prohibition era bootleggers, you move to throw Black men in jail. I'm sorry, you can't relate to them because they don't look like you. Let's not forget that the marketplace was much different before racist propaganda pushed criminalization. Now you want to dangle licenses in the same manner that Jim Crow.
Testifying on a particular bill?
Yes, I am. 6700 and 6699.
Great, thank you.
So I get that time back, right? On my 3 minutes? Okay. All right, thank you very much. I'm sorry you can't relate to them because they don't look like you. Let's not forget that the marketplace was very different before racist propaganda pushed criminalization. And now we dangle these licenses in the same manner that the Jim Crow South pushed poll taxes and literacy tests to vote. There have been no deaths in the state of Connecticut from edibles of any age. You might think you're dying, but that's usually resolved with pizza and a glass of milk. Thank you for focusing on cannabis when fentanyl overdoses are at record levels. Do not conflate pills and fentanyl with cannabis. We have the highest yeast, mold, and pesticide limits in the nation. I'm not sure if I trust DCP on this. You know, they're already not regulating the market. So I would like for my tax dollars to stop, stop playing with my tax dollars here. People are becoming homeless at record levels. There's no set amount to overdose. You cannot overdose on cannabis. It really depends on your tolerance, and it depends what your usage is before it hits you. If you don't smoke and you take edibles, you're going to feel about 2 days, you're going to feel crappy, and that's about it. So as long as there's no deaths, I'm not sure why we're not more focused on people dying and spend our tax dollars where it matters. Thank you. And if you have any questions, I'm able to take them.
I'm guessing there won't be any. Any questions? Thank you for your testimony.
All right, thank you.
Our next testifier is online. We have Alexander Claiborne.
Hello there. Can everyone hear me?
Yes, and see you.
Nice to see you guys today. My name is AJ Claiborne. I am the state legislative analyst for UFCW International, the United Food and Commercial Workers. I'm here speaking on behalf of our international and also on behalf of Local 919 and Local 371, who together represent over 13,000 members in the state, including cannabis workers. Nationally, we represent over 1.3 million workers all across the country in various industries, including the emerging legal cannabis industry. I'm going to try and be brief because I don't want to be repetitive, but we support UFCW International lends its support to HB 6699. We think it's a nice bill that includes provisions that will clarify the enforcement authority for cannabis labor peace agreements in Connecticut. When Connecticut legalized the recreational use and sale of cannabis in 2021, the legislature wisely provided that labor peace agreements must exist between a cannabis employer and a labor organization as a condition of licensure. However, as you guys have heard from my colleague, Emily Sabo, we've had some problems with enforcement of those LPAs. And I just want to add, my voice to say that multiple other states have chosen to include labor peace as a condition for cannabis licensure, including California, Rhode Island, New Jersey, and New York. Also, Delaware has this labor peace language in its medical regime. They don't have legal rec yet. But in all these other states, companies have also tried to get around the bona fide labor union requirement by partnering with fake unions who have failed to satisfy the criteria that they should meet. And whether this is intentional or not on behalf of the companies, we can certainly not fault folks for maybe not knowing. But the companies, we definitely know that the companies take the word of state regulatory agencies seriously. In at least one instance, a company terminated its relationship when an enforcement agency notified them that they had an LPA with a false labor organization. So, I'm here to just say that the enforcement of current law shouldn't really require additional state funding, time, or lawyers. It just really requires some action. Workers in the Connecticut cannabis industry deserve to know that the full range of legal protections afforded to them by the legislature are being enforced by the state. This can only occur if the state agency understands its duties under the Connecticut cannabis statute, and the best way to achieve that is a swift passage of HB 6699. And I urge this joint committee to achieve that end. And in order, just anticipating the question from the member from earlier, the other states with the bona fide labor organization language are Rhode Island, New Jersey, and Delaware. Thanks for the opportunity to comment. Happy to take some questions.
Thank you. Senator Maroney?
Well, you answered the one question, so thank you. I do have another question. We also have testimony from the Department of Labor that they would not be able to enforce this because they are afraid that it would jeopardize their federal funding. Do you know in the other states that have that same language, is this enforced by their Department of Labor?
I'm sorry, I missed the question. The internet, sorry.
That's okay. I'll ask it again and try to be a little more concise. So in the other states that have the labor peace agreement language, we have testimony from the Department of Labor in Connecticut that they're afraid that it could jeopardize their federal funding if they were to enforce the labor peace for marijuana, since it's not federally legal. Who regulates in the other states that have this language, and how did they get around that? If it is their Department of Labor, how are they able to get around that?
Yeah, so in the other states, it's not the Department of Labor that ends up regulating, or at least in the states that I've listed, simply for the fact that a lot of these other states don't really have a Department of Labor in the same way that Connecticut does. But like, for example, in New Jersey, the Cannabis Regulatory Commission is the entity that was able to send out a letter to enforce the labor peace requirement. And that's all it took. It didn't need anything extra besides that. It was just the same agency that handles the licensure. So I guess the analogous structure here would be DCP, but.
Okay, thank you.
Thank you. Other questions? Thank you very much.
Thank you for your time.
Next up, we're going to have Hector Gerardo.
Hello, can you guys hear me?
And see you. Thank you.
All right, how you guys doing? Thank you for this meeting. My name is Hector Gerardo. I'm a land steward in Danbury, Connecticut. I have my farm is called Cimarron Farmstead. I have 3 acres. And at first I want to say free the plant, free the people, free the plant, free the people. Don't forget that marijuana is just a plant. It's not a coke. It's not heroin. It's actually a plant. Even though coke, you can say it's a plant too. But marijuana is just a plant. Just keep that in mind. And I want to also uplift that I'm farming in Pagaset land. A lot of us forget that we are farming on stolen land. All the work that we are doing is in stolen land. So I want to uplift the indigenous people that are being excluded, because there's a lot of there's an indigenous tribe that was excluded from the law that just passed to legalize marijuana. The Eastern Pequot Nation, they were excluded of making money from this industry. So I'm a farmer, grow hemp. So I first want to testify that I think it's wrong that hemp farmers have to give up their licenses to be able to convert to marijuana, to a marijuana business. First of all, the marijuana industry is the number 3 polluter in the United States. That industry is creating more pollution than any other industry out there. The marijuana industry, and hemp farmers know how to grow hemp regenerative and using it as a climate smart crop. If I want to change, I don't have the capital that most of my fellow farmers have to be able to convert and pay $3 million, pay all of this. Why we don't use the way New York State, which New York State is going through their own trouble and tribulations, but they allowed the hemp farmers to enter the cannabis, the marijuana industry first, and they didn't charge $3 million. They charged them $2,000. I don't have capital to be able to convert if I wanted to convert, and I don't want to lose my hemp license if I do want to convert. So I strongly suggest that we do not take away the hemp license because there's 25,000 uses for hemp, and we started at the end with CBD. So there's 24,999 other uses for hemp that we are not doing. So right now we started at the end. We started with the cannabinoids. That's cool and all, but I'm a hemp farmer and I want to grow for building materials. That's going to change the way we do construction in Connecticut. So I want to make sure that we don't pay this ridiculous amounts of money to be able to convert, that you don't take away our hemp license if we do convert, because hemp is not just CBD and everybody's just focused on CBD. CBD is now going down the pipeline because people are not buying CBD because people want to get high. So for me, CBD is more than hemp is more than CBD. So I want to make sure that we keep that and that we don't pay this ridiculous amounts of money that we have to pay. And I want to thank Kibra and Evelisa for the things that they said, because I do think that we got to start with the farmers like me. If hemp farmers like me that are part of the equity, that are part of impacted communities, and let me go first. I work with Black farmers that want to get into the hemp industry, the marijuana industry, but they don't have the money. They don't have the way. There's only 2 cultivation licenses in the whole state of Connecticut. And I know people that put 800 applications. They spend $20,000 just on applications.
Trying to keep a limit on time. So if you could summarize your testimony.
Yeah, I'm gonna summarize that. Please don't take away that license if we do convert. Please bring down the amount of money that we have to put in to convert, and don't allow big farmers coming into the space and take over. Let the people that look like me take advantage of this opportunity to convert their licenses to marijuana and keep their hemp license as well.
Thank you. Thank you very much. Questions from committee members? Senator Maroney.
Hector, thank you very much for your testimony. So I guess my question is, you would like to have the opportunity to grow the hemp and marijuana? Is that what you mean by saying that you don't want us to take away your license if you choose to convert?
Yes, because I already know what I'm doing with the hemp. I want to be able to create and innovate hemp materials. And if you take away my license to grow hemp for those innovations, just because I want to convert into marijuana, then you're doing that disservice to climate. You're doing that disservice to sustainability, because I want to grow for sustainability and create this amazing materials that you can do biofuels. You can create BMW just built a car. Paragonia, the clothing companies already using hemp. They have a hemp line. Levi's is going into hemp. So there's many different ways that people like me can make money in this new emerging industry that is hemp. And also we can make money in the marijuana industry. So don't take it away from us.
Great. Thank you very much.
Thank you.
Up next online, we have Ed Hawthorne.
Good afternoon, Senator Maroney, Representative DeAugustino, and the members of the General Law Committee. My name is Ed Hawthorne. I'm proud to represent over 200,000 working men and women as the president of the Connecticut AFL-CIO. It is on their behalf that I testify on HB 6699, an act concerning cannabis regulation. Now, we all know in 2021, Governor Lamont signed SB 1201, legalizing and regulating the adult use of recreational cannabis. It deliberately included, and I thank you for including, the equity standards and worker protections in the law. As you've heard from prior individuals, Emily, and also from UFCW National, which I just got the opportunity to hear as well, there has been problems with the implementation of the worker protection aspect, specifically the labor peace agreement. Now, UFCW is the expert in this, and they did a great job describing it here today. I want to describe the problem that when we pass a law, if it's not properly enforced, what is the reason for the law? And that's kind of where we're at this point, because in at least 2 cases, applicants signed agreements with unions that do not do business in the state of Connecticut. And another applicant signed an agreement with an organization that is known in other states not to represent the interests of workers. UFCW brought this to DCP and were essentially dismissed. They asked DCP about the appropriateness of the labor peace agreements executed to ensure the intent of creating equitable workplaces and workforce was being realized, that the intent of the law. Requests for clarification were unanswered. Instead, the licenses were approved, even though they signed labor peace agreements. Now, DCP says, we don't understand this, we don't do this. I hope we can find a way that either them or DOL can do this. And I understand the problems with DOL. I come from DOL. I was I worked completely federally funded. I was subject to the Hatch Act prior to obtaining this elected position. So I worked for DOL for over 10 years. So I get the fact that they're reluctant to do that. DOL is very good at kind of separating funds. I wonder if they can do that. I think the more conversation with DOL can be had there. But we need somebody to enforce the intent behind the law when we created this equitable market. And, I plead with this committee to provide either DCP or DOL with the resources necessary to ensure the vision of this new and emerging labor market that we, want it to be equitable is actually equitable because of the regulatory enforcement behind it. Thank you all for your time and attention. I'd be happy to answer any questions you may have.
Thank you. Questions? Senator Maroney.
Ed, thank you very much for your testimony. I'm just, again, relying a little bit on your experience working with a Department of Labor. I'm trying to think how we can get around if this is an issue. I guess And I'm just spitballing here, so
I think we all are, Senator.
yeah. I'm wondering if there would be a process whereby we would just, when they were submitting the labor peace agreement to DCP on behalf of their license, that they would have to have DOL certify that it was a bona fide labor organization. I don't know if that would be a way around them.
I think the
regulating.
problem with DOL is the funding source. So federal funding, I think, accounts for about 80% of the funding at DOL.
Sorry.
So for instance, my job was 100% federally funded. I did not have one red penny of state funding going to my job because I did unemployment insurance. So I think you would have to completely isolate any position that would be dedicated to this.
And I'm sorry, I appreciate that that's a concern they're raising. I don't buy it. I'm sorry. I mean,
that's okay.
Their federal funding's not jeopardized by touching this. If that was the case, DRS would be shut down because who collects the taxes on?
That's very true.
We ask all of our departments. We've created a new industry in the state of Connecticut. We're asking all of our departments in the administration to chip in and help out get this industry off the ground. DCP carries the bulk of all of that work from the regulators. All we're asking DOL to do is what's in their wheelhouse is to verify whether someone's a bona fide labor organization or not. That's not going to jeopardize their funding. If it jeopardized their funding, DRS couldn't touch this either. All right. And DCP's got federal funding as well. Frankly, it's BS. It bothers me that they said it as if that's not coming across enough right now. All right. So we're asking people to do their jobs and help out in an industry that this legislature created. The administration, the various aspects of the administration need to actually do what we're asking them to do. I'm sorry, but that one did not sit well with me at all. That DOL came in and said, no, we're going to lose our federal funding. Come on.
As far as the labor movement goes, as long as somebody enforces it, I think we'd be okay with it, whether it's DCP or DOL. But if a tree falls in the forest,
somebody needs to do their job. Absolutely.
Exactly.
We are on the same page as you. Somebody needs to do their job. We will make sure somebody does their job on the law that we passed last year.
Thank you, sir.
Thank you for your testimony.
Thanks. Have a great day.
You as well. All right, Mr. Clerk.
Thank you. Yeah, Mr. Chairman. Our next person is Kristen Souza online.
Hi, can you hear me?
Yes,
Hello.
please proceed.
All right, perfect. Hi. First of all, thank you for having me. Good afternoon, Chair, Vice Chair, and Co-Chairs, esteemed member of the committee. My name is Kristen Souza. I am the founder and owner of Sugarleaf Boutique, which is a hybrid boutique located in downtown Middletown. We sell CBD wellness products and gift items. I'm also an elected member of the City of Middletown Democratic Town Committee, and I am on the Middletown Youth Services Advisory Board, treasurer of Project Graduation, and also a justice of the peace. And I mention these things not because I am speaking on behalf of those entities, but because there's a lot of conversation around parents and safety of children in use of cannabis, which I wholeheartedly agree, and just wanted to present myself as someone who is a responsible cannabis user and also a parent and involved in the community. I'm mostly here testifying today in support of 6699 as well as 6700. I believe they dovetail together, and my testimony is going a little bit off script today, but as far as 6699 and 6700, the main priority, as mentioned by a few of the previous testimony, is the patients. And there are, I believe Anne Marie testified at one point, there were 50,000 patients, and that has dropped. There has been a lot of conversation from patients and the dispensary owners themselves sending out emails to registered medical patients talking about supply concerns. There's been a reduced amount of flour. There has been reduced production on gummies for patients. And so there have been multiple news articles ranging from CT News Junkie to Connecticut Public Radio, which I myself participated in, where patients are speaking out with real concerns about a lack of supply in the marketplace. So to that, 6,700 would help alleviate that concern. I heard a lot of testimony about how it would be detrimental to businesses, and I'm not immune to that. I'm a business owner myself. I have a Bachelor of Science in Business Management, but I think that we should be primarily focusing on the experience of the patients in the program. And that is almost 50,000 people that are now vocalizing that they cannot get the medicine that they are accustomed to getting. And so if we as a delegation and as a legislation can make steps to improve that for them, which one would be allowing hemp operators who are ready to go enter the market. I don't perceive that as jumping the line or anything like that. It is in service of medical patients, which in my opinion should be the utmost priority. And which dovetails very well into that. Section 8 of 6699 speaks of a cannabis ombudsman position, which would be an individual, eventually part of a commission, that would be responsible for acting as a mediator between the Department of Consumer Protection and patients who are clearly experiencing concerns with quality and supply issues. And in lieu of going to a department and getting shuffled around, they would have a direct contact who would then act as a liaison between the General Assembly, Department of Consumer Protection, and patients to help create some symbiotic nature between everyone involved and make sure that these issues are resolved quickly. I could tell from some of the commentary from y'all on the committee that some of these concerns about supply, this is probably the first you've heard of it. There's a lot on your desk at all times. And this position would help alleviate that because we would have a direct point of contact to go to speak on those things. So I'm good with brevity. So that is really all I had to say. I'm here in support of the ombudsman position. My only commentary on that, I do not think it should be a government appointee position. It should be more of a hiring process so that it is not just a political appointee, in my opinion. But I'm very much in support of that. And I do think that we should allow our hemp farmers into the market as an opportunity to create advantages for our medical patients. Thank you. And if you have any questions.
Thank you. Efficiently done. Questions from committee members? Thank you very much. Appreciate it.
Thank you. Great day.
Okay, next, I believe in person, Joseph Satulo. 34.
Thank you, esteemed committee members, my own representative, Chairman D'Agostino. I thank you guys for your time today. I'm here to oppose House Bill 5434. Upon going over the bill, I did find some alarming things that seem that we're going to start to go backwards. The reason I oppose it is there's language to repeal certain restrictions made on law enforcement in regards to motor vehicle stops and cannabis. Using the odor of cannabis as the sole basis to support an investigative stop or search of a person, or using the odor of in a motor vehicle is problematic for several reasons. The odor of cannabis can indicate the presence of it, but does not necessarily provide probable cause for a search or an arrest. In many cases, the odor of cannabis may be present without any actual cannabis being present, or it may be difficult to determine the exact source of the odor. Thus, relying solely on the odor of cannabis may lead to false positives and unwarranted searches or arrests. The odor of cannabis is not a reliable indicator of criminal activity. The use of cannabis is legal for medical and recreational purpose in the state of Connecticut. So the mere presence of the odor of cannabis does not necessarily indicate criminal activity. Relying on the odor of cannabis to support a stop or search may disproportionately target people who use cannabis for legal purposes. The use of the odor of cannabis as a pretext for a search or stop can violate Fourth Amendment rights. The Fourth Amendment protects against unreasonable searches and seizures. And using the odor of cannabis as a pretext for these stops and searches on someone may violate their constitutional rights. The Supreme Court has held that a police officer must have reasonable suspicion of criminal activity before making an investigative stop. And using the odor of cannabis as the sole basis for such suspicion may not meet that standard. Furthermore, relying on the odor of cannabis to support an investigative stop or search can lead to false positive and disproportionately target certain groups and potentially violate their Fourth Amendment rights. It is important for law enforcement to continue to use other indicators of criminal activity and follow the constitutional procedures to ensure their actions are justified and lawful. I just wanted to thank you guys for your time. And if there's any questions.
Well said. Questions? Senator Chicarello?
Thank you. And thank you for coming today. And just want to make sure, is he doing a good job as your representative?
Yeah, I do.
All right. Just wanted to make sure. So I agree with what you were saying that, if somebody's not seeing something and just having an odor isn't enough.
Right.
I'm going to agree with you on that. But if there's only one person in the vehicle and there's smoke coming out of the vehicle, or if someone is actively smoking, do you think that person should be pulled over? Because I know if I was going down the street with a beer.
Right. So if something's so blaringly obvious and the person is, smoking and there's smoke billowing from it and, the odor is present, coming from the car, then yeah, sure. But I mean, what I'm more concerned about is the fact that we've legalized cannabis in the state, and we wouldn't want police officers to use that knowing somebody always smells like cannabis, or if they're able to target. So to, start to repeal these restrictions or give them, could open up a Pandora's box of, recriminalizing marijuana. And I thought that first and foremost is what we're trying to do, is to decriminalize the plant, and decriminalize the people and community around it.
And we want to make sure that that is in fact the intention. And it's not to profile or do anything where if somebody's smoking that you're going to go after them for smoking. It's strictly just doing it while driving.
Right.
Just to make sure the streets are safe, just like we don't want people drinking and driving,
Right.
same thing with smoking and driving. So I think we're on an agreement that it's common sense that if the person is actively doing that, that it might want to be looked into a little further. And that's all. I just wanted to see your opinion on that. And I appreciate
I
your time.
definitely agree on that. It's just like I of course you want to definitely keep the roads safe, and you don't want people driving under the intoxication and so I do agree with that. It's more of the profiling that's come along with the years of the war on drugs and that being used as a tool for, maybe some predatory type arrests or, in that form.
Got it. Excellent. Thank you very much.
Thank you guys very much. And thank you.
Thank you. Questions? Judge, I want to note it for the record that the committee bill this year also does include a section on DCP studying the bizarre process and coming up with looking at ways to explore how we can.
So, and that's appreciated too, because the bizarre at its core is somewhere where, a person that may not have that opportunity to get into the regulated market learns more about the plant. We've surrounded the bazaars and the community around it with advocacy. We had to get together recently and we had 2 tables dedicated to the bills that are going on right now, and these are people that live and breathe the plant. So I know that, it's tough. And for us, it's tough because we are in the community and some of us, the capital that it takes to start these types of businesses is, in the millions. But I think with a robust caregiver program, like Duncan had said before and stuff, one of which like Maine, that kind of addresses us in the community, because we're not out here trying to, capitalize on, making money on the plant. We are really here to just keep spreading the message of the plant, and furthermore, trying to work on the decriminalization of the plant. So I do appreciate that you guys are looking into the bazaar, and how, and hopefully someday that something like, or the High Bazaar will be a regulated event, because I appreciate that, guys.
Thank you, Jeff.
Thank you, Representative. Thanks,
MJ.
Next, we have online John Davio.
Hi there, distinguished members of the General Law Committee. Thank you so much for allowing me the opportunity to speak today. My name is John Davio. I'm a resident of Lebanon, Connecticut, and I'm co-chair of Connecticut Smart Approaches to Marijuana. I've submitted quite a bit of written testimony, which I will just summarize briefly and not try to duplicate too much of what other people have said before me. I want to address quickly warning labels. What Representative Cheeseman was saying earlier about the yellow background, I think is really important. Actually, there's effective research on effective warning labels, and they all include the most effective warning labels include graphics, pictures, that kind of thing. And I recommend that we go much farther than 5434 actually says in terms of warning labels. In my written testimony, you can see what I've said about what Vermont does related to that. And if anybody has any doubts about the harm to fetuses, I would direct you to Dr. Bertha Mardris's research out of Harvard Medical School. On potency caps, I was really happy to see potency caps in RIRACA originally. They're way too high, and as somebody previous mentioned, researchers, when they're looking at the effectiveness or the problems related to marijuana on health, they have determined anything over 10% THC to be high potency and cause more problems. So I think your potency limits are too high. And I'm somebody who sees a lot of youth surveys across the state. And I'm telling you that youth, their primary, their preferred method of ingestion of THC is through vape products, vape pens, that kind of thing. And so what we're doing is we're allowing kids to get their hands on these 60, 90, 95% THC products. They get them. And this increases the potential for addiction and other health issues. And I think we really need to prioritize youth health instead of whether this is feasible from a business point of view. I think we're making a terrible decision if we don't prioritize youth health. I'd like to just briefly talk about penalties for marijuana compared to alcohol for our youth. For youth, a first-time offender is for possession of alcohol is referred to a diversionary program such as a juvenile review board. If the youth is not in compliance, right, they have a Class A misdemeanor. In addition to their driver's license could be suspended, or they could have to wait longer to get a driver's license if they don't have it already. At this point in time, none of those things exist for youth for possession of marijuana. And I refer you to the mistakes we made with some of the other changes in juvenile that allowed youth to steal cars without any kind of penalties. And then they go steal another car 2 days later. Drug dealers can easily hire youth to make their sales, and then nobody gets any penalties if they're caught. So I really think that's something that needs to be addressed. On 6699, I really think Section 2 and Section 16 should be deleted from this, and I'll focus on Section 16, which would allow individual home cultivators to sell at events organized to facilitate marijuana sales. I mean, why would the state condone events that are organized to allow the sales of individually grown products that are illegal for anyone under 21, especially from non-licensed people? I mean, do we allow, homebrewed or homegrown tobacco events if they're not licensed to, be a brewer or something like that? Of course not. And buyers at these events would have no idea of what they're getting, right? Potencies would be a guess at best. Were pesticides used? Is there mold on these products? Were other legal drugs mixed in? Nobody would have any clue at those kinds of events.
You've reached your 3 minutes. Would you please summarize?
The last thing I would just say is that events like that, you really can't prevent youth use. And I'm set. Take any questions if you have them.
Thank you. Let me see if we have any questions from the committee. No. Thank you very much. I do see we do have your testimony online, and thank you for providing some detailed examples in your testimony.
You're welcome.
All right, Mr. Clerk, next.
On my list, thank you, Mr. Chairman. On my list next, I have Reno Faris. I'm just seeing if I have a phone number in here, so seeing if he raises his hand or something, if that's him. Well, if it's not, we'll move to the next person.
Okay.
Yeah. Angelique Freites.
Good afternoon, everyone. And thank you for listening to my testimony. My name is Angel Fritz. I live in North Haven, and I am a medical doctor and clinical research professional. Between me, my husband, and a business partner, we won a social equity product packager license, and we would like to support the race bill number 06699, while also making more recommendations on the language used to further clarify the role of the product packager in the cannabis industry. Other product packagers and I and our team believe the spirit of the law intended for the product packager license to be a wholesaler. Outside of this ability, there are no privileges exclusive to this license. This license is currently considered an ancillary one, and this does not make sense neither for the state or the industry. The fees associated with its renewal do not make sense if the license is just to provide an ancillary service to growers and producers. For example, food and beverage manufacturers can create products and their non-social equity license fee is $5,000. In contracts, product packagers' non-social equity fee is $25,000. For social equity license, the fees are reduced in half. But there's still a big discrepancy between the two. Therefore, we humbly ask to remove the following text on page 19, section 9, paragraph B of the race bill. Quote, provided the product packager only transports cannabis package at its licensed establishment and end quote. By applying the suggested update, the state wins in the following aspects. It ensures that the tax revenue projected at year 5 can be met and exceeded. It ensures that producers and manufacturers can count on having the infrastructure needed to start and sustain their businesses in an environment, as you have heard today, of capital scarcity, avoiding supply chain issues. Small businesses can compete by avoiding sizable minimum orders quantities and the infrastructure required to support purchasing from dozens of vendors. Also, having access to physical consolidation measures makes everything downstream more efficient, saving everyone money. And last but not least, consolidating deliveries will be safer for retailers. We believe that implementing this update will ensure that the adult use industry is set up for success for the long term. I'm happy to answer any questions. Thank you.
Thank you for your testimony. And I wasn't able to type fast enough, but I do see you have submitted written testimony, so I was able to review that. Are there any questions?
I just wanted to thank you for coming out and testifying. I am going to look further at the written testimony. I know that you only have 3 minutes to talk, so to really understand the issue, but I'm sure you could get a hold of us, especially me. I think I'm your senator, so please feel free to reach out if you have any direct questions for me.
Yeah, absolutely. I mean, if I may, just to make a brief comment, the product packager license, the way that it's written, the law right now doesn't give a lot of room. It's not very explicit as to what we can do. And so our team, I don't even know how many investors we have met, over 70 at this point, and they're not willing to put money on a license that is not very well defined what it can and cannot do. We believe that the product packager license is going to be essential in the middle of the supply chain, but we need these changes in order to make an effective business plan. So the licenses, because obviously it's not just our business, there are other product packagers that are experiencing these issues as well. We have talked to them, they agree. The way that we read the law and interpret the law is very similar. So this is an issue that is impacting all 7 product packagers right now. And we believe that if these changes are not accepted, it's going to really cripple the industry overall, not only for the state, but at the end of the day, consumers and patients, because there's going to be supply chain issues for sure.
Thank you.
Thank you.
Thank you for your testimony. Okay, next, I believe online, Mr. Clerk. Okay, great.
If you're using this phone number, please let us know if you're registered to testify. All right. So then, is Hilda Rios around? they're not online. Nope. And then Norman Plude.
Good afternoon, General Law Committee. I've had testimony, it's online. I'm gonna kind of go away from that. What I've heard here today, as a hemp farmer, I own Sweet Tiva Farms in Seymour. It appears that a lot of the hemp farmers feel that the fee is too high to get into the recreational marijuana business in Connecticut. And then we have corporate on the other side who says they have enough supply there that, you know, they can handle the backfill. But then we have patients that say that they have problems getting medicine. I myself am also a medical cannabis patient. I'm, again, a hemp farmer. So I grow both marijuana and hemp on my farm. Marijuana is for me, that's grown inside. What we don't have in the marijuana program, the medical marijuana program, are caregivers that are allowed to cultivate for patients. And this would actually be a great opportunity for hemp farmers to get their toe into the water to supply possibly medical patients who live in apartment buildings, that have children in the house and they don't want to cultivate. The hemp community could fill that void. We have the facilities. I grow my own. I don't think I've heard of anybody in the medical program so far who is growing their own getting sick from that medicine. I don't think I've heard of anybody being sick from any of the CBD products that Connecticut farmers have produced over the years. It kind of seems like a compromise where hemp farmers were not going gangbusters into the market. We're helping out a section of an industry. It's been in this state for 10 years and we still don't have caregiver grow. It took 8 years to get cultivation rights for patients. And we were still leaving patients out that can't cultivate on their own. I'm willing to take questions.
Thank you very much. Representative Acker.
Thank you. You bring up a good subject. Is there any place that has a caregiver type of grow?
I believe California, Colorado, most of the states have caregiver grows. If patients themselves cannot cultivate their own medicine, that they have an avenue to follow, that they could get safe and effective medicine. And the other great thing about it is if we work with a patient and they have a particular cultivar that works for them, they'll never be out again. We could always grow it for them. Right? We're growing a set of plants for that patient. I have a couple of small greenhouses. My farm is very small. It's 1/8 of an acre. I think I have the smallest hemp farm in Connecticut. I did 8 plants last year. But that's not to say that's all I could do. Depending on how I divide my farm up, I could handle probably 16 to 20 patients on my little small farm, growing their 3 plants every, cycle. So they always have their available medicine.
And you have greenhouses?
I'm rebuilding a greenhouse now, and it's being rebuilt for light deprivation. So I could run multiple crops throughout the year. I could get 5 crops, 12 months a year. So I'm building for the future. Whether I use that to help medical patients or if I use it to help my hemp business, either way, it's going to help my business. I want to be able to help people that don't have that opportunity. To me, it doesn't matter whether I grow THC or CBD. It's all the same plant. I'm not going to give up my hemp license. My farm is very small. I spent the last 4 years building a clientele, and most of them are medical patients that come to my farm to get certain products. And yes, I do make certain products for certain people that come in. Some like sugar. I'll make them, CBD infused sugar. These are products that you're not going to get at a dispensary. I have elderly people that, they forget to take their pills, but they have a cup of tea in the morning. And in that tea, they have honey. So they have infused honey that goes with their tea. So these are things that, we could work with the patient beyond what's available at the dispensaries. Why? Because we're craft. We've been doing this for 4 years, and we're not supplying the same products that you would get at a dispensary. I supply tinctures and salves also, but we have that capability to supply what the patient needs when they
Thank
need it.
Yeah, thank you. Thank you for being here and hanging in. Thank you, Mr. Chair, or chairs.
Thank you, Representative Akron. Are there any further questions? No, thank you very much for your testimony.
Thank you.
Okay, next, I believe is Eileen Kopek online. Eileen, will you please proceed?
Yes, can you hear me?
Yes, we can hear you. Thank you.
Okay, I'm not sure. I guess we're not sharing audio, but that's okay. I want to greet the committee and thank you for taking my testimony. I did provide some written testimony, which I'm going to amend after listening to some of the testimony I've heard today. But at any rate, I'll do that later. I'm a medical patient only. I have no connections to the legal cannabis business, and I have no investments in any businesses. And I want to thank some of the commenters because it's been very helpful in educating me on some of these bills. First off, I totally oppose 5434. I support 6697 in easing caregiving restrictions, and I really like expanding the definition of what a caregiver is. Again, that's something that I learned from other commenters, so thank you very much for that. As far as House Bill 5432, proportional fees, I support that, and I support it because I know that it's Representative Rojas' bill. He's been a great advocate for us. I'm a medical patient because of him, so thank you very much, and I support that. As to 6700, I had an opinion. I have no opinion right now. It really sounds like you guys are going to have to go back to the drawing table on this one because arguments from all over the place are very persuasive. And again, I'm a medical patient. When I first read it, I thought, oh, great, hemp in the dispensaries. I would love that. And now I understand it's not quite that simple. So as far as 6699, I support a lot of it. There's some of it that I don't agree with. I don't know a lot about the workforce issues included in it, but it sounds like for the most part, that's pretty good. And I hope that you can work out this packaging thing as far as the labeling costs go, because that's a little crazy. As far as the ombudsman go, I guess it's a good idea. In general, I've been able to communicate with DCP fairly well. It's the producers that don't communicate with us patients. And again, I'm a patient, so I guess an ombudsman would be helpful, but again, I'd really like him to be talking to the producers more than DCP. I would also like him to focus on some of the environmental consequences of commercial cannabis production, not only here in Connecticut, but throughout the state. And I hope that we can improve the environmental stewardship of the cannabis industry. And I would like that to start with the 4 producers. I don't want to see any kind of environmental restrictions put on the new folks coming in. Let the folks who are doing it now start putting their products in glass or whatever. I mean, really simple things. Like I said, the environmental consequences of cannabis production, not only here in Connecticut, but all over the nation is terrible. And I would like that to improve. Anyone listening to this, there's a public hearing on the environmental committee on the 27th of this month. It's at 10 o'clock. They're taking public comments. One of the issues, there's a lot of issues, but one of the issues is actually adding to our Constitution a environmental, I guess, kind of Bill of Rights or whatever. That's
Thank you
something
very
that I would
much.
love to see.
Your 3 minutes is up. Would you be able to summarize, please?
Yeah, sure. And I don't really need to summarize much more because that's all I wanted to say. But if you'd like to ask me as a medical patient about any of the lack of medicine or anything like that, I'd be happy to answer your questions because there's only been one medical patient who's answered any of your questions. So I'm a medical patient. Why don't you ask me?
Thank you. Let me see if anyone else has on the committee has questions, and then I will take you up and ask you a question. So, okay. Have you seen a diminishment in the options to you since the recreational program has gone in effect?
Absolutely.
Great.
Absolutely.
Well, thank you so much for hanging in there to testify, and thank you for submitting your written testimony. And if you want to revise that, please email that to our clerk.
Okay, thank you very much.
Thank you. Okay, Mr. Clerk, I believe that's it for the people who have. Oh, okay, I'm sorry. Olivia Rinkus, if you can hear us, the floor is yours to testify.
Thank you, and thank you to the General Law Committee for the opportunity to testify. My name is Olivia Rinkus from the town of North Stonington. I'm testifying today in strong opposition to HB 5434, an act concerning the regulation of cannabis. We just legalized cannabis in the state of Connecticut, not simply to open the cannabis industry to corporate investors seeking new markets to profit off of. It's also legalized to address the impact of decades of misinformation and criminalization surrounding cannabis on especially Black and brown communities. I can understand legislators' intention to keep communities safe, but HB 5434 is full of unnecessary fear-mongering. Some problematic sections include Section 2 regarding the warning labels. Not all of the claims on these suggested warning labels have been conclusively proven, and I would urge legislators to prioritize new unbiased research into cannabis now that it's legal. Also, Section 4, suspending sales until the Drug Recognition Expert Program is operational. Cannabis is legal now, and we no longer need to prioritize the criminalization of it. Police officers were more than capable of recognizing it before legalization happened. They don't need more funding and more training to continue criminalizing it, especially now that possession is not illegal. Also, Section 7 regarding police searches of vehicles due to cannabis-related stops. Possession is now legal and allowing the police to search vehicles and persons based on the belief that they're in possession or because they perceive the odor of it is simply fear-mongering and further criminalization. Finally, Section 12, appointing the Department of Consumer Protection to review and approve cannabis products and to designate cannabis a Class 2 scheduled drug. Considering the inability of the Department of Consumer Protection to protect consumers from high levels of mold in products currently available in corporate-owned medical facilities around the state, it does not seem like consumer health and safety is a priority for DCP. And also designating cannabis a controlled substance is a step backwards. I would also like to echo some of the concerns voiced in other testimonies regarding HB 6700, an act concerning hemp licensees in the adult use cannabis market. While I wouldn't suggest making a competition between the hemp and cannabis market, I would like to echo the concerns that others have expressed in allowing hemp license holders to seek a cultivator license. Cannabis was legalized to address the effects of criminalization on disproportionately impacted areas. Therefore, applicants who are disproportionately impacted should be given all priority in this industry now that it's legal. And I would also like to add my voice to those urging legislators that any further discussion of the cannabis industry needs to include releasing individuals with cannabis charges from prison and erasing cannabis charges from criminal records. Thank you very much for the opportunity to testify.
Thank you very much for your testimony. Are there any questions? Okay, hearing none. Thank you for hanging in there until the end. So with that, I believe that is everyone who has signed up to testify. Is there anyone else in the room who would like to testify? Okay. Since you haven't signed up, will you please state your name for the record and then just before you leave, make sure the clerk has your email address.
Awesome. I do have written testimony that has been entered, I believe. My name is Joshua Frazier. I'm here as a medical cannabis patient and representing Maine Quality Roots, a cannabis company aimed at education. The company was started by my sister, who worked for Prime Wellness for 7 years as the head pharmacist. And our whole aim is out there in the community, educating medicinal patients on how to best help themselves, right? I have the ability to grow for myself as a patient, and with the help of many people you've seen in this room, I actually was afforded the opportunity of the equipment and the things I needed to get into that space, not having those. So this is a great community. I don't want to spend time reflecting on the problems. We all know what the problems are, but today a very real thing has come into this room and it sparked energy into me in a way I haven't felt about this. And it's a caregiver, right? Redefining what a caregiver in the state of Connecticut is the solution to all of our issues. We can take the market we already have in place that we're using for the medical, and we can divert that over to our recreational, right? Unfortunately, we have product quality, product quantity issues in that market, a market that's better suited for recreational people discovering what their needs are, right? And then when we introduce this caregiver, I don't know what it's going to look like, how it would look like, but I do know it would solve these problems. You've heard many people testify to this. In Seattle, Washington, we were allowed 99 plants as a caregiver. We had that amount of material we could grow and take care of that amount of patients that we could handle with that. And that was up to the patient to make that decision. So now you're registered with your state as a patient, you qualify for that. Now you're the consumer, you make your decision on your quality of product. I think we have to come up with something because this isn't working. We're all beating our heads against the walls, our policymakers and our constituents. This is the solution. And with that, I thank you for giving me some time to speak.
Thank you for speaking. Are there any questions? Okay, hearing none. Thank you. Okay, is there anyone else who would like to testify? Hearing none, we are adjourned. Our next public hearing, Mr. Clerk, is on February 28th. Can you announce the time in the room, please?
It will be at 2:30 p.m. in room 1C. Thank you, Mr. Chair.
Great. Thank you, Mr. Clerk, and thank you, everyone. Thanks to Pharmacy and Tribes.